Matters of regroup, my lord.
Chair. Which year?
That's 2024. I've failed it, my lord. Revenue entry.
You know, but I'm trying to finish old matters. If I take up 2024, I'll never be able to take up 2016, 17.
Matter may not require 1 minute of.
Today, ಎಲ್ಲ ಕೊಡಿ ಡೇಟ್ ಕೊಡ್ತಾರೆ ಅವ್ರು.
End of matter, my lord.
230, my lord.
Illegal inter.
Revenue inspector issued the shoka eviction notice, my lord. Today is
2:30.
My lord. Illegal interference are respondent, my lord. No document, right. I am for petitioner in this case, my lord. Respondent side illegal interference in this case, my lord. Respondent
ನಿಧಾನ ಕೇಳಿದ್ರೆ ಅವಸರ ಇಲ್ಲ. ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
stay back ಆಗಿದೆ ಸ್ವಾಮಿ. Fresh matter, my lord.
ಫ್ರೆಶ್ ಮಾಡಿ ಕೊಡಿ.
Day after tomorrow, my lord. Day after tomorrow. Illegal interference in my property, my lord. No document, right? No title.
ಫ್ರೆಶ್ ಮಾಡಿ ಆಯ್ತಲ್ಲ.
Yes, my lord.
Malad,
Day after
need to
tomorrow.
withdraw the matter, Malad. Need to withdraw the matter. It may be posted tomorrow, Malad. So once and
ಕೊಡಿ
Lord,
ಡೇಟ್
B group
ಕೊಡ್ತಾರಲ್ಲ.
matter, my lord, short point for consideration. Notice is not given, my lord.
My lord, this urgency, this matter, my lord, the petition on the basis of earlier order, my lord, is trying to interfere in the possession and changing of revenue.
ಏನಕ್ಕೆ?
B group, my lord. So now, ತುಂಬಾ ಮೆಮೋಸ್ ಹಾಕಿದೀನಿ, ಕಡೆಯಿಂದ ಪೋಸ್ಟ್ ಆಗ್ತಿಲ್ಲ.
ನೋಡಿ
ನಾಳೆ ಏನು? Ready go.
For adjournments, page number 18, serial number 88 to 93, page number 19,
serial number 64 you know.
94 to 95.
Senior out of station ಇದ್ದಾರೆ.
Page number 20, serial number 96 to 98, page number 21, serial number 99 to 108, page number 22, serial number 109. For preliminary hearing, serial number 1,
serial number 64 you know. Senior out of station ಇದ್ದಾರೆ. ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ನಾಳೆಲ್ಲ ನಡೆದು 9ನೇ ತಾರೀಕು ಕೊಟ್ಬಿಡಿ.
64 ಮೂವ್ ಮಾಡಂಗಿಲ್ಲ, ದಯವಿಟ್ಟು ಕಾಯಿರಿ. ಹಿಯರಿಂಗ್ ಆನ್ ಐಎ, ಯು ಕಾಂಟ್ ಮೂವ್. ಪ್ಲೀಸ್ ವೇಟ್.
serial number 1, Shri Venkatesh Murthy.
My lord, next week, my lord, first matter, I have asked AC, my lord, she is getting now some records, my lord. Why corrigendum has been passed by the AC and just I need to find out.
Serial number 2,
Kindly pass over, my lord. Kindly pass over, my lord. Please. Lord, I appear for the respondent in the connected matter. That is for process kella ide sunu. My lord, I will definitely explain, my lord. Kindly pass over, my lord.
Pass over.
serial number 3, Shri Suresh Roy, Vadivar. Serial number 3, serial number 4, Shri Narendra Gowda.
In this case, my lord, petitioner is an ex-serviceman. He made an application for grant of land.
Take notice.
Till today, that has not been considered. And there was earlier, there was a direction as per annexure.
Objections if any 2 weeks, the list.
Serial number 5, Shajit PD.
For the petitioner, my lord. My lords instructed the Tahsildar Chikmagalur to file additional affidavit. Once again, the attempt is made to file half-baked affidavit, my lords.
Additional affidavit, my lord, has filed. Lord, the Chikmagalur
ಸೆಕೆಂಡ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀರಾ?
also.
Relevant para is para 3 and 4, my lord.
1984 itself, my lord, the same notified.
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ?
Please.
ಬೇರೆಯವ್ರಿಗೆ ಇದೇ ಜಾಗ
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
Please, my lords, I have produced the RTCs in page 41 of the petition. Page 41. Page 41 and 42 are the.
ಏನ್ ರೆಡಿ ಅವ್ರೆ? ಸೆಕೆಂಡ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು ತಾನೆ.
Second affidavit in respect of Milad, when the notified Milad is Chikmagalur.
ಇಲ್ಲ ಅಕ್ಕಪಕ್ಕ ಸರ್ವೆ ನಂಬರ್ 5 ಕಿಲೋಮೀಟರ್ ಒಳಗೆ ಬರುತ್ತೆ ಇದು ಮಾತ್ರ ಆಚೆ ಆಗುತ್ತೆ.
Alla, the
And the
area
distance
is
is-
Milad, within 5 kilometers Milad.
Then how did you grant the land for the others? Because he says it's 4.635 kilometers. Aerial distance. ಅವ್ರಿಗೆಲ್ಲ ಹೆಂಗ್ ಕೊಟ್ರು?
Alla, Tidre Milad, negative equality.
Yeah, why are they doing this? Why can't they be clear?
Even then Milad, they negative.
So ಅವ್ರಿಗೆ ಮಾಡಿದ ಮರ್ತಬಿಡಿ ಇವ್ರು ಕೊಡಿ ಅಂತ.
That is also Milad, has to be cancelled.
ಇಲ್ಲ has to be cancelled ಬೇರೆ.
If it is Milad, even grants has been made. Milad, negative equality Milad cannot be claimed Milad.
No, suppose in one survey number, you grant it for 10 people. For one person, you want to say it is less than 5.
That is not permissible.
The Tahsildar to state on oath as to whether any adjoining survey number, the orders of grant have been made. Since it is a specific contention of the petitioner that similarly based grantees whose lands are abutting his are also granted land. So he placed the lands on survey number 32 na?
32. In fact,
And-
it's a larger extent of land, my lord, survey number 32. Adralli they have bisected and they have granted it to
So
many people.
next an artist split into survey number 32, which he states is a part of the survey number to which the petitioner has made an application. The Tahsildar to fill in the affidavit by
21st. Seal number 6, Shri M.R. Remand.
Like, no, notice, but serial number 5, notice has been not ordered.
DJ to accept notice for respondents. Seal number 5. The list 6.
Seal number 7, Siddhappa B.M.
Post officer receive notice to her.
Seal number 8, Shri Sanjeev B.N. Sanjeev B.N.
The list.
Seal number 9, Shri Anand Gurrappam Balloli.
Lord, the fifth respondent, private party, Gauramma, she has challenged the mutation along with my extent 1 acres before the respondent number 3, Assistant Commissioner. And Assistant Commissioner has ordered and including my number, extent of 26 kuntas, only the which has gone to the nice road as only the restoration of Kata. I have also purchased by virtue of sale deed. I produce the page number 35, Lordship, by Annexure C. It's my sale deed by extent of 1 acre, and my mutation has been cancelled. And in revision petition also, there was an interim order was granted, and subsequently, the Lordship, along with her contention is originally her father, the respondent number 5 here in Gauramma, her father has purchased 1972 10 acres and some extent of land, including my portion 1 acre. And the mutation was not mutated, and accordingly, Assistant Commissioner has cancelled my registered document. But he don't have any authority because my registered sale deed, even according to their contention, Your Lordship, they have got from the original landowner Naranappa and Venkatachalaya. I have also purchased from the same landowner. Subsequent, I have also purchased. I have 1 acre is my registered sale deed is there, my lord, as per page number 35, Annexure C. And accordingly, based on that, mutation was came to be executed. And with now the AC and Deputy Commissioner, and they have cancelled my mutation and the restored the name of the fifth
But
respondent.
Malaysia purchased 5 acres.
Actually, as per their contention, Malaya purchased 5 acres 1972. And Your Lordship, including my extent is 1 acre. And along with other extent,
Total extent was 10 acres.
10 acres, my lord. 10 acres.
5 acres Malaysia purchased.
Yes, from the Naranappa and Venkatachalaya, original landowners. So I have also purchased from the original landowners, from the Naranappa and Venkatachalaya. they have sold to the one person and one Kamalabai, and Kamalabai in turn sold to me as per page number 35 annexure C by virtue of registered sale deed in 2004 itself. And thereafter 54 of 2001 mutation came to be executed in my name. And even the, as per the blindly 1970 according.
Who's Rudregoda?
Rudregoda, they have taken 5 acres and they are saying, but he's not at all.
Who's Rudregoda? When did he purchase?
Blindly they said that.
When did he purchase?
You know, Rudregoda is no concern at all for me.
Come to page, there are 3 page numbers here, page 24, last paragraph. The paragraph starts with thus, the predecessor was entitled.
Yes.
Go the other.
Thus, the predecessor in the title Naranappa and Venkatachala in respect of land survey number 222 of survey number 10 acre at BM Kavalu, though they have sold extent of 5 acres in favor of the Malaysia as early in the year 1972 itself under the sale deed of so and so document number, and have lost their right and their title to the said extent 5 acres of land. Further, they have also sold another 5 acres of land in favor of Rudregowda, son of Tippa Reddy. Wide number so and so. Thus, Naranappa and Venkatachalaya had no manner of title for the scheduled property. Entire extent of 10 acres.
If Narayanappa, Venkatachalaya, son of Narayanappa,
Yes.
had
Please.
sold the entire 10 acres,
Yes.
5 acres to Malaysia and 5 acres to Rudregoda,
Yes, my lord.
how could you have purchased?
No, I'll just come to the point. See, these owners, they have sold in favor of, as per the document number annexure E, my lord. Annexure E, my lord. Page number 44. Page number 44, may kindly will see. This is the deed of my vendor. I'll just. Page number 44 and
Until you clear this doubt, I can't go forward.
please.
There are 2 sale deeds.
Page number 44 annexure C, my vendor has purchased from the Venkatachalaya only. That's a sale deed. Whatever they have sold it,
What is your
it's my vendors he has sold it.
What is your vendor's name?
Kamalabai, my vendor. She purchased 2 acres.
From whom?
From, that's what I am coming, my lord. My lord, Krayapatra Venkatachalaya Moolaka Krayavagirutte. Page number 45, annexure C,
ಯಾವ ಕೊಂಡ್ಕೊಂಡ್ರು?
that is the sale deed in 1992 itself.
So if suppose,
But 1 minute, I'll just come to point.
like, if you don't understand
Please.
my question, you will
Please.
never be able to answer.
Please.
72 5 acres. Rudregoda,
Please, 72 acres for Malaysia.
Rudregoda so purchased another 5 acres.
Please.
When was that you don't know?
No, please.
Whether your vendor's sale deed was prior to Rudregoda sale deed or after Rudregoda sale deed. If you can answer that question, then
Prior to the Rudregoda only, I am coming to the point.
when did Rudregoda purchase ಅದು ಗೊತ್ತಿಲ್ವಲ್ಲ ನಿಮ್ಗೆ?
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೆ. ಈಗ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, what is happened, my lord? Rudregoda 5 acres is different, and 5 acres, whatever he sold it.
So you want the Tahsildar to give a finding?
1989, one more sale, prior to this, my lord. Idರಲ್ಲಿ, prior to this, Venkatachalaya is sold in 1989. And in respect of 2 acres of land, that sale deed I have produced.
ಒಂದು ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಡಿ ನೀವು ಯಾವ್ಯಾವ ಮಾರಾಟ ಮಾಡೋದು ಅಂತ. I don't think you should not give the Tahsildar this scope to determine which sale deed will prevail. He simply has to go by the chronology.
Please, I'll just.
5 acres 72, you can't escape.
Please, I'll give the gist of the sale deed tomorrow, day after tomorrow.
The list. All these sale deeds in an order.
Please.
That is all.
I'll give that. Day after tomorrow.
15. Seal number 10, Shri Venugopal MS.
In this matter, I pray for 10 days accommodation, my lord. This is with regard to the formation of road, my lord. Survey ಮಾಡಿ report secure ಮಾಡ್ಲಿಕ್ಕೆ another 10 days time may be granted. Sir.
15. Seal number 11.
Well, survey number 46 is a government land, my lord. These petitioners.
What is your prayer?
53, form number 53 we have filed, my lord. Now an extent of 1 acre is, annexure D is the grant order, my lord, for Asaya Yojana, my lord. And we have filed farm number 53, my lord, annexure B, your lordship may kindly see.
When was it filed?
It was filed in the year 91, my lord. A list is also prepared for consideration to the, before the committee as per annexure B, my lord. And there are small holders, 19 guntas, 20 guntas, that's all. It is not considered.
India Devara?
I will take notice.
AG accepts notice for the sport office. Relist on.
Still number 12.
Swami, my lord, one of the respondent, local panchayat, my lord, I have not implemented, I may be permitted to,
Yaro?
local Koppa panchayat PDO, my lord.
Lord Constitution submits that Koppa Gram Panchayat
Oh.
would be a necessary party. Hence, Koppa Gram Panchayat is implemented as respond number 5. Constituted to be amended.
Notice, my
Mr.
lord.
Panchayat. There is a Gram Panchayat, Koppa.
Still number 12. Shri Praveen S.
For the petitioner in this case, my lordship, partition suit pending between the petitioner herein and respondents 3 to 16, my lordship.
What are you challenging?
My lordship,
What are you
we are
challenging?
calling in the question of the AC, my lordship. The impugned order. The impugned order is in ink page 18, my lordship.
18.
18, my lordship. We challenge the mutation entry because the mutation entry was made subsequent to order of the civil court staying all encumbrances.
An appeal was dismissed on prosecution.
My lordship, that is right, my lordship. Only on one date. Only on one date we were not there, and there is a note, a sharat that says, appellant absent, no interference, not interested. Dismiss the appeal.
Which year is the appeal?
My lordship, the year appeal is of the year 2024, my lordship. My lordship,
Who appeared for the respondents there?
my lordship, it was in the notice stage and nobody had appeared, my lordship.
Nobody had appeared.
That is right, my lordship. There was an order of the civil court in ink page 48, my lordship.
Yaar notice ho gaya ilwa?
Notice, copy has not been served. Of 31.
You are for the appellant, huh?
We are for the appellant, my lordship.
You are challenging only annexure A.
My lordship, that is right, my lordship. As well as the mutation entries, my lordship.
The petition is
Annexure
filed-
L, my lordship, K and L.
Petition is filed challenging an order passed by the Assistant Commissioner by which he has dismissed the appeal filed with the petitioner under section 136 of clause 2 for non-prosecution. Learned counsel for the petitioner points out that
Also have an interim prayer, my lordship.
notice was ordered, isn't it?
My lordship,
Notice was ordered to respond.
was ordered, my lordship.
Then you said no, notice was not ordered.
My lordship, notice was ordered, my lordship, but notice is receive agide illa namgote. Notice order agide. First date ali ide swami.
Then I'll have to issue notice to everybody.
My lordship, may be done, my lordship. We have an interim prayer also, my lordship.
Did you have an interim prayer there?
We had an interim prayer there also, my
Where?
lordship. The interim prayer portion is not attached, my lordship, here.
Because
only
you
at-
produce the order sheet only says issue notice.
That is right, my lordship, on 25/6/2024.
Then AG accepts notice for respondents 1 and 2, issue notice to the respondents.
The respondent 17 is a builder, my lordship. There are subsequent mutations happening and subsequent sales, my lordship.
What can I do until I take out notice on, you do not have a stay there.
We don't, my
What
lordship.
was passed almost a year ago.
That is right, my lordship.
What is it that I can do
We
now?
only have a stay before the civil court which is being violated, my lordship.
I'll have to send you to the deputy commissioner. You'll have to go actually file a revision.
Emergent notice order, Madi Swami. We'll take necessary steps. Oblige, my lordship.
Still number 13. Srimati Gaurav Nisa.
But I have challenged order passed by the respondent number 3.
What is the next name, madam?
Annexure,
Impugned order is annexure M, my lords.
impugned order at annexure M, my lords.
136(3), na?
Please, my lords. 136, my lords. Annexure M.
Lords, they never appeared before the authorities, not since 2017.
But that is recorded, my lords, in the order notes. Kindly see page number 79, lords.
I'll send it back then.
Yes, my lord, it can be sent.
My lord, here what has happened is, my lord, yeah, my friend, he's just making the allegation that never appeared. My counsel who
I'm
was
not making
appearing
results,
before
I'm
the
on record,
authorities,
my
my
lord.
lord, he expired. We did not have the knowledge of.
Send it back.
Yes,
My
my
lord.
lords. Unnecessary keeping this matter, not civil, it will go.
Time
my
may
lords.
be fixed, my lords.
Can be fixed, my lords.
The petition is filed challenging the order passed by the deputy commissioner that is clause 3 of the land revenue. It is pointed out that the deputy commissioner has passed the order after making an observation that the petitioner had not filed any objections, nor had she already permitted, nor had he filed any written arguments. Though, and he was always constantly absent. In other words, it is clear from the order that the deputy commissioner has passed the impugned order without actually hearing the petitioner. The counsel also points out, your counsel had died, huh?
Please, my lords.
That the petitioner's counsel was no more and hence there was no representation. So in that way, the matter, in my view, it would be appropriate to set aside the order of the deputy commissioner and remind the matter to the deputy commissioner with the direction of the commissioner to consider the matter afresh after hearing the petitioner. So since both the parties are represented before this court, they are directed to be present before the deputy commissioner on so and so to take further instructions. AG to talk this for response 1 to 4.
My lord, may make one submission, my lords. Here, they are just trying to make, alienate the
I have set
property.
aside the order. Let's go back, go and make an application there.
Please, my lord.
Seal number 14, Shri Prasanna TP.
So in this matter, my lord, they have given representation to Chintamani.
Chintamani, oversight it is, Chintamani it is mentioned, Gauribidnur Taluk, I have made the representation. Respondent number 3 mentioned as the Chintamani, my lord.
They are to consider the representation.
Consider representation.
Of
Regularization.
Sagawali chit, my lord. ಅದರಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಗೌರಿಬಿದನೂರ್ನ ಪಾರ್ಟಿ ಮಾಡಬೇಕಿತ್ತು, ಚಿಂತಾಮಣಿ ತಹಸೀಲ್ದಾರ್
Chintamani ತಾಗಿದೆ.
ಡಿಫರೆಂಟ್ ತಾಲೂಕ್ಸ್.
ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ?
ಅವ್ರು ಅಮೆಂಡ್ ಮಾಡಬೇಕು.
I will
ಫಸ್ಟ್ ಟೈಮ್ ಬೇರೆ
amend.
ತಹಸೀಲ್ದಾರ್
Gauribidnur ತಾಗಬೇಕಿತ್ತು, Chintamani ತಾಗಿದೆ.
is permitted to amend the cost date and describe the third respondent as a Tahsildar.
Gauribidnur
Taluk instead of Gauribidnur.
I will take notice for all respondents. For issuance of Sagawali.
Cost date amend ಮಾಡಿ.
Please, my lord.
Seal number 15, Shri Manikanta HB.
This I need some time, my lord.
Released.
16, Shri Natwaraj Ballan.
Respondent number 4, my lord, initiates proceedings challenging the order of mutation, my lord, of the year 1984-85 on the ground that, my lord, 15 cents of land in 194/1B. Instead of that, they have granted a RTC for 194/B.
You got the mutation done.
I have not, I mean, my mutation was under form number 7 after form 10 was issued in favor of the petitioner. Respondent number 4, who is the legal heir of the landlord, he files a petition in the year 2017 and seeks for change of mutation. That is allowed by the respondent number 2.
On what ground?
On the ground that, my lord, that 15 cents of land was given in a different survey number. That is why it has to be mutated.
Form number 10.
Form number 10 is also in my favor, my lord, but that could not be produced, my lord, because my clients don't have a copy of it.
You are granted survey number 194/1BP2.
Yes, my lord. Total extent of land granted is 2.59 cents.
Where is the order of the land tribunal?
Order of the land tribunal, page 26, your lordship may kindly see. Serial number 2, Koragu Gowda, the husband of the petitioner. Extent is the same, my lord, 4 acres, 13 guntas, but.
No, 194/1BP2, 1BP4.
Yes, my lord.
You are granted 62.
And 1 acre, 92 guntas, cents. It comes to 2 acres, 54 cents.
Now, what is the order that is passed?
Now they have changed it, my lord, saying that it has to be restored to 2 acres 54 cents instead of 2 acres 69 cents. After a lapse of 38 years. My lord, there is a civil suit pending, my lord. I am in possession of the.
Your entitlement can't be for more than 2 acres.
No, my entitlement is only to 4 acres, 13 guntas only. That is what I have filed the application for.
No. The land tribunal says 194 bar 1 BP2 for 62 cents.
Yes.
194 1 BP4 for 1 acre 92
92 gets cents.
Apart from this, you can't get more.
No, my lord, I have not got more. It is 4 acres, 13 guntas only.
It was shown as 2 acres 66 times 66 cents.
66
Whereas
cents.
you are entitled only for 2 acre 54 cents.
54 cents. Yes, my lord.
Then the correction is correct, isn't it?
No, my lord. My extent would change because I don't have the benefit of another 15 cents in any different survey number. The total extent 4 acres 13.
Then you will have to challenge the order of the land tribunal.
I did not challenge, my lord. The landlords.
Yeah, they're okay with whatever is granted, but they're not okay with you asking for 15 cents more.
No, I have not sought for, my lord. Kindly may I clarify. My application, the original applicant's application was for 4 acres 13 guntas only. That 4 acres 13 guntas only has been granted. Instead of granting it in a survey number for which I had applied for is according to them, the land was granted in while mutation was entered, it was in a different survey number where 15 cents has been granted extra. But the total extent is only 4 acres 13 guntas only. There is a civil suit.
For a minute, but I'll forget about the total extent.
Please, my lord.
The extents were specified with reference to each survey number.
Yes, my lord.
Instead of these two survey numbers, 194 bar 1 P2 and P4, you can't get more than 2 acre 54 cents.
Yes, my lord.
If it's 2 acre 66 cents.
No, that is the dispute what is pending, my lord, because I am in possession of the entire extent of land, 4 acres 13 guntas. Now they seek for a change of mutation, my lord, based on saying that, my lord, that land was not sought for by me, and that is what is the dispute, my lord. A civil suit is pending, which is in I am in possession of the entire 4 acres 13 guntas. Now they, after a lapse of 38 years, my lord, the legal heir of the landlord files an application, and that is allowed.
Your entitlement is only as per the land tribunal's
Oh,
order.
yes, my lord.
You cannot get more than
No,
what.
if this mutation is given effect to, my lord, I will lose 15 cents.
You have not got 15 cents in these two survey numbers. You may have got 15 cents somewhere else.
No, but that I cannot go and now challenge, my lord, because for the reason that, my lord, my total extent claim is only 4 acres 13 guntas, my lord.
So suppose some survey number is
No,
granted.
that itself is the dispute, my lord, whether this is the survey number in which the land mutation was entered.
The Tahsildar can't go into it at all. You only have to reflect the order of the land tribunal.
Yes,
If
my
there's
lord.
something wrong with the order of the land tribunal, your remedy is elsewhere.
No, I have not disputed the land tribunal's grant at all, my lord.
Then that means your entitlement for 124 P2 and P4 can only be for 2 acre 54 cents. That's all that has been
No,
done.
my lord, but if that is reduced at this point of time, my lord, I am in possession of the land. If it is no, kindly appreciate this. If it is reduced, I will be losing 15 cents of land, my lord. Which
It was not yours. It was not yours to lose. You had only been granted 2 acre 54 cents. By some circumstances, you were
No, it is no. My other, my lord, may kindly appreciate the land for which I have sought for is granted to me. So 4 acres 13 guntas has to be in my possession, my lord. I am in possession of that land. I am enjoying it. After 38 long years, my lord, he comes and says,
they are not questioning the order of the land tribunal at all.
the mutation, they are challenging it, my lord, after 38
The
years.
mutation has got to be in accordance with the order of the land tribunal.
My lord, they could not have slept over for 38 years, my lord, and thereafterwards.
You can't get something more than what.
No, I am not getting anything more, my lord. I will be losing 15 cents of land.
In these two numbers, you are getting 15 cents more. That's it.
No, that is true, my lord. But what happens is I will be losing as per the land tribunals, if the mutation is affected to my land for 15 cents, my claim for 15 cents is lost, my lord, forever. They have not challenged the order.
Because you accepted the order of the land tribunal as 1 acre 54 cents and 62 cents and 1 acre 92 cents. Therefore, you have given up your rate over the other 15 cents.
No, that is because for the reason that, my lord, my possession is 4 acres 13 guntas is intact, my lord. That is not in question at all. Nobody has questioned it.
Anything else?
That's it, my lord. But since the civil suit is also pending, my lord, I have produced a copy of the injunction.
This is always subject to the result of the suit, isn't it?
True, my lord. I am in possession of that land. So I have sought for injunction was granted in my favor. I am in possession of the land, my lord. That is the dispute. Until that is decided, my lord, on merits, let the mutation not be affected to, my lord, because
when an order of the land tribunal was passed in favor of the petitioner, conferring occupancy rates in respect of the following lands, page 26. The dispute relates to serial number 194-1B-B2 measuring 62 cents and serial number 194-1B-B4 measuring 1 acre 92 cents. It was the case of the contesting respondents that though the petitioner was granted in all 2 acres 54 cents in serial number 194-1B-P2 and 194-1B-P4, the revenue authorities had mutated his name in respect of 2 acres 69 cents, that is 15 cents extra, and therefore the order of mutation was required to be rectified. The Assistant Commissioner accepted this plea and allowed the appeal of the contesting respondent. This order has been confirmed in revision. Being agreed by this, the petitioner is before this court. Not counsel, the petitioner points out that the petitioner had claimed 4 acres 13 cents and the land tribunal granted 4 acres 13 cents. He submits that so long as the total extent of land that the petitioner claimed was granted to him, the mutation effected in accordance with the order of the land tribunal cannot be found fault with. He also submits that the order of mutation was made about 35 years ago, and that order is sought to be disturbed by the contesting respondent. It is to be stated here that the land tribunal did grant a total extent of 4 acre 13 cents, but this extent of 4 acre 13 cents were spread over various survey numbers, and specifically in respect to 194-1B-P2 and 194-1B-P4, the petitioner had only been granted 62 cents and 1 acre 92 cents, that is in all 2 acres 54 cents. Consequently, the order of mutation in respect of these two survey numbers could not be in excess of 2 acre 54 cents. The Assistant Commissioner should therefore right in reducing the extent to reflect the actual extent of land granted to the petitioner by the order of the land tribunal. I find no infirmity in the order passed by the land tribunal by the authorities, and petition is therefore dismissed. Land Council also, however, submits that there is a civil suit pending between the parties, and therefore the revenue entries should await the result of the said suit. In my view, in the event the petitioner succeeds in the trial court, in the civil court, it is obvious that the revenue entries would have to abide with the result of the suit. Until then, the entries has to be registered in accordance with the land tribunal shall be done.
Liberty me to revive my application in respect of other 15 cents, my lord, should be.
I will not. What do you want?
Lord, at least I should get that 15 cents, my lord. My application.
So make an application to the land tribunal.
No, that liberty, at least they have.
Grant you that liberty now. I am permitting you to seek for amendment of the order 40 years afterwards.
Lord,
they'll come screaming.
That
because of
38 years liberty was given to him to revive, my lord.
No, the order of mutation is a ministerial act after the order of the land tribunal. The
Lord,
authorities cannot meddle with the order of the land tribunal.
My lord, but I had the benefit of that land, my lord, all these 38 years.
Then suppose I were to give a finding that you are not in possession, then you aren't.
My lord, that itself is a dispute before the civil court, my lord. That is pending before the civil court.
I am confining this out only to the revenue entries, nothing more. Whatever you want to do, you do.
Lord, I would be left with less of 15 cents of land, my lord, because of this order.
I appear for petition. Lordship, petitioner sought for an mandamus seeking direction to the Tashildar to survey and fix the boundaries. In fact, your Lordship could see at Annexure B on an earlier writ petition, your Lordship, the order was passed to consider and
within 2 weeks, my lord, I will say. ಮಾಡಿಲ್ಲ ಅದೇ ಅರ್ಜಿ ಕೊಟ್ಟ ಮೇಲೆ ಮಾಡಿದಾರೆ ನಿನ್ನೆ ಎಲ್ಲ ಮೊನ್ನೆ ಮಾಡಿದಾರಂತೆ ರಿಪೋರ್ಟ್ ಆಗ್ತದೆ within 2 weeks my lord I will complete it.
Shall I keep it pending or shall I dispose? On 14th of July 2015, the petition filed by the petitioner in WP 44683 of 2014 and 4143-4144/2015 was disposed of by directing the petitioner to submit a fresh petition including the copy of the Tippani, the Akarband, RTC Pani for the purpose of conducting a survey. It is the case of the petitioner that despite several representations, The survey was not conducted even after the records were submitted. Learned AGA on instruction submits that as a matter of fact, survey has been conducted last week, and in all probability, a report will be given within a period of 2 weeks. In the later the said submission, the Tahsildar is directed, Tahsildar direct to conclude the survey, which is said to have been conducted last week, and issue necessary endorsement to the petitioner within a period of 4 weeks from the date of receipt of a copy of this order.
Great.
Issue number 18, Shivir Paksha PH.
Petitioners. Petitioners have sought for a writ of mandamus, my lord.
This matter, my lord, proposal has been sent to the government, my lord. The said proposal is awaited, my lord.
For what?
To reserve the land for the Ashaya scheme, my lord.
It's annexure E, my lords, at page 41, my lords, is the.
Direction is to R1 and R2. No?
Please, my lord. The Tahsildar, my lords, third respondent has forwarded, my lords, a recommendation to the first and second respondent authorities, my lord. At page 41, my lords, annexure E, my lords.
In Madle.
Another 2 weeks time may be granted, my lord.
My lords, may, on the last occasion also, my lord, there was a previous writ petition filed, my lord. If your lordship kindly peruse, my lord, order dated at page 45, my lords, annexure G, my lord. This honorable court, my lord.
What do you want me to do? Tell me.
Lordship may direct, my lords, the first and second respondent to consider the recommendation of the third respondent authority, my lord, and pass appropriate orders, my lord. Now, my lords, even though recommendation is made, my lords, it is kept pending since the year 2022, my lords. Page 43, my lords, is dated 22/7/2022, my lord.
The prayer in this writ petition is for issuance of a direction to the first and second respondent to pass appropriate orders in terms of the recommendation dated 22/7/2022 in relation to the grant of land in favor of the petitioners in Sub number 17 measuring 3 acres 20 guntas situated in Kitnalli village, Dasanpura Hubli, Bangalore North Taluk, and also to hand over the same in favor of the Karnataka Slum Development Board for development of sites expeditiously. The material on record indicates that the Tahsildar had made a recommendation on 5/7/2022 the Deputy Commissioner to reserve 3 acres, 5 acres, 3 acres 20 guntas,
3 acres 20 guntas.
3 acres 20 guntas in Sub number 70 for purpose of allotting sites to persons belonging to scheduled caste, scheduled tribe, and other backward classes. This recommendation was also approved and forwarded by the Deputy Commissioner to the government on 22/7/2022. And though more than 3 years have elapsed, the government is yet to take a decision on the recommendation. In the light of the recommendation of Tahsildar, which has in turn been approved and recommended the Deputy Commissioner, to be appropriate to direct the state government to consider the recommendations immediately, at any rate, expeditiously, at any rate, within a period of 2 months from the date of receipt of a copy of this order. The first respondent shall consider the recommendation and also issue a suitable endorsement to the petitions. Kodtira?
Government has to take decision, my lord. We will consider the recommendation of the Tahsildar, my lord.
Consider the recommendation and pass appropriate orders on the recommendation. Copy of the decision shall also be communicated to the 136th petitioner, that is aforesaid Dr. Ambedkar Horata Samiti. Great.
Number 19, M. Shiva Prakash.
For the petitioner, madam, can you pass over the matter?
In matter,
Petitioner seeking writ of certiorari.
I need to file
annexure D,
objections,
my
my
lord.
lord. Objections are ready. 1 week, my lord. Notice is not yet ordered, my lord.
what is annexure D?
Annexure D, endorsement issued by the Tahsildar, my lord. The petitioners made a representation before the respondent authorities for allotment of sites under the Ashaya scheme, my lord.
ಇನ್ನೊಂದೇನೋ ಸ್ಕೀಮ್ ಹಾಕಿದ್ರಲ್ಲ, ರಿಟ್ ಹಾಕಿದ್ರಲ್ಲ, ಇನ್ನೊಂದು ಬೇರೆ ರಿಟ್ ಹಾಕಿದ್ರಲ್ವಾ?
Yes, my lord. ಅದು mandamus ಕೇಳಿದ್ವಿ. During the pendency of the that petition, my lord, they have issued endorsement at annexure D, my lord, stating that, my lord, there is no
respondents. Released on
28.
Okay.
Number 20, Shri Somsekhar KH.
This matter, my lord.
Petitioner father was granted 3 acre 20 gunters of land in around 28 Milad Majli village, Kolar Taluk. Milad Annexure A is the acknowledged issued by the Milad Tahsildar. B is the Milad
The request
challenge
is
for
rejected, my lord. I will file it along with memo. Just now I received the copy, my lord.
Reject ಆಗಿದೆಯಾ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದು.
it is granted by Milad, just original records is with me. Cannot be Milad.
ಪಟ್ಟಿ ದಾಖಲೆಗಳಾದ್ರೆ ನಿಮ್ಮ ಕೋರುವಂತೆ ಪಾಣಿ ಇಂಡೀಕರಣ ಮಾಡಲು ರಾಹ ಇರುವುದಿಲ್ಲ ಎಂದು ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ವಿಲೇಯ ಮಾಡಲಾಗಿದೆ.
Lordship kindly see Milad Annexure A.
Challenges. ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು, ನೋ ಅದರ್ ಆಪ್ಷನ್. ನಿಮ್ದೇನೋ ಬೋಗಸ್ ಗ್ರಾಂಟ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಅವರೇ ಕೊಟ್ಟಿರೋದು ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಆಮೇಲೆ Lordship kindly Annexure B for a moment.
ಇಲ್ಲ ನಾನು ಏನು ಕೇಳಿದ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಲ್ವಾ?
ಮಾಡ್ತೀನಿ.
The prayer in
Annexure B ಇದು 400 ರೂಪಾಯಿ ಅವಾಗ ತಗೊಂಡಿದ್ದಾರೆ.
The prayer in the state petition is to direct the respondents to consider the representation submitted by the file of the petitioners to effect mutation in respect of the land bearing serial number 28 measuring 3 acres 30 gunters.
ಅಲ್ಲಲ್ಲ.
AG places on record an endorsement dated 4/4/2025 by which the Tahsildar has considered the request and rejected the same. So in view of the above, the prayer sought for in the petition was over reserved to the petitioner to challenge the
ಹೋಗೋಸ್ ಅಂತ ಹೇಳಿಲ್ಲ, ಲಭ್ಯವಿಲ್ಲ ಅಂತ ಹೇಳಿದ ಅಷ್ಟೇ. ರೆಕಾರ್ಡ್ಸ್ ಲಭ್ಯವಿಲ್ಲ ಅಂತ ಹೇಳಿದ.
ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೋಡಿ, ಕೋಟ ಅಂತಾನೆ ಬರ್ದಿದ್ದಾರೆ. ಕೋಟದ
ದಾಖಲೆಗಳಾಗಿರುವುದು.
ಚಾಲೆಂಜ್ ಮಾಡಿ. Challenge it.
Number 21, Government Advocate.
For the respondent.
The last occasion, my learned colleague had appeared and my lords had indicated that there are no grounds which are made out. 74 order now we are intending to challenge, my lords. My lords may kindly see the prayer. We are saying that the RRT entries by order of the DC dated 7/11/2012 and 19/2/1974.
You are challenging the order dated 19 to 74.
Yes, my lords. We have no difficulty in this thing, my lords, except for, my lords may kindly permit me to kindly come to page 44, my lords, Annexure D. The survey sketch would indicate that it is a hillock. Your agricultural keltiyare.
But after how many years?
There is no excuse for us to, but then the fact remains it's a hillock. Our takondu yen madak agala because it's a hillock. Of course, under the mines and minerals, they can seek permission to excavate this and then if at all, if it is still usable as an agricultural land, that is.
And this order is passed in respect of Papaya.
Yes, Manoj. Correct. Papaya son of Munyappa.
Then writ petition is filed against whom?
Papaya and Rangswamy.
Both Papaya and Rangswamy, page number 10.
And he pointed out last time the note.
Now note ಹೇಳಿದ್ದು only insofar as Rangswamy is concerned because Rangswamy is dead.
Rangswamy is not even a partier and you made him a party.
I'm sir. I understand, Manoj. But then my only thing is in what way they can utilize the land as such because it's a hillock.
Same contention was taken in Rangswamy's matter, my lord, in the writ petition, saying that it is a hillock. This court directed them, my lord, to do podi. That was, my lord, confirmed by the division bench, which I produced along with the memo.
Late challenge.
Podi madak agala. What they are saying.
ಮಾಡಿದ್ರಂತಲ್ಲ Rangswamy ಕೇಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರಂತ.
ಅಲ್ಲ ಮಾಡಕ್ ಬರಲ್ಲ, it's a hillock.
But division bench ಒಪ್ಲಿಲ್ವಲ್ಲ ನಿಮ್ದು, ನಾನು ಒಪ್ಲೆ.
ಅಲ್ಲೂ ಯಾರು ಹೇಳಿಲ್ಲ. I went through the entire records. ಒಂದು ದೊಡ್ಡ ಬಂಡೆ ಅದು. 11 acres and what is the ಬಂಡೆ?
ಇದನ್ನು ವಜಾ ಮಾಡ್ತೀನಿ ಇನ್ನೊಂದ್ಸಲ ಹೇಳಿ ಅವ್ರಿಗೆ. Maybe Bhanuprakash says they may listen.
ಅಲ್ಲ ಬಂಡೆ, the factual fact remains that it's a huge hillock.
An order passed by the Special Deputy Commissioner on 19th of February 1974, registering the applicant Papaya as the occupant in respect of 3 acres, it's number 65 of Alage Devralli village, is being challenged by the government by way of this writ petition which has been filed on 20th of February 2025. In other words, an order passed more than 51 years ago is being challenged by the government. Learned counsel for the respondent contends that on the same day, another order was passed in favor of Rangaswamy, correct?
Yes, my lord, same day.
And the said order was also challenged by the government in WP.
Well, that order was not challenged. We had come before this court, my lord, seeking for Podi.
And on the basis of that order, Rangaswamy and his legal heirs had sought for Podi. And this court had disposed of the writ petition by directing a Podi to be conducted. It is also submitted that a defense was taken up by the state that Podi could not be conducted since the land granted was essentially in hillock. However, this objection was overruled and the challenge made by the state in writ appeal number sounds.
Writ appeal number 1331 of 2024. 1331
of 2024 was also dismissed. In the light of the dismissal of the writ appeal by the government, refuting the contention that hillock has been granted, the present challenge cannot be entertained, especially when it has been made 15 years after the order was passed. The writ petition is therefore dismissed.
Great. 22. My lord, the DP Mahesh has filed wakalat, my lord, in respect of.
Correspondent number 1 to 3. Dismiss ಮಾಡ್ತೀನಿ ಬಿಡಿ.
I prefer the petitioners. The petitioners are seeking the writ of mandamus to consider their representations annexure K and L. Petitioners are the scheduled tribe communities, my lord. They filed the application for land purchase scheme.
ಇವ್ರು ಯಾರು ತಗೊಳ್ತಾರೆ?
They are the petitioners, my lord.
ಮಹರ್ಷಿ ವಾಲ್ಮೀಕಿ.
ಅದು they have to emergent notice.
ಅವ್ರು ಯಾರು ಲಾಯರ್ ಇಲ್ವಾ?
ಅದಕ್ಕೆ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ.
Issue notice to R4. Petitions permitted to take out notice on R4 personally or by courier. Very well. 2 and 4. Then quoting.
Number 23, Shri K.V. Narsara, here for the petitioner.
I have received a note. I'm here for the respondent number 4. I'm filing the additional statement of facts. My lord, she is the adjacent owner of survey number 29 bar 27, 28, 23. ಅವರು 9 ಎಕರೆ ಚಿಲ್ಲರೆ ಪಕ್ಕದಲ್ಲಿದೆ ನನ್ನ ಸರ್ವೆ ನಂಬರ್ 29 ಬಾರ್ 2 ಬಾರ್ 30 ಪಕ್ಕದಲ್ಲಿ. ಅದರ ಫೋಟೋಗ್ರಾಫ್ಸ್ ತಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು ಇಟ್ ಇಸ್ ಕ್ಲೈಮಿಂಗ್ ದಟ್ ದಿ ಆರ್ and moreover they have not challenged the original annexure D order. Annexure D order is review order adu ನಮ್ಮ ಇದರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು annexure D ನಲ್ಲಿ.
I received a copy of the factual things. I need some time to file it, sir. ಇದರಲ್ಲಿ ಏನು ಹೇಳುತ್ತೆ ಅಂದ್ರೆ in all the survey number 2 would measure the second paragraph, no? Second paragraph. In all, survey number 2 would consist of 112 acres and 16 guntas. In the Akarban, RTC ಅಲ್ಲಿ 135 acres, 33 guntas ಅಂತ ತೋರಿಸ್ತಿದೆ. There's a difference of 23 acres, 17 guntas. Out of which 46 acres, 14 guntas is the Gomala as on today. ಅದರಲ್ಲಿ 9 ಜನ they have made an application under Forms 57. And certain appeals are also pending. ಇವರು ಮೊಗಣ್ಣಗೌಡ ಅವರಿಗೆ 2 ಎಕರೆ 20 ಗುಂಟೆ ಮೊದಲಿಗೆ ಆಗಿತ್ತು, ಬಟ್ in the year 1994. However, in the year 1961, one Syed Ali was granted 3 acres. So I need some time to verify these notes. And also our objections are not filed.
ಯಾವ್ದು ಸೆಟ್ಲ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಯಾವ್ದು
ಅಲ್ಲ ಸೆಟ್ಲ್ ಇದರಲ್ಲಿ ಒಂದು ಎಕ್ಸ್ಟೆಂಟ್ ಜಾಸ್ತಿ ಇದೆ, ಅದು ಏನೋ ಒಂದು ಅರ್ಧ ಎಕರೆ 1 ಎಕರೆ ಅಲ್ಲ, ಆಲ್ಮೋಸ್ಟ್ 23 acres is ಡಿಫರೆನ್ಸ್. ಜೊತೆಗೆ ಇವ್ರು ಗ್ರಾಂಟ್ ಕೊಟ್ಟಿರೋದು ಸರಿ. ಆಮೇಲೆ earlier grant in 61 is not set aside for whatever reason.
So that's what I challenge. No, what has happened is, my lord, they grant it to me. My lord, I'm in possession of the property. I develop the land, and suddenly, my lord, the claim comes from the respondent. Then I realize it when, my lord, I challenge it. Now, in the challenge, my lord, the assistant commissioner can say whether his grant is valid or not. He goes to the extent of holding it against me in my appeal and cancels my grant. By then it's almost 30 years, my lord, that I have been granted with this.
Annexure D is not the original grant order.
I resolve this.
No, it's very difficult for 2 reasons. ಒಂದು ಅಲ್ಲಿ ಆಕಾರ ಬಂದು RTC ಗೂ ತಾಳೆನೇ ಇಲ್ಲ.
ಇರೋರ್ ಗ್ರಾಂಟ್ ಮಾಡೋರ್ಗೆ ಏನ್ ಮಾಡ್ತೀರಿ ಇವಾಗ?
That I have to sit with the DC my lords. 23 ಎಕರೆ ಜಾಸ್ತಿ ಇದೆ. ಇವ್ರು ಕೊಟ್ಟದ್ದು 23 ಎಕ್ಸ್ಟ್ರಾ ಅಡಿಷನಲ್ ಇದೆಯಾ? ಅದು ಮೊದಲಿಗೆ ಯಾಕಂದ್ರೆ ಮೊದಲಿಗೆ 61 ಅಲ್ಲಿ ಕೊಟ್ಟದ್ದು 3 ಎಕರೆ. ಈಗ 91 ಅಲ್ಲಿ ಕೊಟ್ಟದ್ದು 2 ಎಕರೆ. Whether it was the grant was right or not, I'll have to look into. My lords may give me a week's time. Before vacation starts, I'll file my objections. My lords may have it.
My lord, I have borrowed the loan also for this and I have built up, that is why.
ಅವ್ರು ಹೇಳದ್ ನೋಡಿ ನಿಮ್ಗೆ ಇಬ್ಬರದ್ದು ಜಮೀನು ಕಾಣಿಸುತ್ತೆ.
ಅದೇ ಅಲ್ಲ, ನಂದು 1960 I am in position and enjoyment of.
ಅವ್ರು ಹಂಗೆ ಹೇಳ್ತಾರೆ, ಇಬ್ಬರದ್ದು ಜಮೀನು ಹೋಗುತ್ತೆ ಇವಾಗ.
ಅಲ್ಲ, ಅವ್ರದ್ದು 9 ಎಕರೆ ಜಮೀನ್ ನನ್ನ ಪಕ್ಕದಲ್ಲೇ ಇದೆ. ಆ ಬಿಲ್ಡಿಂಗ್ ತಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. 9 ಎಕರೆ ಅವರು ತೋಟ ಮಾಡಿದ್ದಾರೆ. ಹೆಂಡತಿ ಹೆಸರಲ್ಲಿ ಬೇರೆ, ಮಗನ ಹೆಸರಲ್ಲಿ ಬೇರೆ, ಎಲ್ಲರ ಹೆಸರಲ್ಲೂ ಗ್ರಾಂಟ್ ಮಾಡಿಸ್ಕೊಂಡವ್ರು ಅವರು.
Great.
Number 24, Sachin DS.
Registered settlement deed is executed by my father to me.
What are you challenging?
Annexure A order, AC order. 128 prakar, it should be automatic, registered document. My brother is opposing. He is opposing.
ಹೋಗಿ
Yes, Swami.
DC ಹತ್ರ ಹೋಗ್ಬೋದಲ್ವಾ?
Order note. He has held in my favor. Kindly see, not a reason or page 12. That's the reason why I filed a writ petition. ಮೇಲ್ಮನೆದಾರರು ಕರ್ನಾಟಕ so and so ರೆಡಿಯಲ್ಲಿ ಮೇಲ್ಮನೆಯವರು ಸಲ್ಲಿಸ ಮೇಲ್ಮನೆಯಲ್ಲಿ ಪ್ರತಿವಾದಿ ಅವರು ನೀಡಿದ ದಿನಾಂಕ 7/10/2023 ಪ್ರಶ್ನಿತ ಹಿಂಬರ ಆದೇಶವೆಂದು ಕರೆಯಲ್ಪಡುತ್ತಾ ಪ್ರಶ್ನಿಸಲಾಗಿದೆ so and so. ಮೇಲ್ಮನೆಯಲ್ಲಿ ಸಂಗತಿಗಳು ಮತ್ತು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಇಷ್ಟೇ. ಅದರಂತೆ ಮೇಲ್ಮನೆದಾರರು ಶೆಡ್ಯೂಲ್ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿ ಈಗಾಗಲೇ ಕಚೇರಿಯ ನ್ಯಾಯಾಲಯ ಪ್ರಕರಣ ಅಂತೆ 24/6/2022 ಆದೇಶ. ಇದು ನನ್ನ ಫೇವರ್ ಆಗಿದೆ. 2 ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಮಾಡ್ತಾನೆ ನನ್ನ ತಂದೆ, ಇನ್ನೊಂದು ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಪ್ರಕಾರ ನನಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಾರೆ ತಂದೆ. My brother opposes it. Tahsildar rejects it. Then I went in appeal before the AC. AC has held in my favor on 24/6/2022 in respect of different property. Sir, 2 ಪ್ರಾಪರ್ಟಿ ಇತ್ತು ಸರ್. ಒಂದು ಪ್ರಾಪರ್ಟಿಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಮಾಡ್ತಾರೆ, for which I made an application before revenue for change of khata. My brother opposes it. Tahsildar says that status quo order has to be made. Against that order, I went before the AC. AC has held in my favor. Since it's a registered document, the validity of the registered document has to be tested before the civil court by the opponent. So accordingly, AC has directed to change the entry in my favor. That is order dated 24/6/2022. This is a part of record.
Relation to which survey number that is?
Different survey number. Now, in respect of this survey number, this is also subject matter of registered settlement deed.
Same deed or different deed?
Different deed. My brother opposes, saying that the document is not valid. Tahsildar says that status quo to be made. Against that order, I came before the AC. AC passes this order.
You should go to the
disputed question of fact illa. ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಒಂದ್ಸದ ರಿಜಿಸ್ಟರ್ ದಾಖಲಾತಿ ಇದ್ರೆ
respondent to issue notice to R3.
25, Anandishwar Adia.
For the petitioner, as challenge to a KAT order, that annexure A, you'll see the operative portion at page 29.
You are for the appellant or for
petitioner? For the appellant. Just to give a background, what had happened in 1995 itself, an application was filed referring to the wrong survey number. There was one survey number.
What was the proceeding which came up before the tribunal?
Regularization. Regularization which came to be rejected by initially by the Tahsildar. We came to this honorable court. This honorable court said, you don't have jurisdiction, place it before the committee. The committee was then substituted by the DC. DC rejected on 2 grounds. One is that your original application referred to survey number 87, whereas actually you're now claiming for survey number 86 is 1. 2 is that it falls within 18 kilometers that prohibited distance on BBMP limits. Insofar as the first aspect is concerned, we had corrected it. In fact, we had written an annexure E. We had said that I'm illiterate. I had therefore sought correction. I had written in 2014 itself that 87 was wrongly, or 86 was wrongly mentioned as 87. And it was considered as 86. So therefore, there was no, in my opinion, no great dispute. The second aspect is what is really the only dispute, whether it falls within 18 kilometers. To that, Manoj, I'm instructed to submit right next door, Manoj, it has been regularized. So either.
When was it regularized?
So conversion orders has been.
Conversion kuda agide.
When was it?
That is annexure reject and.
It is before 18 kilometers. That's one thing.
That is 2022 itself.
2022 itself. 22.
In Manjana?
I have to seek a notice, my lord, because page 29 of the KAT order, my lord, paragraph 10 says,
I read, my lord.
2017.
Page 29, KT order. Whereas the lower court records page number 198 application submitted by the appellant dated 27/12/92. In the application serial number 8, she has mentioned survey number as 87. In serial number 9, it is mentioned as Kattada Pradesha 20x15. This shows that she has applied for building site measuring 20x15 feet in survey number 87 and has not applied for regularization of agricultural land 2 acres in survey number 86. In page number 96, there is a DO letter addressed to the Deputy Commissioner, Bangalore Urban District by Managing Director, so and so. ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಪರಿಮಿತಿಯಿಂದ 18 ಕಿಲೋಮೀಟರ್ ವರೆಗೆ ಬರುವ ಸರ್ಕಾರಿ ಜಮೀನು ಅಧಿಕೃತ ಒತ್ತುವರಿ.
Where have you raised that it falls, similar lands are granted? Where was it argued before the tribunal?
2015, 17.
No, where was it argued before the tribunal? That similar.
ಆಗಿದೆಯಾ? ಅಕಸ್ರ ನಂಬರ್ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದೀರಾ?
I have to say, fresh matter, my lord, I have to say. Perfect, my lord.
That's the only limited aspect, my lord. Beyond that.
AJ accepts notice for respondents. Still list.
Not to discuss.
The first.
Great.
Number 26. Suresh Krishna.
You for the petitioner, my lords. This is a matter, my lords, considering my representation at Annexure A. My lords, there's already a compromise decree passed by this honorable court. My lords, as an annexure.
Fresh matter, my lord.
CJ accepts notice for respondents. List. Yuriak, why did you make the sixth respondent a party?
Because there's a compromise decree, I can file, he's agreed to it.
Issue notice to R6.
Number 27. H. Shant Kumar.
Great.
Petitioner challenge the annexure.
Page 46, my lord.
46, my lord, that endorsement issued by Tahsildar. The compromise petition, the court decree was passed. It must be registered as a, settlement is there, my lord, before the civil court. 128 ಪ್ರಕಾರ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸ್ಬೇಕು ಅಂತ ಹೇಳಿದೆ. I am not transfer the somebody, some person, third person, my lord. ನಮ್ಮ ಖಾತೆ ನಮಗೆ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ.
ಖಾತಾ ಯಾರ ಹೆಸರಲ್ಲಿತ್ತು?
ಅದು ನಮ್ಮ ಫ್ಯಾಮಿಲಿ, ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ.
Suit is between NC Ajit Kumar, Appaswamy and others.
Yes, ಪಾರಿಕೃತ ಆಯ್ತು, ಪಾರಿಕೃತ ಮೇಲೆ ನಾವು
ಅಲ್ಲ ಈ ದಾವಾಕ್ಕಿಂತ ಮುಂಚೆ ಯಾರ ಹೆಸರಲ್ಲಿತ್ತು?
ನಾವು ಆನ್ಸಿಸ್ಟರ್ ಪ್ರಾಪರ್ಟಿ ನಮ್ಮ ತಂದೆ ಹೆಸರಲ್ಲಿತ್ತು.
ಯಾರ ಹೆಸರು?
ತಂದೆ ಹೆಸರು ಮೇಲೆ ಅಪ್ಪಸ್ವಾಮಿ.
ತೋರಿಸಿ RTC.
ತಂದೆ ಪರ್ಮಿಷನ್.
Number 28. Shri Kevin Narasimhan.
The matter concerns, my lord, the cancellation of the grant made in favor of the petitioner. My lord, the petitioner.
On what ground is it cancelled?
Pardon me.
On what ground?
My lord, on the ground that I am not in possession of the property. Now, my lord, I produced the photographs and the material saying that I have brought it under cultivation. My lord, in the meantime, it so happens that the.
How much is grant?
2018, my lord.
7 years.
Please. Now I produce the documents. My lord, in the meantime, what happens is Deputy Commissioner wanted to reserve this, my lord, for Ashraya Yojana. I challenged this before this honorable court. Stay is granted. Now Deputy Commissioner somehow wants to, my lord, justify his decision. So he recites the.
Where is that? Where is that writ petition?
I have produced it annexure L, my lord, page number 71. Annexure K, page 69 is the order of the Deputy Commissioner.
Notice for respondents 1 to 4. Who is R5 and R6?
Well, they were the persons who filed a complaint against me stating that we
issue notice to R5 and R6. Post number WP 10042/2024. Till the next date of hearing, there shall be an interim stay. All further proceedings pursuant to annexure F.
Okay. Number 29. Rajshekar history. Number 29.
Fresh matter, my lord, they are seeking for effect kata as per. In terms of the Sagoli chit, my lord, I will take notice, my lord, I have to secure it.
Access this for respondents.
Number 30. Shri Ketan Kumar for petitioner.
Prayer is for mandamus directing the respondent to mutate the name of the petitioner in respect of petition subject property, my lords.
Notice for respondents.
My lords, submission, it may be disposed of with the direction to the.
Our instructions
please, date may be fixed, my lord.
22nd.
Please.
Number 30, sorry, number 31.
Lords, appearing for petitioner, my lords.
let's say it's a writ of mandamus, my lords, page number 54, my lords.
Consider his objections, my lord, because.
Let's say, no, my lords,
Contesting
what
res-
happened here, my lords?
Contesting respondent has filed an application, my lord, seeking for adbust. Then the petitioner has filed an objections, my lord, on 15/3/2025. Is seeking for a direction, my lord, to consider his objections and to pass orders, my lord. It may be disposed of, my lord, if not yet considered.
Let's, here, my lords, the suit is pending, my lords. Kindly come to page number 51, my
But
lords.
objections is filed on 15.
What is your objections, H1?
Not to
My lords,
conduct.
my objection is, my lords, suit is pending, my lords. There is an interim order, page number 51, my lords. The defendants or anybody on his behalf are hereby restrained by way of adding interim injunction from alienating or creating any charges in whatsoever manner in respect of suit schedule property till the disposal of fire number 3, my lords. This is the
ಸರ್ವೆ ಮಾಡಬಾರ್ದು ಇಂಜಂಕ್ಷನ್ ಇದೆಯಾ?
ಸರ್ವೆ ಮಾಡಬಾರ್ದು ಅಂತಿಲ್ಲ, my lords, because
ಸೊ ಸರ್ವೆ ಮಾಡ್ರೆ ಇನ್ನು ಆಚೆ ಬರುತ್ತೆ ಅಂತ ನೀವು ಮಾಡ ಅಂತಿದ್ರೆ.
ಅಲ್ಲ ಆಚೆ ಅಂತಲ್ಲ ಸ್ವಾಮಿ, ನಾನ್ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೀನಿ. What happened here, my lords? Kindly see page number 20, my
Ask him
lords.
to consider objections before he takes a decision to conduct a survey.
19th ಸರ್ವೆ ಇದೆ ಸ್ವಾಮಿ.
ಅದರ ಮುಂಚೆ he will take a decision.
ಸರ್ವೆ ಬೇಡ ಅಂತ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಸಿವಿಲ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅಲ್ಲ, he has a statutory duty to conduct a survey when a demand is made. If you have any legal right, let him examine it.
My lords, we have filed for adverse position, my lords. Before LRF.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ತಗೊಂಡ್ರೆ ಚೆನ್ನಾಗಿರ್ತಿತ್ತು, ಸರ್ವೆ ಮಾಡಿಸ್ಬೇಡಿ ಅಂತ. ನೀವು ಬರೀ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ನಾಟ್ ರಿಲೇಟೆಡ್ ತಗೊಂಡ್ರಿ ಇವಾಗ.
ಅದಕ್ಕೆ my lords, ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇದರಲ್ಲಿ my lords, there is a kindly see page number 23, my lords.
Is to direct
for a moment, my lords,
to consider the objections raised by the petitioner to the proposed survey. So it is a case of the petitioner that the petitioner and the contesting respondent are litigating in OS 34/2025, and there is an interim order in his favor, and therefore the survey should not be conducted. In my view, in the light of this assertion, the fourth respondent is directed to consider the objections raised by the petitioner before he decides to conduct a survey. So, with petitioner going to disposed of.
Serial number 32. Sought for a writ of mandamus, my lord, but direction to the second respondent
TJ to take notice, 3 list.
22nd. Number 33, petitioner, my lords. Challenging the order passed by the deputy commissioner, my lords. Deputy commissioner reversed the order of assistant commissioner and tahsildar, my lords. My lords, we have purchased the property in the year 1934, my lords, and we are the absolute owners of one.
What was the original order of the tahsildar?
Tahsildar says that in our file, ma'am.
Where is that order?
My lords, Annexure. $35, my lords. Sorry, 58.
58.
58.
You claim to have purchased 9 guntas, huh?
Please, my lord.
What is your name?
My lords, Varadamma, my lords, that is my grandmother, my lords. Ombegoda is
When
my,
did she purchase?
my lords, 11/12/1934, my lords.
So from 34 till this particular period, her name was never.
No, my lords. Our grandfather name was reflected, my lords. I have produced the revenue entries also. Kindly see page 36, my lords. Original appellant is the Varadamma, my lords. Varadamma is the wife of Maregoda, my lords. That is at page 36, my lords. Serial number 112. It is Maregoda bin Ombegoda name is reflecting, my lords. Page 36, my lords.
Typed copy.
Typed copy 37, my lords.
739.
And next page also, my lords, page number 41 also, my name also reflecting, my lords. Maregoda bin Ombegoda.
ಏನ್ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಆಯ್ತಾ?
Please, my lords.
ಅಲ್ಲ ಬಟ್ 34ನೇ ಇಸ್ವಿಯಿಂದ ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ ನೀವು?
My name is reflecting, my lords.
ಪ್ಲೀಸ್ ರೀಡ್ ಪೇಜ್ 39.
39, my
ಮಾರೇಗೌಡ
lords.
ಬಿನ್ ಒಂಬಾಳೆಗೌಡ ಖಾತೆದಾರರಾದ 1933ನೇ ಇಸ್ವಿ ಡಿಸೆಂಬರ್ ತಾರೀಕು 18ರಲ್ಲೂ ಒಂಬಾಳೆಗೌಡನಿಗೆ.
That is different, my lords. Others, ಬೇರೆದೆಲ್ಲ ಟೈಪ್ ಆಗಿದೆ ಅಲ್ಲಿ.
ಇನ್ಯಾವುದು?
ಸರ್ವೆ ನಂಬರ್ 112, my lords.
ಟೈಪ್ ಕಾಪಿಲಿ ಯಾವುದು?
Typed copy mistake ಇದೆ, my lords. 112, my lords.
112 ಇಲ್ಲ ಇಲ್ಲಿ ಜಂಜರ್ ನಂಬರ್.
In page 36, my lords. Maregoda bin Ombegoda. Ombalegowda. Ombalegowda is purchased the property, my lords. I have produced family tree also, my lords.
ಏನ್ ದರ್ಖಾಸ್ತು ಅಂತ ಇದು ಕ್ರಯ ಅಂತ ಹೇಳಿ ಬರ್ದಿದ್ದಾರೆ.
Maregoda bin Ombegoda, my lords. Subsequently, my lords, kindly see page F, annexure F, page 41, my lords. Pitrarjita, Maregoda bin Ombegoda. Page 41, my lords. Maregoda bin Ombegoda, Ombalegoda. Ombalegoda is purchased the property, my lords. That is the reason why it is saying that Pitrarjita.
ವರ್ಧಮನ ಹೆಸರು ಯಾವಾಗ ಬಂತು?
Vardhama next, subsequent to death of Maregoda, Vardhama name is. My lords, see, what has happened, my lords? Subsequent to this, my lords, some unauthorized name was reflected.
ಯಾವಾಗ ಬಂದ್ ಮಾರೇಗೌಡ ಹೆಸರು ಇತ್ತಲ್ವಾ?
ಮಾರೇಗೌಡನಿಂದ ವರ್ಧಮಂಗ್ ಬಂದಿಲ್ಲ, my lords. ವರ್ಧಮಂಗ್ ಬಂದಿಲ್ಲ. ಮಾರೇಗೌಡನಿಂದ ವರ್ಧಮಂಗ್ ಬಂದಿಲ್ಲ. But
ಮಾರೇಗೌಡ ಯಾವಾಗ ತಿರುಗಿದ್ದು?
Maregoda, my lords, we have no documents, my lord, when Maregoda died. But unauthorized, my lords, kindly see annexure page.
Please go to civil court.
My lords, I am the said order.
You are the wife of Maregoda.
Please, I am the wife of Vardhama's son, my lords. That is Maregoda's daughter-in-law, my lords.
ಈ ಎಸಿ ಮುಂದೆ ಹೋಗಿದ್ದು ವರ್ಧಮ್ಮ ಕೋಮ್ ಮಾರೇಗೌಡ.
Please, my lord, I am the daughter-in-law of Vardhama.
So Vardhama's name was never there.
Vardhama name was there, my lords. Kindly see page 62, my lords.
ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಅಲ್ಲ, ಮುಂಚೆ ಅದು ಮುಂಚೆ
ಇಲ್ಲ ಬಂದಿಲ್ಲ. Their unauthorized entries, my lords, they have no base for that.
You don't know when Maregoda died.
Please, my
you
lord.
don't know till what time Maregoda's name was entered. Then you come up after nearly 100
Annexure
years.
F1, my lords, kindly see annexure F1.
What does the DC say?
DC says go to civil court and establish your right. But I am the sale deed order, my lords.
Correct, but if you don't enforce your seal deed for 100 years.
No, my lords, not 100 years, my lords.
You don't know till what time Maregoda's name was there.
Please, my
You
lord.
don't have the mutation to show Maregoda's name being entered pursuant to a sale deed.
Please, my lord.
There's no MR in favor of Maregoda.
My lords, enter, my lords. Kindly see page
Pitrajita
41. Pitrajita, because my lord, Ombalegoda has purchased the property.
ಒಂಬಳೆಗೌಡ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೊಂದು MR ಇರ್ಬೇಕು ತಾನೆ?
Please, my lord.
ಆ MR ಇಲ್ಲ.
ಅದು ಸಿಗ್ತಾ ಇಲ್ಲ ಸರ್.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ
ಅಲ್ಲ
ಎಲ್ಲ ಮಲ್ಕೊಂಡಿದ್ರಿ.
And also, my lords, directed to us to go to civil court and also reflect the name of the respondents in the revenue entries.
Please read page 22. ಅಲ್ಲ third paragraph.
ಪ್ರಸ್ತುತ ಸರ್ವೆ ನಂಬರ್ 112 ರಲ್ಲಿ 9 ಎಕರೆ ಗುಂಟೆಯ ಜಮೀನು ಇಸಾಪೊಡಿಯಾಗಿ ಸರ್ವೆ ನಂಬರ್ 112/1 3 ಕುಂಟೆ, 112/2 3 ಕುಂಟೆ, 113/3 ರಲ್ಲಿ 3 ಕುಂಟೆ ಜಮೀನು ಖಾತೆ ನಮೂದಾಗಿದ್ದು, ಸರ್ವೆ ನಂಬರ್ 112 ರಲ್ಲಿ 3 ಕುಂಟೆ ಜಮೀನು ನೋಂದಣಿ ಕ್ರಯ ಪತ್ರದಂತೆ we already sold, my lords. That is mentioned, my lords. We have already sold to third party. Portion of property we have already sold, my lords. ನೋಂದಣಿ ಕ್ರಯದಂತೆ ರವಿಕುಮಾರ್ ಬಿ ಬಸವರಾಜರವರಿಗೆ ಖಾತೆಯಾಗಿರುವುದರಿಂದ 3 ಎಕರೆ ಗುಂಟೆ ಜಮೀನಿನ ಸಂಬಂಧ ವಾದಿಗಳಿಗೆ ತಮ್ಮ ಹಕ್ಕನ್ನು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನಿಸಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳುವಂತೆ ಸೂಚಿಸಿ 112/1 ರಲ್ಲಿ 3 ಎಕರೆ ಸರ್ವೆ ನಂಬರ್ 113 ರಲ್ಲಿ 3 ಎಕರೆ ಜಮೀನನ್ನು ಖಾತೆಯನ್ನು ಚಂದ್ರ ಬಿನ್ ಲೈಟ್ ವೀರಭದ್ರಯ್ಯ, ಕಿರಣ್ ಬಿನ್ ಲೈಟ್ ವೀರಭದ್ರಯ್ಯ ಗಿರಿಗಮ್ಮ ಅವರ ಹೆಸರಿಗೆ ಜಂಟಿಯಾಗಿ ನಮೂದಿಸಿ 1ನೇ ಪ್ರತಿವಾದಿಗಳು 11/12/1934 ಕ್ರಯಪತ್ರದಂತೆ ತಮ್ಮ ಹಕ್ಕನ್ನು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನಿಸಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಲು ಸೂಚಿಸುವುದು ಸೂಕ್ತವೆಂದು ಅಭಿಪ್ರಾಯಿಸಿ ಈ ಕೆಳಗಂಡಂತೆ ಆದೇಶಿಸಿದೆ. ಪ್ರಸ್ತಾಪಿಸಿ.
Correct.
My lords, already the revenue entry is in my favor, my lords.
I'm not impressed. But there is no revenue entrance in respect of the Maregoda.
Please, my lord.
Then ಇನ್ನೊಬ್ಬರ ಅವ್ರ ಮಗನ ಹೆಸರೇನು?
Maregoda is the son, my lords. Ombalegoda is the
Maregoda ಹೆಸರಲ್ಲಿ ಖಾತಾ ಇಲ್ಲ.
Please.
Maregoda ಹೆಸರಲ್ಲಿ ಖಾತಾ ಇಲ್ಲ, ಕ್ರಯ ಅಂತ ಎಲ್ಲೂ ಬರೆದಿಲ್ಲ, IHC ಇಂದ ಬರೆದಿಲ್ಲ.
Because
ವರ್ಧಮನ ಹೆಸರು ಬಂದೇ ಇಲ್ಲ. ಇವಾಗ ವರ್ಧಮನ್ ಸೊಸೆ ಬಂದ್ಬಿಟ್ಟು ನಮ್ಮ ಹೆಸರು ಹಾಕು ಅಂತಂದ್ರೆ.
But for the respondent, there is no base, my lords, how their name is reflected.
But right or wrong, their name has been there for quite some time.
But we are in the
You
possession.
accepted that.
We are in the possession, my lords. They are not in the possession, only taking advantage of unauthorized entries. They are disturbing us, my lords. And we have sold the property also. Kindly see Annex N, my lords.
ಅವ್ರ ಅದೃಷ್ಟ ಅವ್ರು ಉಳ್ಕೊಂತ ನಿಮ್ಗೆ ಅಷ್ಟಕ್ಕೆ ಬಂದಿರೋದು.
ನಮ್ದು ರಿಯಲ್ ಓನರ್ಗೆ ನಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ ನಿಮ್ ಹೆಸರೇ ಇಲ್ವಲ್ಲ, ನೀವು ಖಾತೆ ಇಲ್ದ್ರೆ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಯಾರಿಗೋ ಅಲ್ವಾ?
ಪ್ಲೀಸ್.
ಅವ್ರು ಕೊಂಡ್ಕೊಂಡವ್ರು ಬುದ್ಧಿವಂತರು ಅವರೇನ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನಿಮ್ಮ
ಇಲ್ಲ, ನನ್ನ ಹೆಸರು ಇದೆ. Kindly see Annex N, my lords. Annex N, page 77.
Page
77.
You said it was never there in the name of Vardhamma.
That is Varalakshmi, present petitioner, my lords.
Which is this MRH 30/23/24? ಎಲ್ಲಿದೆ ಅದು?
That is subsequently, my lords, we have divided the property, my lords. Divided the property.
Where is that?
We are not produced. I am not produced.
I think but you go to civil court.
Let's.
ನೀವ್ ಎಲ್ಲೂ ಇಲ್ಲ, ಸಡನ್ ಆಗಿ ಒಂದ್ ಬಂದ್ಬಿಡಿದ್ರ 90 ವರ್ಷ
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ ಸೈಡ್ ಇದೆ.
ನಿಮ್ದೇ ಅವ್ರ ಕೋರ್ಟ್ ಬಂದಿಲ್ವಲ್ಲ.
ನಂದು ಸೈಡ್ ಇದೆ ಸ್ವಾಮಿ.
Produce that MRH, let us see.
Till that time, alas, revenue interest may be stayed, my lord.
Produce it, let us see.
34. Srimati Harini, we are.
In this matter, my lord, I will take notice, my lord, and it can be disposed of, my lord. 19/6/24, my lord, 136(3) proceedings has been dropped. Thereafter, my lord, they have given a representation, my lord, on their further queries, my lord, to implement the order of the special DC. Some time may be granted, my lord. We will implement.
Next year, B na,
Please.
the 34, a proceeding under section 136 of clause 3 was initiated against the Obra petitioners.
Obre, petitioner, Obre.
Against one Bhanumati and the petitioner. Since the Tahsildar doubted the legitimacy of the grant made in respect of survey number 30 mentioning 4 acres, the Deputy Commissioner, after holding an inquiry at the 136(3), came to the conclusion that the name of the petitioner was required to be entered in the revenue records as the legal heir of the first respondent, Anumati. After he came to the conclusion that there was a grant made in favor of Anumati. It is a case of the petitioner that despite this order and despite the representative being given, the order of the Deputy Commissioner is not implemented. In the light of the fact that the Deputy Commissioner had dropped the proceedings initiated against Bhanumati and had also specifically directed mutation to be made in name of the petitioner, we appropriate to direct the Tahsildar to implement this order within a period of 2 months. We have rest of the copy of this order.
Please. Number 35, Sri Vajasri.
Lords, this case, my lords, have challenged the notice issued under section 104 of land
Tomorrow,
revenue.
the date is fixed for the inquiry, my lord. After this notice, my lord, the petitioner has filed an objections. Tomorrow it is fixed for
My
inquiry,
lords,
lord.
the
Let them
issue-
appear and before the.
The issue here is, my lords, annexure H may kindly be seen at page 125, my lords. Annexure H at page 125, they are saying in the nomenclature that it's a notice issued under section 104 of Karnataka land revenue. Summary eviction, my lords. My lords, now they are saying Karna Keluva notice. But my lords, if the contents of the notice is seen, it says you have already encroached. Why should I not take action against you under section 192 or 94?
And saying that why you have not, that you are not encroached. They will consider your objections.
My lords, my respectful submission is that to say that I've actually encroached or come to a finding under section 104.
This is view.
They have not given me any notice, my lords.
This is the notice that is
No,
given.
no, my lords, this is a notice which says you have already encroached. Why should I not take action under 92 or 94 or 192A, my lords?
Please read the notice if you want.
My lords, kindly come to the last paragraph of the notice, my lords.
Now read the first paragraph itself.
Shri G.N. Chandrasekhar bin Narasimhachar ಕೇತ್ಕನಹಳ್ಳಿ ಗ್ರಾಮ ಬಿಡದಿ ಹೋಬಳಿ ರಾಮನಗರ ತಾಲೂಕು ಆದ ನೀವು ರಾಮನಗರ ತಾಲೂಕು ಬಿಡದಿ ಹೋಬಳಿ ಕೇತ್ಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 7 ಸರ್ಕಾರಿ ಗೋಮಾಳ ಜಾಗದಲ್ಲಿ ಈ ಕೆಳಕಂಡ ವಿಸ್ತೀರ್ಣದ ಜಮೀನಿನಲ್ಲಿ ಹಾದು ಹೋಗಿರುವ ಕಾಲುದಾರಿ ಮತ್ತು ಸರ್ಕಾರಿ ಕಟ್ಟೆಯನ್ನು ಅನಧಿಕೃತವಾಗಿ ಒತ್ತುವರಿ ಮಾಡಿರುವುದು ಉಲ್ಲೇಖ 2 ರವರ ನಕ್ಷೆಯ ವರದಿಯಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. Next, my lords.
So he has got a report which says that you have encroached. So he is saying, why you should not take action to evict you.
Yes, my lords,
Reply.
that particular document they're
Reply is
relying
given.
on, my lords, that actually ought to have been, now my lords, for procedure under 104, I should have actually been heard, my lords. Like at least if a survey was conducted in my presence.
That's what he's going to do now.
My lords, the next para may kindly be seen, my lords. Next para, my lords. ಆದ್ದರಿಂದ ಈ ಮೇಲ್ಕಂಡ ಪಟ್ಟಿಯಲ್ಲಿ ತಿಳಿದಿರುವ ವಿಸ್ತೀರ್ಣ ಸರ್ಕಾರಿ ಜಮೀನಿನಲ್ಲಿ ನೀವು ಅನಧಿಕೃತ ಒತ್ತುವರಿ ಮಾಡಿ ಸ್ವಾಧೀನದಲ್ಲಿರುವುದರಿಂದ ಏಕೆ ನಿಮ್ಮಿಂದ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 1964 ಕಲಂ 94 ಅಡಿಯಲ್ಲಿ ದಂಡವನ್ನು ವಸೂಲಿ ಮಾಡಬಾರದಕ್ಕೆ ಹಾಗೂ ಸದರಿ ಸರ್ಕಾರಿ ಜಮೀನಿಗೆ ಅನಧಿಕೃತವಾಗಿ ಪ್ರವೇಶಿಸಿ ಒತ್ತುವರಿ ಮಾಡಿರುವುದಕ್ಕೆ ಏಕೆ ನಿಮ್ಮ ವಿರುದ್ಧ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ 1964 ಕಲಂ 192A ಅಡಿಯಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಮುಕದ್ದಮೆ ದಾಖಲೆ ಮಾಡಬಾರದು. So my lords, they have come to the conclusion. Now they are saying within 7 days you reply.
Show cause notice. If you want, I'll ask him to give you a copy of that Ulega 2 for you to file objections.
My lords,
to satisfy your requirement.
One submission, my lords, that this can be treated as a show cause notice because after issuing, no, my lords,
The show cause notice.
my lords, my respectful submission is that after issuance of this, JCB is ತಂದು ಫೆನ್ಸ್ ಹತ್ರ ನಿಲ್ಸ್ಬಿಟ್ಟು ಇವತ್ತು ಖಾಲಿ ಮಾಡ್ತೀರಾ ನಾಳೆ ಮಾಡ್ತೀರಾ.
7 days ಆಗಿದೆ, ನೀವು objections ಹಾಕಿಲ್ಲ.
ಹಾಕಿದ್ದಾರೆ.
We have filed, my lords.
Next, they have filed objections. My
We have filed in the next
Tomorrow it
connection,
is
my
fixed
lords.
for inquiry. My lords.
But my only apprehension is, my lords, they are limited to the issue of why I should not be penalized. Now, my lords, there's this judgment of this honorable court, my lords, coordinate bench, which particularly says, even to issue notice under section 104, my lords, I should have been given a notice as to why, whether I've encroached or not encroached, my lords. That opportunity was not given to me.
That is what is being given to you now.
Okay, my lords, but then finding may be recorded to the effect, my lords, that because I don't want them to limit this particular thing to 192A or 94, why I should not be penalized in that sense, my lord.
What do you want to do?
My lord, now because it says that why I should not be penalized under section 192A and 94, because I've already come to the conclusion that I have encroached, let them not take any coercive action and consider my representation.
The petitioner is aggrieved by the issuance of the show cause notice dated 18/3/2025, issued by the Tahsildar. The said show cause notice, it is contended by the Tahsildar that the ADLR has submitted a report on 12/2/2025 and 15/3/2025 to the effect that the petitioner had encroached upon the pathway and the Sarkari Katte unauthorizedly in survey number 98, 99, 100 and 101, measuring 3, 15, 21 and 11 guntas respectively. The Tahsildar is therefore calling upon the petitioner as to why action should be taken to evict him from the alleged encroachment. It is not in dispute that to this show cause notice, the petitioner has given a detailed response on 24/3/2025. In the light of the fact that the petitioner has given a detailed response to the show cause notice, it will be incumbent upon the Tahsildar to conduct to consider the objections raised by the petitioner and then pass an appropriate order before initiating any coercive steps against the petitioner. The petitioner is accordingly disposed.
Tomorrow it is fixed for inquiry, my lord. They also know, my lord. Let them appear before the inquiry tomorrow.
Then a DGA submits that, as a matter of fact, inquiry is fixed to be conducted tomorrow. That is so and so. And the petitioner may be directed to attend the inquiry. In the light of the above, the petitioner is directed to participate in the inquiry scheduled to be conducted tomorrow and put forth his contentions before the Tahsildar. As already observed above, the Tahsildar shall consider the contentions raised by the petitioner and pass an appropriate order on merits and furnish a copy of the order to the petitioner to enable him to challenge it if it is adverse to his interest.
Grateful.
36.
For petitioner, my lords, I'm challenging the annexure A, the order passed by the district commissioner with respect to cancellation of my mutation. My lords, petitioner is the plaintiff and respond number 3 and 4.
Petitioner is the
plaintiff. Respond number 3 and 4 is the defendants. There are suits and counter suits. I have filed a suit for.
What is the original order with Tahsildar?
Sorry, my lords.
Which was the original order of the Tahsildar which was challenged?
My lords, annexure A at page 15,
This is the order of the DC.
District Commissioner.
Which is the original order of the
But,
Tahsildar?
Lord, that is at page number 107, annexure.
No, that is the AC's
Yes,
order.
yes, my lords.
Where is the order of the Tahsildar?
This is the order. My lord, when the suit is pending,
Where is this RRT number 567/22/23 dated 31/7/2023? This was the original order, isn't it?
my lord. My lord, that is at page number 101, annexure H. My lord, this is on 31/7/2023.
Please read that.
ನಿಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಿದ ಚನ್ನರಾಯಪಟ್ಟಣದ ತಾಲೂಕು ಬಾಗೂರು ಹೋಬಳಿ ಕುಂಬಾರಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 45/2ರಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಖಾತೆ ಕೋರಿದ್ದು, ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಖಾತೆ ಮಾಡಲು ಕಾಳಮ್ಮ ಕೋನ್ ತಿಮ್ಮೇಗೌಡರವರಿಗೆ ಈಗಾಗಲೇ MR 8/9/91ರಂತೆ ಖಾತೆಯಾಗಿ ಕೈಬರಹದ ಪಹಣಿ ದಾಖಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಚಾಲ್ತಿ ಪಹಣಿಯಲ್ಲಿ ಖಾತೆ ನಮೂದು ಮಾಡಲು ಮ್ಯೂಟೇಷನ್ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ ಪ್ರಾಧಿಕಾರದ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಅರ್ಜಿಯನ್ನು ವಿಲೇ ಮಾಡಲು ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕ ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ.
You made a claim on the basis of a court order.
My lord,
What court order?
this is not my application, my lord. This is
Kammaya's.
respond number 3 and 4 application.
Kammaya's application.
ಹೌದು. I am
What
the
was-
plaintiff.
What was the Assistant Commissioner's order?
Assistant Commission order says mutation ಮಾಡಿ ಅಂತ. ಅಲ್ಲಿ ಎರಡು ಸೂಟ್ ಇದೆ, ನಂದು ಒಂದು ಸೂಟ್ ಇದೆ, ಅವ್ರದ್ದು ಒಂದು ಸೂಟ್ ಇದೆ. There is a suit for declaration. That is at page number 108, my lord. ನನ್ನ ಹೆಸರಿಗಾಗಿರೋ mutation ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. My mutation is at page number 69.
What is this MRH 33/1718?
My lord, that is at page number 69.
69?
ನನ್ನ ಹೆಸರು ಪ್ರಾಪರ್ಟಿ ಮ್ಯೂಟೇಷನ್ ಆಗುತ್ತೆ. Annexure B4.
On what basis?
My lord, it's inherit on death. On death of Timmegowda, the property is transferred to his son Shivegowda. Not the originally survey number 45/2, my lords.
Then what is this 11/5/1990? Who had executed the sale deed?
ಅಲ್ಲ, ಇವ್ರು ಹೇಳೋದು ಸೇಲ್ ಡೀಡ್ ನನಗೂ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ ಅಂತ. My lords, what happened was
ಬರ್ಕೊಟ್ಟಿದ್ದು?
ಇವರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 and 4 ಅವ್ರ ತಾಯಿ ಹೆಸರಿಗೆ ಆಗಿದೆ ಅಂತ.
ಅವ್ರ ತಾಯಿಗೆ ಯಾರು ಬರ್ಕೊಟ್ಟಿದ್ದು?
ರಂಗೇಗೌಡ ಅಂತ ಬರ್ಕೊಟ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. My lords, what happened was survey number 45/2 was measuring 2 acres 26 guntas belonging to one Topegowda. When he was alive, 1 acre 12 guntas was sold in favor of another Topegowda, and after his death, that 1 acre for his properties were divisioned amongst his sons. One is Timmegowda and Rangegowda. This 1 acre 14 guntas that shoot scheduled property fall into the share of Timmegowda. ಇವ್ರೇನ್ ಹೇಳೋದು, ನನಗೆ ರಂಗೇಗೌಡ ಬರ್ಕೊಟ್ರು 1 acre 12 ಗುಂಟೆನ ಅಂತ ಇವ್ರು ಹೇಳೋದು.
ಬಟ್ ಅವ್ರ ಕ್ರಯಪತ್ರ ಇದೆ ಅಲ್ವಾ?
ಅವ್ರ ಕ್ರಯಪತ್ರ ಇದೆ, ಬಟ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಬೀನ್ ಇಟ್ಸ್ ಅ ಡಿಫರೆಂಟ್ ಪ್ರಾಪರ್ಟಿ.
But so long as the sale deed is not challenged, what is the effect?
My lord, I've sought for declaration, lord. That is that page number.
So if you succeed in the suit, then entries will
ಅಲ್ಲ,
go.
ಈಗ ನಾನು ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದೀನಿ, ಅವರು ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದ್ದಾರೆ, ಅವರು ಒಂದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಎರಡು ಕ್ಲಬ್ ಆಗಿದೆಯಾ?
ಅವರು ಹಾಕಿದ್ದಾರೆ, ಹೌದು madam.
Where is it?
ಹಾಕಿದ್ದಾರೆ. My lord, page number 78, our return statement.
Plaint ಇಲ್ಲಿ
78 minutes. ಹಾಕಿದ್ದಾರೆ. 78 minutes. Para 3. ವಿದ್ಯಮಾನಗಳು.
No, this is a written statement. Where is the plaint?
ಅಲ್ಲ, plaint none. Okay.
Plaint.
No, that is at page number 70. 70, my lord.
70.
Prayer is at 73.
You are Shivegowda, na?
How? My name is Shivegowda.
Where is their suit?
Their suit ಅವರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಪೇಜ್ ನಂಬರ್ 78, ಪ್ಯಾರಾ 3. ವಿದ್ಯಮಾನಗಳು ಈಗಿರುವಲ್ಲಿ ವಾದಿಗೆ ಈ ಮೇಲ್ಕಂಡ ವಿಚಾರವು ಖುದ್ದು ತಿಳಿದರೂ ಸಹ ವಾದಿಯ ಸ್ವತ್ತನ್ನು ಲಪಾಟಾಯಿಸುವ ಸಲುವಾಗಿ ರೆವಿನ್ಯೂ ಅಧಿಕಾರಿಗಳನ್ನು ಶರೀಕು ಮಾಡಿಕೊಂಡು MRH 33/17-18ರಲ್ಲಿ ಪ್ರತಿವಾದಿ 1 ಎಕರೆ 14 ಗುಂಟೆಗೆ ಕಾನೂನುಬಾಹಿರವಾಗಿ ಪೌತಿ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಪ್ರತಿವಾದಿಯವರಿಗೆ ವಾದಿಯ ಮೋಸದಿಂದ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರುವ ವಿಚಾರವು ಎರಡನೇ ವಾದಿಯ ವಿರುದ್ಧ ಆದ ಸಂಖ್ಯೆ 1000/2022 ದಾವಾ ದಾಖಲು ಮಾಡುವ ಒಂದು ವಾರದ ಹಿಂದೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಯು ಬ್ಯಾಂಕಿನಲ್ಲಿ ಸಾಲ ತೆಗೆದುಕೊಳ್ಳಲು ರೆವಿನ್ಯೂ ದಾಖಲೆಗಳನ್ನು ತೆಗೆಸಿ ನೋಡಲಾಗಿ ವಾದಿಯು ಮೋಸದಿಂದ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಆದುದರಿಂದ ಎರಡನೇ ಪ್ರತಿವಾದಿಯು ಅನ್ಯ ಮಾರ್ಗವಿಲ್ಲದೆ ವಾದಿಯ ವಿರುದ್ಧ ಇದೇ ಘನ ನ್ಯಾಯಾಲಯ ಆದ ಸಂಖ್ಯೆ 1000/2022ರಲ್ಲಿ ಹಕ್ಕು ಘೋಷಣೆ.
Before the mutation, in whose name was the kata standing?
In my name.
Before the mutation.
In my father's name. Timmegowda.
Where is that?
Well, that is at page number RTCL, page number 22, B2.
Page number?
22. ಆಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 24 ಎಲ್ಲ RTC ಹಾಕಿ.
Page number?
Page number 22, my lord, 22 in the starter. Typed copy 23 ನಲ್ಲಿದೆ.
There are two Timmegowdas there. One is KT Timmegowda, bin Tirumale.
ಹೌದು, KT Timmegowda is 1 acre 12 ಗುಂಟಸ್ my lords.
Other is Timmegowda.
ಅದು ಇನ್ನೊಬ್ರು ತಿಮ್ಮೇಗೌಡಂಗೆ ಇವ್ರ ತಂದೆ ಬದುಕಿದ್ದಾಗ ಮಾರಿರ್ತಾರೆ. KT Timmegowdange, there are two Timmegowdas. One is my father.
What's your father's name? KT.
Timmegowda. ತಿಮ್ಮೇಗೌಡ ಸನ್ ಆಫ್ ತೋಪೇಗೌಡ ಅಂತ ಇದೆ. ಪೇಜ್ ನಂಬರ್ 22 ನಲ್ಲಿ KT ತಿಮ್ಮೇಗೌಡ ಕೆಳಗಡೆ ಇದೆ.
Do you have the copy of these two MRs? MR 2/6566 and MR 15/8485?
ನಾನು ಇಟ್ಸ್ ನಾಟ್ ಅವೈಲಬಲ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಎಲ್ಲಿ ಹೇಳಿದ ನಾಟ್ ಅವೈಲಬಲ್ ಅಂತ? On what basis was your father's name entered?
Sorry, ma'am.
On what basis was your father's name entered? ಅವ್ರ ದಾವಾ ಇಲ್ಲಿ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ?
ಕಾಪಿ ಸರ್.
ಅವ್ರ ಕಾಪಿ ಇಲ್ವಾ?
This is the copy of the MRs notes. ಅವ್ರು ಕೊಟ್ಟಿರೋದು. I'm in possession of the property. ಅವ್ರಿಗೆ ಎದುರಿಗೆ ರಿಸ್ಟೇನಿಂಗ್ ಆರ್ಡರ್ ಕೂಡ ಇದೆ ಫೇವರ್.
ಇತಿಲವಾಗಿರೋದ್ರಿಂದ.
That is at page number 84.
Now, how did your father get this property?
My lord, ancestral property. ನನಗೆ ಪಾರ್ಟಿಷನ್ ಶೇರ್ ಆಗಿ ತಿಮ್ಮೇಗೌಡಂಗೆ ಮತ್ತೆ ರಂಗೇಗೌಡಂಗೆ ಬಂದಾಗ ಅವರ ತೋಪೇಗೌಡನ್ ಪ್ರಾಪರ್ಟಿ.
ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ತೋರಿಸಿ ನನಗೆ. ಅವ್ರ ಸೇಲ್ ಡೀಡ್
ಅಲ್ಲ, ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಸೇಲ್ ಡೀಡ್ ಇದೆ ಅಂತ.
ತೋರಿಸಿ ಅದನ್ನು. Produce that sale deed.
Yes, I'll produce the copy.
Ready ನೋಡಿ MR 15/8485, number 14/8586. Ask him to get a copy. ಇದು ಕೊಡಿ ಅವರು.
ಆಯ್ತು. Date may be.
List.
21st. Number 37, Shri Raja L.
79 AB.
ಯಾವ ವರ್ಷದ ಆರ್ಡರ್ ರಾಜಾ?
17 2016.
16.
ನಾವು ನೋಟಿಸ್
ಆಗಿತ್ತಾ?
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ, ಅಬ್ಸೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Allot.
Bill number 38.
Appearing for petitioner. The petitioner has purchased the property at annexure F, page number 45. Page number 44 is the RTC.
Is annexure J?
Please, my lord.
Annexure J ಏನು?
J is the rejected order, my lord. J is a complaint given, madam. Before that, my lord, annexure E. Page number 44.
Instructions are required, madam.
Respondents 1 to 5. ಇವ್ರನ್ನೇ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು ಅವ್ರ ಹೆಸರಲ್ಲಿ?
ಅವರು ಎಲ್ಲ annexure H page number 63 में kindly peruse my lord ಎಲ್ಲ ಸರಿ ಇದೆ ಅಂತಾರೆ. There is no objection from the any party, there is no ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಮ್ಯೂಟೇಶನ್ ಆದೇಶದ ವಿವರ ಅದಾದ್ಮೇಲೆ ಅವರೇ ಫ್ರಾಕ್ಸಿ ಚೆಕ್ ಲಿಸ್ಟ್ ನ ಪ್ರಿಪೇರ್ ಮಾಡಿಬಿಟ್ಟು ಮ್ಯೂಟೇಶನ್ ನ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ ಫಾರ್ ದಿಸ್ ಅಲ್ಟೀರಿಯರ್ ಮೋಟಿವ್ ಅಂಡ್ ಸಚ್ ಅದರ್ ಥಿಂಗ್ಸ್. 3, 4, 5, 6, 7 ತಾವು ನೋಡ್ಬೋದು, ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. It's a through the register selded intimation has been properly sent by the sub registrar as per the order of this honorable court. ಕೊನೆಯಲ್ಲಿ ಫ್ರಾಕ್ಸಿ ಚೆಕ್ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಆಗಿದೆ ಅಂತಾರೆ. ಅದು ಕೇಳಿದ್ರೆ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಆಟೋಮೆಟಿಕಲ್ ಪ್ರಿಪೇರ್ ಆಗಿದೆ, ನಮಗೆ ಗೊತ್ತಿಲ್ದಂಗೆ ಅಂತಾರೆ. He himself has prepared the proxy checklist. ಅದಕ್ಕೆ ಅವ್ರ ಮೇಲೆ we have given a complaint against the revenue inspector and the action has not been taken against the revenue inspector.
Further, there are correspondences, my lord, why action has not been taken. Based on the representation as per Annexure J, my lord, I have to get instructions, my lord, because
ಇಲ್ಲ ಏನಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಏನು ಬರ್ದಿಲ್ಲ ಅಲ್ಲ ಇಲ್ಲಿ?
ಇಲ್ಲ ಏನೂ ಇಲ್ಲ, ಕೊನೆಗೆ ಒಂದು ಸೇರಿಸ್ತಾರೆ. ಇದು 7ರವರೆಗೂ ಎಲ್ಲ ಸರಿ ಇದೆ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಫ್ರಾಕ್ಸಿ ಚೆಕ್ ಲಿಸ್ಟ್ ಅಥವಾ ವಹಿವಾಟಿನ ವರದಿ ತಯಾರಾಗಿದೆ. ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಫ್ರಾಕ್ಸಿ ಸುಳ್ಳು ಒಂದು ಚೆಕ್ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಆಗಿತ್ತು ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಆ ಸುಳ್ಳು ಚೆಕ್ ಲಿಸ್ಟ್ ಅನ್ನ ಅವರೇ ರೆಕ್ಟಿಫೈ ಮಾಡಕ್ಕೆ ಹಿಮ್ಸೆಲ್ಫ್ ಹ್ಯಾಸ್ ಪ್ರಿಪೇರ್ಡ್ ಫಾರ್ ದಿ ಸಚ್ ಅದರ್.
AJ accept notice for response 1 to 5. Notice to R6 deferred for the present. Relist. Find out.
please do.
The preliminary hearing stage it may be listed.
First ಅವ್ರು ಹೇಳಿ ಅವರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ಅದೇ preliminary hearing stage ಅದು.
28.
Yes, please.
Number 39, Shri Vardarajan MS.
Have it next week, my lord, taken up 16th, my lord.
It is only a notice, my lord, 1325, both matters.
Because, my lord,
And the
16th, 41 also.
No 40, Shri TP Vivekananda.
Let's in an agriculture land, let respond number 7 has formed a layout and he has sold sites to different persons.
What is your interest?
Let's, I am the owner of the adjacent land. That is, you may kindly see page 32, annexure 31.
Who's R6?
R6 is the superintendent of police. R7 is the private party. Who is
R6?
the?
ಪೊಲೀಸರು ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಇದರಲ್ಲಿ?
Let's we complain to them also, my lord, saying that the in an agriculture land the construction is being put up. Kindly see, my lord, annexure C1 page 32. That's we are the owners of, my lord, land in
advocate.
15 and 12. We are the owners of land in survey number 15 and 12, and the respond number 7 is the owner of, my lord, 16 and 7.
Who's the owner in 15?
15 and 12, my lord, owned by the petitioners. 16 and 7 is owned by respond number 7. If your lordship could see the extract of the master plan annexure C1 page 32, it is next to my land and the entire land is in green zone. Let them file a report, my lord, after inspecting the land, and now the construction is being, my lord, put up. I kindly see the photographs which I have produced, which are annexure E page 40 onwards. Just next to the fence erected by the petitioners, and these are the trees, my lord, which are standing in the petitioner's land. Just next to that, my lord, the construction is being carried out.
Left on Thursday. Get instructions.
Copy to this.
AJ to take notice for respondents. Is there to secure instructions as to whether any attempt is being made to form a layout on the lands in question.
In survey number
Thursday.
In survey number 16 and 17 minutes.
AJ accepts notice for respondents. 3, 4, and 6. Sri K. Krishna to take notice for R2 and R5. Issue notice to R7. Petitioners permanent take out notice in R7 personally. Relist on Friday.
Friday is holiday. Friday is holiday. Thursday or
Thursday.
Thursday.
9th agutta. Can you do it by day after tomorrow?
15th minutes.
15th.
15th. Please.
41.
The time margin.
Even also.
16 for order, seal number 42. RB Sadashivappa.
On the last occasion, direction has been issued to the government to secure the original land reforms records, my lord.
One more week, my lord. Authorities, they are searching, my lord. Files are missing and.
ಏನ್ ಮಾಡ್ಬೇಕು?
My lord, any direction, my lord, to secure. 15th, I'll secure, my lord.
We'll list on 15th.
Seal number 43.
HD court ಇದಲ್ವಾ? My lord, sorry, my lord, kindly pass over, my lord. They are coming on, they are on the way, my lord.
Please pass over.
Krishna, my lord, the respondents 4 to 8 were supposed to file some objections on the last date of hearing.
Objections we have filed. In fact, my lord, we wanted to file a synopsis. Synopsis is ready, my lord.
We are ready with the matter, my lord, but my friend wanted some time.
They were supposed to give me a copy of the objections. Now they are telling it's a synopsis. I look into it, kindly have it next Tuesday, man.
Playlist.
On 15.
16. Obliged. Seal number 44. Shri Ashwath Narayan Reddy.
44, my lord. 44. Lord, day before yesterday, my lord, the communication has been made by, my lord, the government to the, my lord, deputy commissioner. Reject the, my lord,
ಏನಂತ?
ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ. Side ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ.
Now, DG placed on record in order passed by the government, whereby the government has refused approval for allotment of a site to the petitioner. Liberty is reserved to the petitioner to challenge the same.
Seal number 45. Shri Vishnu Reddy.
Petitioner, the fourth respondent is died. After that, I filed the memo. Respondent number 5 to 12 are her legal heirs, my
Read as
lord,
the analysis
already
of
on
R4
record.
as requested with the petitioner. Necessary note be made in the cost date.
Will be posted on next week, my lord.
Seal number 46. Srimati Vidya S.
I appear for the petitioner, my lord. My lord, in this particular case, I have filed IA number 1 for the stay, my lord. I was being granted this land by grant land, my lord. Subsequently now.
What is your observations on IA1?
My lord, in IA1, I have asked for not to participate the action on my annexure A, my lord. Annexure A is the grant certificate is issued in my favor.
What is annexure A?
My lord, annexure A is the endorsement issued by the respondent. Possession of that particular land, my lord. My lord, but however, my grant was granted from 1/4/1984. From then, I have only been in possession of that land. My lord, he is only given one line. If I can read page 16, my lord, he only tells you are not in possession and enjoyment of the land as more than 30 to 40 years. I'm reading page number 16 in my petition, my lord.
They refused to grant the land to you on the ground that you are not in possession.
My lord, the land was already granted to me on 1/1/84. I have been in possession, my lord. My lord, subsequently, there are a number of issues. There is R6 to 13 had filed a particular challenging this grant order before the special Tahsildar, my lord. That is before R3 they filed their case. And that particular.
Please read annexure A.
Lord, Annexure A, I'm reading English copy, my translated is in page number 16. It tells in connection with survey number 93 of Adihalli village, Kasaba, Hubli, Arsikare Taluk, under the above referred order in connection with Adihalli village, survey number 93 land, between the grantees arise in dispute by verifying the grantee genuine document, and there is provisions by carrying out the podying of land and carrying out to solve the dispute. An order is passed to the Tahsildar and ADLR to take suitable action. As per the above referred order, you are not in possession and enjoyment of the land as more than 30 to 40 years have passed after the sanction grant process, and this stays without possession.
One minute. You are also a rival grantee.
Lord, my grant is of 77. They claim that their grant is of 84. Now their grant is cancelled. In fact, there is a latest order that has been passed, which they will have to challenge before the deputy commissioner.
Where is their cancellation?
My lord, in my statement of objection, my lord, page, it is the latest order, my lord, annexure R12, page 49, please. That is dated 5/2/2025. That order, my lord, they will have to challenge it because their all entire history of the lands, my lord, has been considered.
What is their name?
My lord, their name is, my lord, Mahadeva.
Have you served a copy of this objection, sir?
Please, I have served.
My lord, it has been served.
Before the deputy commissioner.
I have a submission after I finish, my lord.
Now,
My
can
lord,
you reduce your volume? You are too loud. We can't hear you properly.
Sorry, my lord. Yeah. My lord, in this particular case, my lord, subsequent to my grant, lot of grantees were there, my lord, in this particular case. I was granted 3 acres, 35 guntas. And once I was granted this plan, from the day which I'm in possession, number of things has transpired in this particular case, my lord. I filed number of petitions because the petition was pending before R3 Tahsildar and Special Tahsildar. And subsequent, while the proceeding was on, they come and file the learned counsel which they relied upon is the order in the year 2024, while this petition was on, my lord. That is where they have cancelled, they are stating that they have cancelled my grant without giving me an opportunity. And this was while this writ petition was pending, and while this was aware by the respondent that this petition is pending, they cancelled my grant, my lord. And
don't you think you should challenge this?
My lord, that we have also filed an IA specifically to tell not to take action on this particular IA, because now already in the new sketch they are moving, telling that.
Madam, until you amend the petition and challenge this order, your main prayer will not survive for consideration. Your main prayer puts on the footing that you have been granted the land and therefore what is to be done. If they say that the land is cancelled, the land grant is cancelled, if you don't challenge it, then the prayer in the petition has become infructuous.
My lord, I will challenge that, but however, till I challenge, my lord, at least they should not take any purposive action against this particular, my lord, because they're already started. They're wanting me to move from that particular place where I'm in possession. So I will definitely challenge this order, my lord.
File an
Till then,
application for amendment immediately.
Submissions.
Yes, my lord. At least till then, I'll definitely do it, my lord. Till then, they have not taken any action against this particular annexure, my lord.
They are not in possession is of the year 1994. Consistently, my lord, it has been held that they have not been in possession.
No,
now, my lord, this order, if they want to challenge, they will have to challenge it before the deputy commissioner.
My lord, this was again. I'm repeating, my lord. This was done while this writ petition was pending, my lord.
Challenge it immediately. Then I'll consider your prayer.
My lord, I'll challenge it only till then. Till I challenge, my lord, kindly let them not take any action against me, my lord.
Do it tomorrow. I'll have it day after tomorrow. File the application amendment. I can't grant you an interim order instead of prayer, which is not even there before the court.
Yes, ma'am. I'll do that.
Please, oblige.
Much obliged.
What is amendment? Revision.
Now sought to be withdrawn by giving a room of another litigation.
ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ. ಏನಂತ ಮಾಡಿದಾರೆ? ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರಾ?
ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ತಹಸೀಲ್ದಾರ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ನಲ್ಲಿ ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Please advise them, ready. You know why they are.
ಇದು ಸರಿ ಇಲ್ಲ.
ಹಿಂಗ್ ಮಾಡಿ.
Will advise, my lord.
Last portion.
Egday's clients are very powerful.
ಅದಕ್ಕೆ ಇದು
ಅಲ್ಲ
ಆಗೋದು.
ಯಾರ್ ಪವರ್ಫುಲ್ ಅನ್ನೋದು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಈಗ.
Last ನಲ್ಲಿ.
And he is nobody. He is troubling the villagers and everybody there.
ಅಲ್ಲ, ನಾಲ ಬರ್ತಾ ಇದೆ ಅದನ್ನ
ನಾಳೆ ಇವ್ರಿಗೆ ನಿಮ್ಗೇನಿದೆ ಅಧಿಕಾರ ಅಲ್ಲಿ ಕೇಳೋದಕ್ಕೆ? ನೀವು ಆ ಊರ್ನವರೇ ಅಲ್ಲ,
ಬಿ ಕರಾಬ್ನಲ್ಲಿ.
ಆ ಊರ್ನವರೇ ಅಲ್ಲ ಅವರು. ಇಟ್ ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ದಟ್. ಅಲ್ಲಿ ಭಕ್ತಾದಿಗಳಿಗೂ ಎಲ್ಲ ಹೋಗಕ್ ಬಿಡಲ್ಲ ಅವರು.
Asking for
We'll advise the Lord.
Consider the Learned AG place on record.
ಅಲ್ಲ, this may be closed, my lord, if at all.
Which the, in which it is stated that the impugn notice, in the notice impugned in this repetition is being withdrawn. In the light of the above, no further orders are necessary.
Let the right to reserved, liberty has been reserved. ಅದರಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ಗೆ ಅದು ಮಾಡ್ಲಿಕ್ಕೆ.
The said communication is own for him to challenge the same in accordance with law.
My lord, liberty also may be reserved to me because my contention has not been considered at all.
He has come to the court, you have not come to the court. What liberty should I create?
No. See, whatever remedy which is available to me, well, let both parties have a remedy.
ನೀವು ಕೋರ್ಟ್ಗೆ ಬನ್ನಿ, ಅವಾಗ ನಾನು ಲಿಬರ್ಟಿ ಕೊಡ್ತೀನಿ. ಕೋರ್ಟ್ ಬರ್ತಾರೆ ನೀವು advise him. I think he'll be in trouble if.
ಇಲ್ಲ, I will advise.
48, in this matter, respondent number 9 and petitioner has settled the dispute, my lords. Illi enagutte, my lords, he is the purchaser of.
What is the prayer in the writ petition?
My lords, to set aside the order passed by the assistant commissioner and deputy commissioner and to rectify the revenue records, my lords, B, annexure, my lords, prayer B.
136(3) na.
ಹೌದು. ಇದರಲ್ಲಿ ಈಗ
TC order ಎಲ್ಲಿದೆ?
My lords, TC order is at annexure P, page 164. My lords, respondents number 122.
You are the revision petitioner there.
My lords, ಹೌದು. My petition is rejected.
Who's R9?
R9 is the purchaser of the very same property, my lords, where I claimed 30 guntas of land, which pertains to 8/3. 8/2 ಅಲ್ಲಿ ತೋರಿಸಿದ್ರು.
Who appears for them?
My lords, now my learned friend is appearing. ಇವಾಗ ಆ 30 guntas na.
Your Honor, for respondent number 9.
What's your name?
Your name?
R9, R10 and 11 for all three.
No, only 9.
9, Your Honor.
My lords, ಇವಾಗ ಏನಾಗುತ್ತೆ, 9 is in claims that he has purchased 30 guntas of land, which I have sought for, my lords, for rectification. ಈಗ ಅದನ್ನ joined up.
Madhurana?
Yes, sir.
Madhura CF.
CR.
Madhura CR enters appearance for R9.
ಈಗ my lords,
R10 and R11?
R10 and 11 ಬೇಕಾಗಿಲ್ಲ. ಇವಾಗ 9 and petitioners have settled the dispute, my lords.
Are you going to say that they are not necessary?
My lords, they are not necessary, my lords.
So the petitioner submits that notice to R10 and R11 can be dispensed with since they are not necessary parties. As the rest of the petitioner, notice to R10 and R11 is dispensed with.
ಈಗ my lords. Now, my lords, this 30 guntas, what I am claiming, my lords, has been purchased by respondent number 9 from respondent number 5 to 8. Because now he is developing that. In lieu of this dispute, my lords, the developer is allotting 9,300 square feet to me in this 30 guntas of land.
ಇದಕ್ಕೂ
ಅಲ್ಲ, ಈಗ 30 guntas what he has purchased from the respondents number 5 to 8 is the property in respect of survey number 8/3, which is in my possession.
Now, proceeding on 136.
If this my lords, suit ಇದೆ,
I don't know what other, there are so many other respondents here.
my lords, they are the purchase, they have alienate this property in favor of respondent number 9. Respondent number 9, my lords, he is purchased 2 acres 12 guntas, including 30
Will
guntas.
simply say that you don't wish to press the petition because of the settlement that you arrived at.
Yes, my lords. In terms of the settlement, my lords, it may be closed, my lords.
Consider the petitioner submits that pendency of the writ petition. The petitioner has settled his differences with the 9th respondent, and in light of this settlement, he does not intend to prosecute the writ petition. The compromise entered into between the petitioner and the 9th respondent are indicated in the petition that is now filed before the court. The same is taken on record. And the petition is dismissed and become unnecessary in view of this settlement.
Observation, my lords, suit is pending
That's why I said I don't know anything.
My lords, my lords, this compromise also I will
Only
record.
said WP has become unnecessary in view of the settlement.
Settlement. Yes, much obliged.
49.
But I appear for the caveators.
It will be part of the order, my lords, the compromise, my lords.
No, I've said there will be a part taken
Yes,
on record.
much obliged.
Not I appear for the caveators. Lord, we are not persons to in whose favor no land has been granted. 48 years delay, Lord, writ petition is filed.
They want a week's time. They want a week's time to comply with the objections.
Lord, let them comply, Lord, but can I request for next week, Lord, 48 years delay, Lord, in filing of the writ petition. But temple comes and says, Lord, the land, Lord, is granted in my favor, that is challenged.
All right.
Next week, Lord.
Let them comply. Without them complying, what's that I can do?
Lord,
Because you
they
comply
not-
on their behalf, I'll take it up.
Good. Number 50, Rupesh Abhi. Number 50.
Week's time.
Respondent number 6.
Number 51. Number 51, Shri Tyagarajapu.
Office submission has complied, you subsequently small of raised you. All the office submission has complied, you subsequently has raised the objection. Agree with the order passed by the Deputy Commissioner, Bangalore Urban, Rural. Originally land, agricultural land 26 guntas belongs to my father. Kindly page number 12, your lordship. Page number 12. Typed copy, page number 11, typed copy 12, your lordship. Column number 2, Chikkavirana is my father.
You had filed an appeal.
Please, your lord.
Under against which order?
Deputy Commissioner, page number 27, your lord.
Yav order mane?
Deputy Commissioner passed the order, kindly page number 29, your lordship. It's my ancestor property, your lordship. It's ILRR standing in my father name, your lordship. After that, all the revenue records transfer my father. After the demise of my father.
You challenge MR 11/93/94.
Please, your lord.
Where is that MR 11/93/94?
The only in respect of your lordship, kindly pay, just of delay, your lordship, they're saying that. And page number 29, the operative portion, your lordship. Page number 29 of the order.
You are challenging 93/94 order in the year 2022.
Your lordship.
And the kata was standing in the name of his father before that.
Before that, after that, it's standing my name, your lordship. Kindly see the page number 11, your lordship. Typed copy of page number 12, your lordship. Chikkavirana is my father name, your lordship. ILRR, your lordship. Typed copy, page number 12, your lordship. Second column number 2.
Where is the order of the DC?
DC order is the page
Section
number 27, your lordship.
He confirms the order of Assistant Commissioner.
27.
Page number 29 is 27 to 20.
29 and
29 Parish.
No, according to the order of the AC, please come to page 26. ಎರಡನೇ ಪ್ರತಿವಾದಿಗಳ ತಂದೆಯವರು ನೋಂದಾಯಿತ ಕ್ರಯ ಪತ್ರದ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋನ್ಸೋ 38 ಕ್ರಯ ಮಾಡಿದ್ದು ಎರಡನೇ ಪ್ರತಿವಾದಿಗಳೇ IHC 11/93/94 ಅಂತರಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ ನಂಬರ್ ಸೋನ್ಸೋ ಜಮೀನ್ ಪೌತಿ ಖಾತೆ ಆಗಿರುತ್ತದೆ. The ಖಾತೆ was in the name of his father.
Your lordship. The sale deed in the 1939 sale deed has produced, your lordship. Here, my father has sold the property, not this scheduled property. Entire joint family properties has been sold except this property, your lordship. I produce a sale deed, your lordship. It's a typed copy of sale deed, your lordship. This survey number is not there in the sale deed, your lordship. Apart from this survey number, 4 items has been sold my father, your lordship, to the respondents, your lordship. Apart from this property, your lordship. They wrongly made a representative before the Assistant Commissioner saying that this property is also a subject matter of the sale deed, your lordship. It's not so, your lordship. Entire sale deed is there, your lordship.
Pursuant to this sale deed, when was the name of the second respondent's father entered in the new records? That is
93, your lordship.
93 ಪೌತಿ ಖಾತೆ. ಅದರ ಮುಂಚೆ?
Until that, my name was there, your lordship.
Show me 91 RTC.
Please, your lord. Okay. Page number 21, your lordship. Typed copy of page number 21. RTC, your lordship, page number 13 onwards, RTC, your lordship. Chikka Virana is my father name, your lordship. Page number 13 is the RTC. It's 1973, your lordship. After that, continuously, as my father name has continued, your lordship. Page number 15 also, it's my father name's, your lordship. My name was entered.
First time hangare.
First time. It's ILRR, your lordship. My father name is standing in the page number 11, your lordship.
Yeah, on the ground of delay, my lord, it was.
It's only in
No, but if I thought the name of Jayama's predecessor and title was there in the records.
No, your lordship.
Another upon that. RTC shows, my lord.
Issue notice. AG accepts notice to response 1 to 4. Issue notice to R5 and R6. Status quo regarding entries to continue. To be maintained.
Number 52, Shri Ganesh Nath.
My lord, I am appearing for the petitioner. Now, the objection is with respect to the details and address of respondent number 13 to 16, my lord. Idರಲ್ಲಿ annexure A and other notices with respect to the matter in question, your my lord. Even there, we are unable to procure the details of respondent number.
What is this proceeding against?
My lord,
what is this proceeding about?
Challenging the order of a special tahsildar in granting the occupancy rights.
Enforcement.
Yes, yes, ma'am.
Why are they necessary parties?
My lord, what has happened, if your honor sees page number 142.
Where is the order of land tribunal?
My lord?
Land tribunal annexure A na?
Please, my lord. Occupancy rights.
Krishnappa was the tenant.
Krishnappa claimed to be the tenant and he had initiated the proceedings initially, my lord. Initially, it was rejected, saying that he was not an occupant there. And the land was a barren land. There was no question of cultivation. And thereafter, he has challenged the order and the matter was remanded.
You were the respondent landlord.
Please, my lord. I was the respondent landlord.
Where's your objections?
My lord, as far as respondent number. Respondent number 13 to 16, my lord. 13 to 16. Even in annexure A order, the details of them have not been furnished. And in the notice, they say all these are represented by me only. Nanna representationally.
No, were they partners of your firm?
No, my lord. No, my lord. No. There was one transaction in the year 1967 by the petitioner.
Where is your sale deed?
My lord, at annexure B, my lord. Annexure B is the sale deeds which I have purchased it in 5 different sale deeds with respect to 4 survey numbers. And with respect to the same, the RTC is also reflecting in the name of the petitioner at page number 130. So as far as the ownership is concerned, my lord, there is no dispute. The only question which was arisen was whether the tenant, that Krishnappa was tenant under me or not. So that Krishnappa, who had claimed to be the tenant under me, was unable to prove that he was the tenant under me. Based on presumption, the order has been passed saying that there is only one entry, my lord. That entry I'll. Page number 209, my lord. Before that, first order. My lord, at annexure J 168, my lord. The typed copy is at 169. Annexure J, my lord. So this was the first order passed by the land tribunal, my lord.
No, but please come to page 47. It is stated that you were the first respondent with the land tribunal, isn't it?
Yes, my lord. I was the first respondent.
Please read the first paragraph. Further, it shows.
Further, in
earlier to
respect
that
of
first
application.
respondent company has sold and conveyed the land in question instead of the second respondent herein under registered sale deed dated 20/12/67.
No, that is not correct, my lord.
What is the date? What is the sale deed dated 20/12/67?
That I have produced before this court, my lord, at page number. Page number 99, my lord. So this indenture was only signed and which was kept for register, which was submitted before the registrar adjudicate at Bombay. There, the registration was refused for not coming within time for executing the sale deed. So the note of the sub-register is at the end of the sale deed, my lord, page number 105 and 106. So the registration was refused. Thereafter, my lord, if my lord sees page number 130, adralli matte the parties who were the confirming parties to that sale deed have reconfirmed to the same amount to the petitioner hearing. So
what is there to show that you were in possession? You are a company based in Bombay.
Yes, my lord.
What is there to show that you were cultivating the land in question?
My lord, initially I was cultivating.
How can you hold this agricultural land after 74?
My lord, this was purchased in the year 1960-61.
Correct.
Thereafter, my lord, we were running a factory there. And thereafter, since along the railway parallel.
You got this land converted?
Yes, my lord.
When?
The artisanal entry this one converted anteli. If your honor sees, my lord, if that objection is overruled, I'll ask my senior to.
Office objections kept in abeyance for the present. List.
Date may fix.
Number 53, Shri Sagar BB.
My lord, any date, my lord, I beg this. 21st. Oblige, my lord.
Notice.
Notice Soltira. Counter submission accepted. In
But for mandamus, consider this request my lord.
ಮಾಡ್ತೀರಾ ಏನ್ ಮಾಡಿ?
ಅಲ್ಲ ಮಾಡಕ್ ಗೊತ್ತಿಲ್ಲ. How to get instructions.
Notice for respondents.
Take notice.
Relist.
Number 54, Shri Kishan.
Challenges to the order passed by the Assistant Commissioner, my lord. In fact, the Assistant Commissioner himself has conferred previously khata in favor of the petitioners, my lord.
Now, what is the office objection? Do not complete.
Some typed copies have to be.
Interim order ಕೊಡ್ಬಾರ್ದಾಗಿತ್ತು ನಾನು.
Lord, David Swami.
Interim order ಕೊಡ್ಬಾರ್ದಾಗಿತ್ತು.
In the course of the day, I'll comply, my lord. Kindly pass on, my lord. This matter may be taken up in the afternoon, my lord. Overlooking 75 years revenue records, my lord, the Assistant Commissioner passes the order saying that there are no original records available in its office. So it cancels the names of the petitioners, my lord.
DC ಗೆ ಯಾಕೆ ಹೋಗ್ಲಿಲ್ಲ?
Lord, in this case, filing an application for impleading, Lord, over the very same area, I've been granted a quarrying lease. I've been in possession of the area for the past.
Organized attempt to snatch the lands of poor farmers, my lord. They are before this honorable court, my lord. From 75 years, my lord, they are there, my lord. The Assistant Commissioner has no jurisdiction to pass this order at all, my lord. And principles of violation of natural justice also, my lord. Violation.
The Tahsildar couldn't have gone to the AC alva.
ಹೌದು.
He could have gone to the DC. Why did he go to the AC? One 136 ಇನ್ವೋಕ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು. ಅಪೀಲ್ಗೆ ಒಂದು ಆರ್ಡರ್ ಇರಬೇಕಲ್ವಾ? AC ಹತ್ರ ಹೋಗಕ್ಕೆ.
All hand in glove with mining mafia, which is happening in the adjacent lands, my lord.
70.
Page 170.
Is the Assistant Commissioner order.
ಇಲ್ಲ ಫಸ್ಟ್ ಪ್ಯಾರ ಪ್ರಸ್ತಾವನೆ ನೋಡಿ.
ನೆಲಮಂಗಲ ತಾಲೂಕು ಸೋಂಪುರ ಹೋಬಳಿ ಮಾಕೇನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 47-48 ಅನಧಿಕೃತವಾಗಿ ಖಾತೆ ಪಹಣಿ ಮಾಡಿರುವುದನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ ತಹಸೀಲ್ದಾರ್ ನೆಲಮಂಗಲರವರು ಸೋನ್ಸೋ ದಿನಾಂಕ 2/9/2020 ವರದಿ ಸಲ್ಲಿಸಿದ್ದು, ಈ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಿ ಚಾಲ್ತಿ ಪಹಣಿದಾರರಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸಿ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಲು ಸೂಕ್ತ ಎಂದು ನಿರ್ಧರಿಸಿ ಪಹಣಿಯಲ್ಲಿ ನಮೂದನ್ನು ತೆಗೆದುಹಾಕಲು ವರದಿ ಮಾಡಿರುವ ತಹಸೀಲ್ದಾರ್ ನೆಲಮಂಗಲರವರನ್ನು ಮೇಲ್ಮನವಿದಾರರನ್ನಾಗಿ ಚಾಲ್ತಿ ಪಹಣಿದಾರರನ್ನು ಪ್ರತಿವಾದಿಯನ್ನಾಗಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ 1900 ಅಡಿಯಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡು 14/12/20 17/9/24
ಅಪೀಲ್ ಹೆಂಗ್ ತಗೊಳ್ತಾನ 136(2) ಬರಲ್ಲ. 49A ಹೆಂಗ್ ತಗೊಳ್ತಾನೆ?
Somehow the names of the petitioners, poor farmers, were to be removed from the RTCs, my lord. They have passed this order, my lord.
Even there, if the grant is made in favor of the petitioner.
If he has any grievance about the entries, he can go to the DC under 136(3). How can he go to the Assistant Commissioner, and how can the Assistant Commissioner under 49A treat it as an appeal? There was no original order against which he could have entertained the appeal.
Then, my lord, the petitioners has, my lord, don't have, my lord, any records, my lord.
Correct. Let him go to DC. Can the ACE do this?
Matter of remand, my lord, lordship may.
Our remand. This order is without jurisdiction. If you want to let the Tahsildar go to the DC.
Liberty may be reserved, my lord. The Tahsildar may be.
Filing an application for impleading, my lord.
DC ಮುಂದೆ ಹೋಗಿ application ಹಾಕು.
Please.
It is noticed that the impugn order is passed by the Tahsildar, by the Assistant Commissioner, on the basis of a report said to have been summoned by the Tahsildar on 2/9/2020, alleging there were several irregular entries in the RTC. The Assistant Commissioner has treated this report as an appeal under section 49A and has entertained it as an appeal at the behest of the Tahsildar. It cannot be disputed that an appeal under section 136 of clause 2 would lie only against any order passed in respect of mutation of revenue entries. The Assistant Commissioner could not have entertained or could not have registered the appeal on the basis of a report of the Tahsildar. It is therefore clear that the order of the Assistant Commissioner, by treating the report of the Tahsildar as an appeal, cannot be sustained. Consequently, the impugn order is quashed. Our liberty is given to the Tahsildar to resubmit the report dated 2/9/2020 or a fresh report to the Deputy Commissioner under section 136(3) of the Land Revenue Act, subject to the above writ petition is allowed.
Lord, one submission, Lord. Pursuant to the order passed by this law, my lord.
Quash this order. What else you want to do?
Names of the petitioners have to be restored in the RTCs, my lord.
It is now quashed. It is automatic.
Yes, my lord. It may kindly be mentioned in the order, my lord, because they have been suppressed by this powerful mining mafia which is happening in the neighboring lands, my lord.
The names of to state that since the order of the Assistant Commissioner has been set aside, if the revenue entries are mutated against the petitioners, the same shall be restored in their favor.
Please.
Yes, my lord. Same, my lord.
Next time I won't grant you an interim order if you don't comply with office objections.
My apologies, my lord. My apologies. Grateful, my lord.
Seal number 55, Shakash Kumar Gowda.
Petitioner. Kindly have it next week, man. R6 ಗೆ ಸರ್ವ್ ಮಾಡಿದ್ವಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಮ್ಯಾಮ್.
Response 3 to 5 minutes. There is an appeal pending. There is an appeal pending before the Assistant Commissioner.
6 year. 6 with all ನೀವು ನೋಡಿ.
Only 3 to 5 minutes. Private party.
What is annexed, Sheriff?
There is a entry in the revenue records of a stay order granted by the Assistant Commissioner.
A week's time is granted.
Number 56.
I request it may be passed over, my lords.
We have filed wakalat
Please
on
serve
behalf.
notice.
Notice has been served, my lords.
We have filed wakalat on behalf of respondent number 4 to 7, my lord.
What about R8?
R8, we are not concerned.
Courier has been sent, my lords. Sorry.
Matter may be taken up for tomorrow, my lord. Arguing counsel is not in station today.
Maybe past or senior will come and argue the matter, my lord.
So and so states that he has entered appearance for rapport to R7. Office to print his name. They list on.
My lord, kindly have tomorrow, my lord.
My request for 23rd, my lord.
What is the urgency?
My lord, after obtaining the order, my lord, the
Interim
respondent
order
of 4 to 7.
The
It has-
interim order is passed on. AC order is stayed.
ಇದಂಗೆ ನೋಡಿದ್ರ ಆರ್ಡರ್ ನ
I have seen, but I have to check it tomorrow. It may be taken up tomorrow, my lord. I'm not taking time.
A4, my lord, petitioner.
Number 57. Prasanna, we are.
I'm sorry, my lord. I have not noticed the hand summons, my lord. I may be permitted to take.
weeks time.
I am told that one more writ petition is filed by the government challenging the very same KAT order, my lord.
Goes along with WP number.
It is in FR number, my lord.
What is number code?
10,476 of 2025, my lord.
Number 58, CMB Chandrachuda.
ಇದರಲ್ಲಿ
Kindly pass over this matter.
serial number 58, my lord, after 2 weeks, my lord,
Kindly pass over this matter.
I will enter appearance, my lord.
Kindly pass over this matter.
My lord, caveat copy is not yet served, I think, only today I have received. I have what you know. There is no urgency also. Interim order.
ಹೇಳ್ಬೇಕಲ್ಲ
Kindly pass over just to
The interim order prayed, my lord, your lordship may kindly see.
my colleague is on the way.
3/12/24 order. At least I will file my objections.
Pass over
There is
this
a lot
matter,
of
no objection.
suppression here. 2 suits are pending, my lord, before the trial court. Injunctions.
Kindly pass over this matter.
Day after tomorrow.
ಒಂದು is on the way. ಪಕ್ಕದಲ್ಲಿ ಕೂಡ ಇದ್ದಾರೆ ಅಷ್ಟೇ ಸರ್.
ಅವ್ರೇನೋ ಟೈಮ್ ಬೇಕಂತ day after tomorrow.
pass over ಮಾಡಿ ಈ submit whatever they want. Kindly just 2 minutes coming on.
ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ. ನಾಳೆ.
So I will.
Want some urgency, I'll hear him and then pass an order, that is all. Or else you convince him that it will be taken up next week, I'll adjourn it.
Order, because interim order prayed is stay of further proceedings in person to December 24.
ಅವ್ರನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ನಾನು ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀನಿ.
Very well.
ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ, ಕೂತ್ಕೊಂಡು ಕಾಯ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳಿ. ಅದಕ್ಕೆ ನಾಳೆಗೆ ಅಂದೆ ನೀವು ಕಾಯೋದು ಬೇಡ ಅಂತ. Tomorrow.
Please.
Tomorrow, day after tomorrow. 1 day's accommodation.
Day after tomorrow.
Number 59, Shishir number.
Lord, in this case, my lord, your lordship has directed me to produce the form number 7. Form number 7, your lordship will get it.
ಇನ್ನೊಂದ್ಸಲ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ ನಂಗೆ.
ಅದೇ ಆರ್ಡರ್ 1 ರೂಲ್ 10 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು on the ground that we are the co-owners of the property in question. Page number 22, your lordship kindly see me. Today's memo. Lordship got it. 22. My lord, the petitioners are concerned in respect of item number 7, my lord. Totally, he has claimed about 30 acres of land.
Where is the cost title of this land terminal?
My lord, cost title, my lord, first page ಅಲ್ಲಿ ಇದೆ, ಇವತ್ತಿನ ಮೆಮೊದ first page ಅಲ್ಲಿ ಇದೆ. ಅದು subsequently we got it, my lord. Therefore, at the time of filing, we number tally 945 of 8081.
You are for the Ella's of the landlord.
My lord, Pushpalata Adyantaya was a party to the proceedings. She is my cousin sister. My lord, we have filed an application on the ground that we are the co-owners of the property in question. Our application came to be rejected.
ನೀವು ಯಾರು ಬರ್ತಾ ಇಲ್ಲ, they're not prosecuting ಆ ಕೇಸ್ ತಾನೆ?
ಹೌದು. ಹೌದು. My lord, your lordship kindly see, my lord, the form number 7, which I have filed along with the page number 22, my lord. Today's memo. My lord, I am concerned only with regard to item number 7. There are so many items of the property which was granted in his favor, for which we are not a parties or we are not interested.
You're concerned with what? Which item?
7, my lord. Sorry, 8. 8. Mangalore Taluk village Padav 43, survey number 43 and 298, my lord.
totally measuring about 14.60 acres of land. No matter why we are interested to prosecute the matter, my lord, kindly turn to the page number 93, my lord. Petition copy, page number 93. One Subbaya Shetty, my lord, he has executed at an undisputed point of time, my lord. He has executed a release deed in our favor and other in favor of other family members. Now,
So settlement deed.
sorry, settlement deed. 1940. Now, my lord, kindly turn to page number 99, my lord. That Subba Shetty had two wives. Page number 99, Subba Shetty.
Yes.
Dhumakke and Kamala. Now, my lord, we are the children of Kamala. That is also mentioned under the 1940 document. Now, my lord, petitioners before your lordship are Suchitra's sons.
This word is Pushpalata is bedridden ಅಂತ ಹೇಳಿದೆ.
Yes, my lord. Now she is the daughter of Dhumakke, first wife. We are the daughters and sons of second wife. Now hitherto, my lord, she was contesting the matter up to Supreme Court. Matter was remanded by the division bench of this honorable court. Again, we went to the Supreme Court. Supreme Court.
You all Pushpalata went.
Pushpalata Adyanta. She was contesting the matter. Now, my lord, in the today's memo, kindly turn to page number. I have produced the medical certificate where, my lord, the power of attorney holder of Pushpalata Adyantaya, she is now aged about 90 years, my lord. It is at the page number. My lord, it is at page number.
ನೀವು ಅವ್ರ ಹತ್ರ ಒಂದು GPA ತಗೊಂಡು ಕೇಸ್ ನಡೆಸ್ಬೋತಾನೆ, ಇದೆಲ್ಲ ಯಾಕೆ ಬೇಕು ನಿಮ್ಗೆ?
Pardon, my lord.
ಅವ್ರ ಹತ್ರ ಒಂದು GPA ತಗೊಂಡು ಕೇಸ್ ನಡೆಸಿ.
ಅಲ್ಲ, ಅವರು ಫಸ್ಟ್ ವೈಫಿನ ಹೆಂಡತಿ.
ಇಷ್ಟೆಲ್ಲ ಸಿಗ್ಬೇಕು ನಿಮ್ಗೆ ಡೀಟೇಲ್ಸ್ ಬಗ್ಗೆ ಅಂದ್ರೆ
ಅವರು
can secure the medical certificate.
See, my lord, there was a partition in respect of one item property.
You can get their medical certificate.
Yes.
You can also get other
documents. No, medical certificate was produced before the land tribunal by the advocate of Pushpalata Adyantaya. We got the certificate. Now, my lord, it clearly says, your lordship, can you see, if your lordship 25, my lord.
What was the form number 7 filed? But
form number 7 filed by the father of the respondents.
When?
Father of the respondent. That is in the year 1974 itself.
So for the past 51 years, you would never participate.
No, my lord, because Pushpalata Adyantaya was contesting the matter. Now, kindly see, my lord, this Ramaya.
Since you trusted Pushpalata for 51 years, you will take the consequences of trusting Pushpalata.
There are two aspects in this matter, my lord. If Pushpalata Adyantaya is to succeed the matter, we have no difficulty at all, because we can file a suit for partition, because we are also the family members. In case if his respondent's application is allowed, my lord, then we have
to take the good and the bad. You can't just take the good.
Kindly see, property right is involved, my lord. Your lordship, kindly see.
Won't allow you to come in now after 51 years.
My lord, now we are the co-owners, my lord.
Maybe so. You
whatever the right,
you kept
your
for
lordship,
51 years. How many remands so far?
Pardon, my lord.
How many remands so far?
3 remands. 3 remands.
No, in none of the 3 cases.
No, none of the 3 cases we were not a party, for the reason that since Pushpalata Adyantaya was contesting matter. Now, my lord,
since you trusted Pushpalata
your lordship, she is not in a position to contest.
Don't
Therefore,
our husband will take care.
she was placed now, evidence illa anta heli agide. Yaru Pushpalata, kindly see the medical certificate. Page them, I will persuade your lordship, because property 20 total 15 acres is involved, my lord. We have got a equal share in the property. Page number 25 for a moment, my lord.
If you sleep over your rights for 51 years.
No, we have not slept, because if Pushpalata Adyantaya is to succeed, my lord, definitely we will get a right over the property in question by filing a document 25, page number 25.
I will not entertain this. Where is your application?
My lord, that we have filed the application, your lordship, can see. That is also a part of the record. Annexure B, my lord. Annexure B, page number 27. Yatish Adyantaya. My lord, his mother name was also mentioned in the 1940 document, my lord. This Yatish Adyantaya name was also mentioned in the 1940, not Yatish Adyantaya. His mother name was mentioned in the 1940 document.
ಫಾರ್ಮ್ ನಂಬರ್ 7 ಯಾರ ಹೆಸರು ತೋರಿಸಿದ್ರು?
Ramaya Shetty. Ramaya Shetty name was shown.
His name is also there in the settlement deed, my lord.
I have filed the copy of the form number 7 also. Ramaya Shetty is one of the beneficiary under the 1940 document.
Ramana Shetty and
Another Ramaya Shetty and Muttaya Shetty. Ramana Shetty and Muttaya Shetty. They are also the beneficiary, my lord. Your lordship can see page number 93 ಅಲ್ಲಿ. ಇಬ್ಬರನ್ನು ಓನರ್ ಅನ್ನು ಮಾತ್ರ ತೋರಿಸಿದ್ದಾರೆ. Even in form number 7, though much before the act came into force, my lord, we had a interest over the property in question.
So Pushpalata was not shown as the landlord there.
My lord, Pushpalata was the daughter of Dumakke. We are the daughter of second wife.
Form number 7.
ಇಲ್ಲ ತೋರಿಸಲಿಲ್ಲ.
It is shown as
ರಾಮಯ್ಯ ಎಂದು ಮಾತ್ರ ತೋರಿಸಿದ್ದಾರೆ, ನಮ್ದು ತೋರಿಸಲಿಲ್ಲ.
ರಾಮಯ್ಯ ಯಾರು?
ರಾಮಯ್ಯ ಒನ್ ಆಫ್ ದಿ ಬೆನಿಫಿಷಿಯರಿ, ಮೈ ಲಾರ್ಡ್. 9 ಜನರಿಗೆ ಆ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂಡರ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್. ಓನ್ಲಿ ರಾಮಯ್ಯಸ್ ನೇಮ್ ವಾಸ್ ಶೋನ್. ರೆಸ್ಟ್ ಆಫ್ ದಿ ಪರ್ಸನ್ಸ್ ನೇಮ್ ವಾಸ್ ಆಲ್ಸೋ ನಾಟ್ ಶೋನ್.
Then how did Pushpalata come on record?
Pushpalata, it appears, my lord, she filed an application for impleading.
You never filed an application?
No, we never filed an application so far. My lord, your lordship kindly see.
Our interest ಇತ್ತು, ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇರಲಿಲ್ಲ.
My lord, we were in Bombay, my lord. We were.
Stay in Bombay.
Your lordship kindly, since entire land has gone, my lord, for our evocation we went to Bombay. We were residing there. Therefore, since one of the family
want to take the benefit
now
of whatever
Pushpalata, she is not in a position to contest. If she is to contest, my lord, absolutely we would not have come on record at all.
She will take care, don't worry.
Now, annexure A, your lordship kindly see, which I have challenged before this honorable court. Annexure A, my lord. Early, I have produced the copy of the order sheet, my lord. Otherwise, I would not have persuaded your lordship kindly. Page number 25, my lord. Ink page number 25.
Yes.
Witness not present, given ample amount of time, but KPC submits medical certificate non-presentation of the witness. But since already many chances are given, opposite counsel oppose for the same. Pushpalata or Adyantaya evidence taken as nil. So her evidence is also taken as nil. Therefore, we filed an application, my lord. If Pushpalata Adyantaya medical certificate shows that they are not in a position to move.
Madam, I will direct the land tribunal to appoint a commissioner to examine Pushpalata at her house.
My lord, the matter is now for argument, and Pushpalata herself is.
I will reject their application for impleading, but since this is brought to my notice that she is bedridden, I will direct the land tribunal to appoint a commission to examine Pushpalata at her house.
Yes.
But if order goes wrong, my lord, we will. My application reject ಆಯ್ತು ಅಂತ ಹೇಳಿ. My lord, one submission I will make.
You are inviting a lot of adverse comments.
My lord, one submission. If our application is allowed, within a week, my lord, we will complete the evidence, complete our evidence. Within a week, I will undertake. ನಮ್ಮ ರೈಟಿಗೆ ತೊಂದರೆ ಆಗ್ತದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
ನಿಮ್ ತೊಂದರೆ ಆಗೋಗಿದೆ.
ಈಗ ಒಂದೇ ಎಕರೆ.
Pushpalata got and fought for 51 years.
Yes, yes.
You were silently watching from Bombay. Now suddenly
ಅವರು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳಿ, ಅದಕ್ಕೋಸ್ಕರ.
I will reject this writ petition, but since it is brought to my notice that Pushpalata is bedridden, I will direct the land tribunal to appoint a commissioner to examine her at her residence.
ಅವಾಗ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ,
ಏನಾಗಲ್ಲ. ಅವಾಗ your grievance that she will not contest the proceedings will be taken care of.
ಅಲ್ಲ ಅವ್ರು ಬರ್ತಾರಾ ಇಲ್ವಾ ನಮ್ಗೆ? ಅಲ್ಲ ಅವ್ರಿಗೆ ಹಾರ್ಡ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಇದೆ, ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್. Therefore I said, my lord,
ಮಾಡ್ತಾರೆ ಬಿಡಿ ಅವರು ಕೋರ್ಟ್ ಕಮಿಷನರ್.
ಪೇಜ್ ನಂಬರ್ 25 ತಾವು ನೋಡಿದ್ರೆ ಅಯ್ಯೇ ಅಲ್ಲ ಅವರು ಎವಿಡೆನ್ಸ್ ಕೊಡುವ ಪರಿಸ್ಥಿತಿಯಲ್ಲೂ ಇಲ್ಲ. Therefore I said, my lord, I may be permitted to read. ಒಂದೇ ನಿಮಿಷ, ನಾನು ಆ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ I will leave it to your lordship. Page number 25 of the memo. This is to certify that HR Adyantaya is under my treatment of Dr. Jairam for ischemic heart disease, diabetes, hypertension and imbalance for the last 17 years. I understand he is seeing him in his absence. My lord, it appears he has also
lost medical certificate of
25
Adyantaya
6/3/1925.
Pushpalata illi.
Pushpalata, his wife.
Correct. Pushpalata is healthy.
Pushpalata is aged about 89 years.
Correct, but our there is nothing to indicate.
This man was contesting the matter all through.
Correct. I'll direct Pushpalata to be examined at her house.
Yes.
Even according to she, there's nothing about, there's nothing wrong with her. She's capable of leading evidence, isn't it?
Like from the beginning, 74 onwards, this man was contesting me.
Today, Papa,
I don't know whether she is.
He's not the landlord, so therefore.
Allah, husband.
He's not the landlord, so that he is not a necessary witness. Pushpalata ಬಂದು ಹೇಳ್ತಿರ್ಬೋದು.
ಅಲ್ಲ ಇದಕ್ಕಿಂತ ಮೊದಲು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವರೆಗೆ ಇವರೇ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರು, ಹಸ್ಬೆಂಡ್ ನಾಟ್ ವೈಫ್, ಆಸ್ ಎ ಪವರ್ ಆಫ್ ಅಟರ್ನಿ ಮೈ ಲಾರ್ಡ್. She is an uneducated lady, therefore.
If we were to agree that they were the owners as well, my lord, in the settlement deed, the disputed survey numbers are not mentioned in the name of Kamala. Schedule B only one survey number.
No,
all the survey
it is
numbers
mentioned,
are
my
not-
lord.
In the settlement deed, the survey number is not.
No, it is mentioned. It is mentioned, my lord.
Chair, ನಿಮಿಷ ಅವ್ರು ಹೇಳಿ.
Page 89, my lord, of their petition.
Not 89.
Sir.
He said 3 survey numbers, no 43.
ಹೌದು, ಅಲ್ಲಿ 97ರಲ್ಲಿದೆ. Your lordship kindly see, my lord. 44, 285, 292. Item number 8ರಲ್ಲಿದೆ.
Madam, which page of the settlement deed?
97, typed copy. ತೊಂಬತ್ತರಲ್ಲಿ ಅದು
7, my lord. 285 and 292, those are the properties, and 44-1, those are the properties given to Kamala, second wife. If they have not produced a genealogy before the land tribunal as well, but if we were to agree.
No, genealogy was also given me.
No, in this settlement deed, this 43/2, 43/1 and 298, to whom is it given?
It 43, those are not mentioned, my lord. Those survey numbers are not mentioned. Those are given to Remand, my lord.
My lord, I may be permitted to read, my lord. I may be permitted to read.
Where is Ramana share?
Ramana, number 2, my lord. In
So under this settlement deed, you are not given, Kamala is not given any land.
Kamala has given land, my lord, but
land.
under Schedule B, there are 2 schedules in the settlement deed.
This particular survey number is not given to them.
Survey number is not.
ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ. My lord, page number 96, I may be permitted to read, my lord. Page number 96, my lord.
Last 4 lines, ಸದ್ರಿ ನನ್ನ ಎರಡನೇ ಹೆಂಡತಿ ಕಮಲಗೆ ಅವ್ರು ಜನಿಸಿದ ನನಗೆ ಜನಿಸಿದ ಮಕ್ಕಳಿಗೆ ಸಹ ಒಟ್ಟಿನಲ್ಲಿ ಅನುಭವಿಸುವ ಸರಿ ಬೆಳೆದಿದ್ರೆ ಸದ್ರಿ ಗೋಪಿಯೋ ಮೂರನೇ ವಂಶ ಅಕ್ಕನ ಗೃಹಸ್ಥರು ನಿರ್ಣಯಿಸುವಂತೆ ಅದಕ್ಕೆ ತಕ್ಕ ಪ್ರತಿಫಲ ಪಡೆದು ಸದ್ರಿ ನಂಬರ್ ನನ್ನ ಎರಡನೇ ಹೆಂಡತಿ ಕಮಲಗೆ ಅವಳದ ನನಗೆ ಜನಿಸಿದ ಮಕ್ಕಳಿಗೆ ಬಿಟ್ಟು ಕೊಡತಕ್ಕದ್ದು. ಸದ್ರಿ ಕಮಲಗೆ ಅವಳದಲ್ಲಿ ನನಗೆ ಜನಿಸಿದ ಮಕ್ಕಳಿಗೆ ಸದ್ರಿ ಬಿ ಆಸ್ತಿಯಲ್ಲಿ ಅವರಿಗಿರುವ ಮೂರನೇ ಅಂಶ ಸದ್ರಿ ಗೋಪಿಗೆ ಬಿಟ್ಟು ಕೊಡಬಹುದು. ಒಂದೇ ಸದ್ರಿ ಗೋಪಿಯು ಅಕ್ಕನು ಸದ್ರಿ ಕಮಲ ವಗೈರೆ ಪಡೆಯತಕ್ಕದ್ದು, ಇಲ್ಲವಾದರೆ ಸದ್ರಿ ಕಮಲ ವಗೈರೆ ಮೂರನೇ 2 ಅಂಶದ ಅಕ್ಕನು ಸದ್ರಿ ಗೋಪಿಗೆ ಕೊಡತಕ್ಕದ್ದು. ಬಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯ ವಿವರ ಮಂಗಳೂರು ಸಬ್ ಕ್ಷೇತ್ರದ ಮಂಗಳೂರು ತಾಲೂಕು ನಂಬರ್ 79ನೇ ಪದವು ಗ್ರಾಮದಲ್ಲಿ ಆಸ್ತಿ 44, 285, 292.
My lord.
43/1 and 298. You are not granted anything. Kamala is not granted anything.
My lord, ಪಾರಂಪರ್ಯ ಅನುಭವಿಸಿ ಬರಬೇಕು ಹೊರತು ಸದ್ರಿ ಬಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ಅಡವು, ವರಮಾನ, ದಾನ, ಮೂಲಗೇಣಿ, ವಾಯ್ದೆ ವಗೈರೆ ಯಾವ ವಿಧದಿಂದಲೂ ಪರಾಧೀನ ಮಾಡುವವರೆ ಅವರಿಗೆ ಹಕ್ಕಿರುವುದಿಲ್ಲ. ಇದಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಶೆಡ್ಯೂಲ್ ಎ, ಶೆಡ್ಯೂಲ್ ಬಿ, ಶೆಡ್ಯೂಲ್ ಬಿ 4 ಸರ್ವೆ ನಂಬರ್ಸ್.
ಅದೇ 44, 285, 292.
ಹೌದು.
43 ಇಲ್ಲ, 298 ಇಲ್ಲ.
ಅಲ್ಲ,
is right.
ಅಲ್ಲ, ಇದು ಫಾರ್ಮ್ ನಂಬರ್ 7, your lordship can see.
Forget about form number 7.
ಅಲ್ಲ, ಫಾರ್ಮ್ ನಂಬರ್ 7 ಅಲ್ಲಿ ಐಟಮ್ ಕ್ಲೇಮ್ ಮಾಡಿದ್ದಾರೆ.
You are claiming the settlement deed.
Under the settlement.
Kamala is your predecessor in title.
Pardon me.
You are claiming title through Kamala.
Kamala, yes.
Kamala, show me from the settlement deed that Kamala has got survey number 43.
Yes.
298.
I will show. I will show.
There is 44/1, 44/2, 44/3, 285, 292.
And 239 is the ಪದವು ಗ್ರಾಮದಲ್ಲಿ 1ನೇ ಆಸ್ತಿ. ಬಿ ಶೆಡ್ಯೂಲ್ ವಿವರ ಮಂಗಳೂರು ಸಬ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಸೇರಿದೆ. ಮಂಗಳೂರು 4 70ನೇ ಪದವಿನಲ್ಲಿ 1ನೇ ಆಸ್ತಿ. ಮೇಲೋಡ್ ಅಡವು ಮೇಲೋಡ್ ಇಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ. ಸದರಿ ಎ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ಅಡವು, ಕ್ರಯ, ವಾರ್, ದಾನ, ಮೂಲಗೇಣಿ, ವಾಯ್ದೆ ವಗೈರೆ.
ಅಲ್ಲ, ಬಟ್ ನಿಮ್ಗೆ ಕೊಟ್ಟರು ಬಿ ಶೆಡ್ಯೂಲ್. ಈ ಶೆಡ್ಯೂಲ್ ತೋರಿಸಿ ನಿಮ್ಗೆ ಏನ್ ಬಂದಿದೆ
ಒಂದು ನಿಮಿಷ. ಯಾವ ವಿಧದಿಂದಲೂ ಪರಾಧೀನ ಮಾಡುವವರು ಅವರಿಗೆ ಹಕ್ಕಿರುವುದಿಲ್ಲ. ಇದಕ್ಕೆ ವಿರೋಧವಾಗಿ ಅಥವಾ ಪರಾಧೀನಗಳು ಮಾಡಿದರೆ ಅವುಗಳು ಮಂಜೂರಾಗತಕ್ಕದ್ದಲ್ಲ, ಕೂಡಲೇ ರದ್ದಾಗತಕ್ಕದ್ದು. ನಂತರ ಸದ್ರಿ ಬಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯು ಹುಟ್ಟುವಳಿಯಲ್ಲಿ ಮೂಲಗಾರರಿಗೆ ಸಲ್ಲತಕ್ಕ ಮೂಲಗೇಣಿಯನ್ನು ಮೂಲಗಾರರಿಗೂ ಮುನ್ಸಿಪಲ್ ಟ್ಯಾಕ್ಸ್ ಅನ್ನು ಮುನ್ಸಿಪಾಲಿಟಿಗೆ ಸಹ ಕೊಡುತ್ತಾ ಬಾಕಿ ಉಳಿಯುವ ಹುಟ್ಟುವಳಿಯನ್ನು ಸದ್ರಿ ಎಂಟನೇ ಕಮಲ ಸದ್ರಿ ಮೈನರ್ ಮಕ್ಕಳು ಸದ್ರಿ ಕಮಲದಲ್ಲಿ ನನಗೆ ಇನ್ನು ಮುಂದೆ ಜನಿಸಬಹುದಾದ ಮಕ್ಕಳು ಸಹ ಮೇಲೆ ಹೇಳಿದಂತೆ ಅವರ ಸಂತತಿ ಪಾರಂಪರ್ಯ ಅನುಭವಿಸಿಕೊಂಡು ಬರಬೇಕು. ಹೊರತು ಸದ್ರಿ ಬಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ಅಡವು ವಾರ್ ಟ್ರಾನ್ಸ್ಫರ್ ವಾರ್ ಮೂಲಗೇಣಿ ಕಾಯ್ದೆಗೆ ಯಾವ ವಿಧದಿಂದಲೂ ಪರಾಧೀನ ಮಾಡುವವರು ಅವರಿಗೆ ಹಕ್ಕಿರುವುದಿಲ್ಲ. ಮೆಲೋಡ್, ವಾಟ್ ಈಸ್ ಎಸ್ ಮೆಲೋಡ್? ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಯನ್ನ we have no right to alienate the property at all.
Are granted only 1/3 share or 2/3 share in B schedule property. In B schedule, none of the survey numbers in which this Pushpalata is making a claim is being considered, is being granted to your Kamla. Kamla kottella 43 na.
ಕೊಟ್ಟಿದ್ದಾರೆ. I will point out, my lord, your lordship kindly pass over. ನಾನು I will point out.
In page 94, my lord.
94.
Sixteenth line.
ಎಂಟನೇ ಕಮಲದಲ್ಲಿ
16th line, my lord. Number 8 is Kamala, my lord. Number 2 is Ramanna Shetty.
ಎ ಶೆಡ್ಯೂಲ್ನ ಹಕ್ಕು 1ರಿಂದ 7ನೇವರೆಗೂ ಮತ್ತು ಬಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯು 8ನೇವರೆಗೂ. ಮೇಲಡ್, ಐ ಆಮ್ ದಿ 8th. ಬಿ ಶೆಡ್ಯೂಲ್ 8th 8ನೇವರೆಗೂ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಗಾಟ್ ಇಟ್, ಮೇಲಡ್. ಈ ಕೆಳಗೆ ತೋರುವ ಎ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯ ಹಕ್ಕಿನು 1ರಿಂದ 7ನೇವರೆಗೂ. 1ರಿಂದ 7 ಅಂತ ಹೇಳಿದ್ರೆ ಮೇಲಡ್, 1ರಿಂದ 7 ಅಂತ ಹೇಳಿದ್ರೆ
ನಿಮ್ಗಂತ ಕೊಟ್ಟಿಲ್ಲ.
ನಾವು 8ನೇವರು.
ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಇದೆ. I will point out, my lord. I will point out. ಎ ಶೆಡ್ಯೂಲ್ನ ಆಸ್ತಿ ಪೈಕಿ 2ನೇ ಆಸ್ತಿ 231A ಪುಂಜ ಎಕರೆ 160 ಲಾಗಾಯ್ತು. ನಿಯಮ ನನಗಿರುವ ಪ್ರೀತಿಯ ಸುಣಿಸು. ಬಿ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ತೋರುವ ಮೂಲಗೇಣಿ 1ರಷ್ಟು ಸ್ವಂತ ಸಂಪಾದನೆ ಆಗಿರ್ತದೆ. ನೀವು ನನ್ನನ್ನು ಹೊಂದಿಕೊಂಡಿರುವುದಿಲ್ಲ.
ಬಟ್ರೆ ಕೆಳಗೆ ತೋರಿಸುವ ಎ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯು ಹಕ್ಕಂದು 1ರಿಂದ 7ನೇವರೆಗೂ.
1ರಿಂದ 7
ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿ ಹಕ್ಕನ್ನು 8ನೇವರೆಗೂ.
ಹೌದು, ನಾನು 8ನೇವಳು.
8ನೇವರು ಬಿ ಶೆಡ್ಯೂಲ್. ಬಿ ಶೆಡ್ಯೂಲ್ ನಿಮ್ದು ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ, 1ರಿಂದ 7ನೇವರೆಗೂ ಮತ್ತು ಬಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿ ಹಕ್ಕನ್ನು 8ನೇವರೆಗೂ.
ನಾವು ಕಮ್ ಬ್ಯಾಕ್ ಟು ಬಿ ಶೆಡ್ಯೂಲ್. ಬಿ ಶೆಡ್ಯೂಲ್ ಇಸ್ 44/1, 2, 3, 285 and 292.
ಹೌದು.
They are not a part of the form number 7 that you rely upon.
ಅಲ್ಲ, ಅಲ್ಲಿ ಅದೇ ಫಾರ್ಮ್ ನಂಬರ್ 7 ತಾವು ನೋಡಿ
ಸ್ವಲ್ಪ ನೋಡಿದೆ. ಅದರಲ್ಲಿ 44 ಇಲ್ಲ, 285 ಇಲ್ಲ, 292 ಇಲ್ಲ.
ಅಲ್ಲ, 292 ಇದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ,
ಇದೆ. ಲಾಸ್ಟಿಗೆ ನೋಡಿ, ಲಾಸ್ಟಿಗೆ 3 ಎಕರೆ 57 ಸೆಂಟ್ಸ್ ಅದು ಸೀಲ್ ಬಿದ್ದಿದೆ. 292
part 2 ಇದೆ. ಇದು 292
ಅಷ್ಟೇ.
292 ಮತ್ತೆ 44. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ
say, but you can't get up now.
ಅಲ್ಲ, 44 ಅಲ್ಲಿ ಇದೆ.
If I accept this settlement deed also, how many years ago this was?
1940.
So for almost how many years? 82 years you are sleeping.
ಅಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ನಮ್ಮ ಹತ್ರ ಇದೆ.
Protect your interest by saying Pushpalata will be examined through a court commissioner. An application for impleading has been rejected.
ಅಲ್ಲ, ನಾನು may request, my lord, this application could be considered by the tribunal, my lord. ತಾವು ಎಲ್ಲೋ ಮಾಡಿದ್ರೆ 2 ವಾರದಲ್ಲಿ ನನ್ನ ಎವಿಡೆನ್ಸ್ ಮುಗಿಸ್ತೇನೆ.
The application was filed by the petitioners. Where's the application?
My lord, annexure B.
Annexure B na.
ಹೌದು. annexure B, page number 27. ಆಮೇಲೆ recalling application ಹಾಕಿದ್ದೀನಿ.
It is not in dispute that a form number 7 was filed
one
by
Supreme Court judgment. May I cite, my lord?
Leo Crasta, back in the year 1974.
May I cite?
In which
Supreme Court
in which several survey numbers were claimed and the rest of the lands in question. Crasta contended that Ramana Guruva Shetty, Muttaya Shetty, Muttaya and Ramana Shetty were the landlords. In these proceedings, Pushpalata or Adyantaya
Pushpalata are Adyantaya.
impleaded, and she was a party to the proceedings in which the land tribunal had conferred occupants' rights on 3 occasions, and the matter was remanded to the land tribunal on 3 occasions. In fact, Pushpalata had carried up the matter right up to the Supreme Court in civil appeal number 3928/2017.
As against the remand mail.
It was therefore clear that all along from 1974, it is only Srimati Pushpalata or Adyantaya who was contesting the application filed by the tenant. Next para. However, in the year 2025, in the month of November 2024, an application has been filed by the present petitioners seeking to implead themselves in the proceedings. In the affidavit filed in support of the said application, it is stated as follows, page 29. Thus, after nearly a period of 50 years, the petitioners approached the tribunal requesting the tribunal to implead them as co-owners and that they had an undivided right over the scheduled property. This application has been rejected by the tribunal on the ground that no documents were produced.
It is also incorrect.
Consequently, an application was filed to recall the said order.
Yes.
By producing certain documents, but the tribunal has taken the view that it has no jurisdiction to recall an order that it has passed, and thereafter it has posted the matter for arguments. Shri O. Shivram Bhatt, Learned Counsel, opinion of the petitioner submits that there were ample documents to indicate that the petitioners were the children of Kamala, the second wife of Subhash Shetty, and they had an interest in the property. He submits that Pushpalata or Adyantaya was the granddaughter of the first wife, and since she was prosecuting the matter, the petitioners had not taken the initiative to get themselves impleaded. Next, in my view, this argument of the petitioners cannot be accepted. If the petitioners, though claim to have a right in the property, did not choose to implead themselves like Pushpalata did 50 years ago, they cannot approach the tribunal 50 years after the application was filed to contend that they have an undivided interest. It is clear from the proceedings that throughout the proceedings from 1974, which resulted in orders being passed with the tenant on 3 occasions and the matter being remanded on 3 occasions back to the tribunal, the petitioners chose not to participate. They cannot therefore be permitted to come on record at this stage to contend that they have right in the property. The order of the land tribunal is therefore just and proper and does not call for any interference. Next, however, Shri Bhatt, Learned Counsel, submits that Pushpalata Adyantaya's husband was prosecuting the matter on her behalf, and he has been bedridden, and therefore the matter cannot be prosecuted effectively. In the light of this submission, though the land tribunal has noticed that there is no evidence adduced on behalf of Pushpalata, in my view, interest of justice will be served by directing the land tribunal to appoint a court commissioner to examine Pushpalata Adyantaya at her residence, given the fact that she is 90 years old, and take her version of the story before it considers the matter on merits. Subject to the above, the writ petition is dismissed.
Lord, if order goes against me, liberty maybe.
Why should I?
At least I could challenge, my lord. Otherwise, proper. It is not a small acre, my lord. 15 acres of land, Punja land, not a cultivable land at all. ಅಲ್ಲ ನಮಗೂ ಅವರಿಗೆ 25 ಎಕರೆ ಸಿಕ್ಕಿದೆ, ನಮಗೆ 1 ಎಕರೆ 2 ಎಕರೆ ಬರ್ಲಿ ಸ್ವಾಮಿ ಲ್ಯಾಂಡ್. ಬೇರೆ ಏನಿಲ್ಲ, ಅದೊಂದೇ ನಮಗೆ ಸೋರ್ಸ್ ಆಫ್ ಇನ್ಕಮ್. ಎಲ್ಲ ರಿಟೈರ್ಡ್ ನಾವು ಇವಾಗ.
Dispose, my lord, the order, my lord, it is at annexure M, ತಿಳುವಳಿಕೆ ಪತ್ರ. Let the petitioner may treat this as a notice, my lord, let him give reply.
Treat the show cause notice, failure objections.
Please, we will pass order.
The petition is aggrieved by the notice dated 3/4/2025, whereby the petitioner has been called upon to remove the shed and the structure that he has erected
The government land.
on or before 4th of April 2025, failing which action will be taken to demolish the same. In my view, since it is noticed that the impugned notice was not preceded by a show cause notice, nor was any inquiry conducted, it would be appropriate to read the impugned order as a show cause notice and permit the petitioner to file objections to the said show cause notice within a period of 2 weeks from today.
My lords, 4 weeks, my lords. Our
Such objections being filed, the Tahsildar shall consider the same, hear the petitioners and then pass an appropriate order. Writ petition accordingly disposed of.
My lords, until then, no precipitative actions.
See, that is quashed. How can they do anything?
My lords, can I request for 4 weeks, my lords?
Writ petition on ದಿವಸದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ and objections ಆಗೋದಕ್ಕೆ 4 weeks ಕೇಳ್ತಾರೆ.
Correct. He's got a point. Please file it.
At least 3 weeks, my lords, because there's
File 2 weeks.
Shri Prakash.
My lord, there is an application for early hearing. My lord, the writ petition is filed by, my lord, the tenant, aggrieved by, my lord, the order of the land tribunal, my lord, rejecting his claim. My lord, in respect of survey number.
Time back.
My lord,
time back.
My lord, I will argue, my lord, if the other side is ready. My lord, last time also I took time, my lord, because of some personal inconvenience.
The other side is ready if you are ready.
Yes, my lord, I argue, my lord.
How ready are you ready than the
Yes, my lord, I will. I go on.
Yes.
My lord, the third respondent, my lord, is the owner of, my lord, land comprised in survey number 18 of, my lord, Govindapura village, 18 and also 19. My lord, the petitioner.
Annexure M.
Annexure
M is the impugned order.
Yes, my lord. Annexure M is impugned order. My lord, that is, my lord, for the third time this order is came to be passed. I will bring to my lord's notice.
Please read from page 72.
72. Yes, my lord.
Page 72 in the Avadi.
72 no. Yes. Yes. ಮೇಲಿನ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಅರ್ಜಿದಾರರಾದ ಪೊನ್ನುಸ್ವಾಮಿ ಬಿನ್ ರಾಯಪ್ಪ ಇವರು ಹೇಳಿರುವಂತೆ ಗೋವಿಂದಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 18ಕ್ಕೆ ನಮೂನೆ 7ರಲ್ಲಿ 4 ಎಕರೆ 7 ಗುಂಟೆ ನಮೂದು ಮಾಡಿದ್ದು ಸರಿ ಇರ್ತದೆ. ಆದರೆ ಇದೇ ಅರ್ಜಿದಾರ ದಿನಾಂಕ 9/9/76ರಂದು ಸಮಿತಿಗೆ ಮುಂದೆ ಹಿಂದೆ ನನಗೂ ಪ್ರತಿವಾದಿಗಳಿಗೂ ವ್ಯಾಜ್ಯ ಇದ್ದಿದ್ದರಿಂದ ದಿನಾಂಕ 27/8/76ರಲ್ಲಿ ಪೂರಾ ಜಮೀನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದೇನೆಂದು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೆ. ನಾನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ಗೋವಿಂದಾಪುರ ಗ್ರಾಮ ಸರ್ವೆ 18ರಲ್ಲಿ 1 ಎಕರೆ ಮಾತ್ರ, ಅಷ್ಟು ಮಾತ್ರ ನಡೆಸಿ ಖಾತೆ ಮಾಡಿಕೊಂಡು ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ ಎಂದು ಹೇಳಿಕೆ ನೀಡಿ ತಾವೇ ಸಹಿ ಹಾಕಿರೋದು ಕಂಡು ಬರುತ್ತದೆ. My lord, this is third time. Second, my lord, only on this ground. My lord, where is that statement? It was not even confronted to me. My lord, my grievance is this on this ground from 77. My lord, twice, my lord, the matter was remanded. I never made statement is my case. My lord, this is the only ground on which, my lord, my claim for 4 acres 7 guntas is reduced to 1 acre 12 guntas.
So RTC ನಿಮ್ಮ ಹೆಸರಿಲ್ಲ
ಇದೆ ಅಲ್ಲ. My lord, I have page 22. My lord, I have got a entry, my lord, in respect of survey number 18, but page 22 typed copy is at page 23.
Survey number 19 you don't have.
No, I don't.
Survey number 19 you don't have.
No, my lord, survey number 19 I don't have, my lord, entries in RTC, but I have adduced, my lord, the oral evidence of neighbors. And my lord, there is no suggestion that those witnesses are interested at.
No, but no, but you had made this statement on 9/9/76 for the land tribunal itself.
No, that is, my lord, what they say. My lord, I kindly see the order, but annexure C, page 27. My lord, they have not followed rule 17. That is my case. While recording evidence, my lord, they have to follow rule 17 of Karnataka land reforms rules. It should be recorded.
What was the statement that you gave?
Well, that is, according to me, I never said, made any such statement is my case. My lord, therefore, this honorable court, annexure C, my lord, Lordship kindly say, there are 2 orders of this honorable court.
Let me look at the statement first.
No, that is not, my lord, my statement. That is what I said. My lord, this has to be read after reading, my lord, the two orders of this honorable court.
ಇದರಲ್ಲೂ ಕರೆಕ್ಟ್ ಮಂಜೂರು ಮಾಡಬಹುದೆಂದು ಕೊಟ್ಟಿದ್ದಾರೆ. ತನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿರೋ ಕೇವಲ ಒಂದು ಎಕರೆ ಮಾತ್ರ ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿ ನಿಜವಲ್ಲ. ಇದು ಹೇಳ್ತಾರಲ್ಲ, ನಿಜವಲ್ಲ ಅಂದ್ರೆ ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ನಾನು ಇದ್ದೀನಿ ಅಂತಾನೆ. 19 ದೇವನ they are disputing 18. 39 ಗುಂಟಸ್ ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿದೆ ಅಂತಾರೆ.
ಮೇಡಮ್ 76 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಾ ಇಲ್ಲಿ?
76 ಸ್ಟೇಟ್ಮೆಂಟ್
Lord, if there were to be any such statement, it should have been confronted to me, my lord, when I was examined, my lord, thereafter, to remand. My lord, this honorable court said, my lord, the recording of evidence is contrary to Rule 17, Para 6 of Annexure C. This is the order passed by this honorable court, my lord, in the writ petition filed by me as well as third respondent. My lord, there were two writ petitions earlier, my lord, and this honorable court said the both parties are permitted to, my lord, adduce further evidence. I have thereafter, my lord, adduced evidence. My lord, 76 and 77, my lord, advocates were not allowed to appear for parties. Your lordship knows, my lord, after 1987, my lord, judgment of the Supreme Court, the parties, the advocates are allowed to appear.
Mr. Prakash.
Yes, my lord.
It was the applicant record for further examination in chief, and this is what he says. ಹಿಂದೆ ನನಗೂ ಪ್ರತಿವಾದಿಯವರಿಗೆ ವ್ಯಾಜ್ಯ ಇದ್ದಿದ್ದರಿಂದ ತಾರೀಖು 27/8/76 ಪೂರಾ ಜಮೀನನ್ನು ಸಾಗು ಮಾಡುತ್ತಿರುತ್ತೇನೆ ಎಂದು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೆ. ನಾನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು 1 ಎಕರೆ 20 ಗುಂಟೆ ಮಾತ್ರ. ಅದು ನನ್ನ ಮಾತ್ರ ನನಗೆ ಖಾತೆ ಮಾಡಿಕೊಡಬೇಕೆಂದು ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ. This is a statement made by you voluntarily before the land tribunal.
No, that's why, my lord, I said I have not made such statement. That is what I said. My lord, kindly see Annexure C, my lord. I have not made that statement. Well, it should be recorded by the chairman. That is what, my lord, Rule 17 says. This honorable court in the writ petition filed by me and the third respondent. Your lordship, kindly see Annexure C, page 27. Kindly see Para 6 of Annexure C, my lord.
Your signature is found in the statement.
My lord, signature, my lord, it is possible to say that it is my signature. My lord, in what manner such a statement was recorded is not, my lord, forthcoming. My lord, it should be recorded by chairman.
Have you seen the statement?
My lord, it is said that it is said by the land tribunal in the first order and in the second order and in the third order. There are 3 orders passed by the land tribunal. Kindly see, my lord, permit me to, my lord, read Para 6, my lord, of order of this honorable court at Annexure C, page 27. This is the writ petition I have filed, my lord, aggrieved by the order of the land tribunal, reducing the extent to 1 acre, my lord, 12 guntas.
Annexure?
Annexure C, page 27.
Yes.
Well, kindly see Para 6, my lord, at page 31, internal page 5. Perusal of the record shows that the land tribunal, my lord, in this order, first order itself, land tribunal said, I have made a concession. That is, I am in possession of only 1 acre 12 guntas. Kindly see Para 6. Perusal of the record shows that the land tribunal has not followed the procedure prescribed in Rule 17 of the Kerala also. It is also evident that land tribunal has not passed speaking order. Relevant materials that were available on record have not been considered. In my opinion, the matter requires. Allah. In the next Milord, para 7 Milord, para 7. Milord, in the light of this Milord, in the light of this finding that para
Rule
6,
17.
para 17 Milord, no, Rule 17 Milord. Rule 17, procedure to be followed by the tribunal. The tribunal shall, in respect of an application made to it, follows the same procedure as specified for a summary inquiry under Section 34 of the Land Revenue Act, subject to the condition that is not applicable. 2. Order sheet shall be maintained by the chairman in respect of on each case heard by the tribunal, noting in it the day-to-day proceedings tribunal relating the conduct of the case. In a meeting is that in a para 5. The opposite party shall be allowed to cross-examine the witness, and if it does not cross-examine, a note shall be made accordingly.
Then what is wrong? Which part of Rule 17 is not followed?
There must be a Milord. See, your lordship kindly say on the Milord, on the date according to them they made a statement. Milord, it should have been posted for the evidence, and there must be a note that Milord, I have my statement was recorded, and I have made a voluntary statement, and after the remand, Milord, that statement should have been confronted to me when I was examined, and parties are assisted.
Where is the question of confronting? It is a statement given by you to the statement. Where is the question of confronting it to you?
My lord, I have denied that statement before this honorable court. My lord,
where have you denied?
My lord, I have denied, even in this petition also I have denied to, my lord, say that, my lord, I am cultivating only 1 acre 12 guntas. My lord, RTC up to 84-85 shows that I am in possession of 4 acres 7 guntas. And what type of a dispute between us is nothing. My lord, he says the dispute is prior to 76. My lord, my application for under Form 7 is filed, my lord, on 22/12/1975 in respect of survey number, my lord, 18. My lord, another application I have made in respect of survey number 19. What type of a dispute, my lord, in the year 76? Why should I say that I am only in possession of only 1 acre 12 guntas?
You have given reasons. You have given reasons. You said there was a litigation between the two of you. Therefore,
there is no litigation except my claim for occupancy right. There can't be any other dispute.
You can't give a statement on oath and thereafter run away from it.
Oath, my lord, there is nothing to show that I was given oath and chairman has recorded it. My lord, Rule 17, my lord, chairman has to record his statement. And this court, my lord, has said that, my lord, inquiry was not conducted by following the procedures under Rule 17. And, my lord, next para, your lordship, 7 in the order of Annexure C.
Madam, first round the order sheet. First round the order sheet.
My lord, in this court, my lord, Annexure C, the matters are remitted back to the land tribunal for fresh disposal in accordance with law after due notice to all parties.
That does not, Prakash, that does not mean that your statements will go away.
No, my lord.
That does not mean that you can ignore your statements.
No, not my lord. If it can't be ignored, if there is a material to show that I have voluntarily made that statement, then
that is what is mentioned there. You affix your signature. You are given reasons as to why you made the earlier deposition and why you are going back.
No, lordship.
That is what is stated there.
No, my lord, Annexure C, my lord, Annexure C is the writ petition filed by me and the landlord against the order of the land tribunal, where, my lord, occupancy granted only 1 acre 12 guntas on the ground that I have made such statement. My lord, in spite of that, this honorable court at Annexure C, my lord, said that, my lord, tribunal has not followed the procedures contemplated under Rule 17 and therefore remanded the matter. If this honorable court
this court did not refer to any contention of yours that the statement was improperly recorded.
No. Yes, my lord, it has, my lord, it has, because I also filed writ petition. Tenant has made an application seeking grant of occupancy. Then this honorable court should have dismissed my writ petition. You should have dismissed my writ petition because
Please
I
read
have.
para 6 again. There are two grounds. Has
No,
not followed the
I have
procedure,
not-
neither has not passed speaking orders.
No, para 5. I have heard the learned counsel for the parties and perused the material placed on record means as the statement also. It can't be said that court has not considered this statement. Court said peruse the materials placed on record. Record means including my statement. Para 6. Perusal of the record shows the land tribunal has not followed the procedure prescribed in Rule 17 of the KLR rules. Therefore, my lord, in the light of this honorable, all contentions are kept open for the decisions of the land tribunal. Parties are at liberty to lead further evidence in support of their respective contentions. My lord, in spite of this, my lord, again, Annexure D, the land tribunal has passed the same order, verbatim the same. Then, my lord, I filed writ petition before Annexure E. My lord, second order of this honorable court. Your lordship kindly see Annexure E. Annexure E, my lord, page 36.
Yes.
Para 4, my lord, page 36. My lord, the second writ petition filed by the tenant. Annexure E. This was contested by my lord, the third respondent and his LRs. The lawyer was engaged. Lieutenant Counsel for submits that no inquiry has been held as contemplated. Para 2 at page running page 38, internal page 3. The Lieutenant Counsel.
Lord, his statement is being given. Order sheet ಇಲ್ಲ notices is there. Notice for the first installation.
Your lordship got it, my page running page 38, my lord. Yeah, annexure at Annexure E, my lord. The order of this honorable court. The Lieutenant Counsel for petitioner submits that no inquiry has been held as contemplated in Rule 17 of the Karnataka Land Reform. I have perused the impugned order as well as the order sheet which is made available. It appears the matter was listed on so and so. Thereafter, it was adjourned for recording the statements of all the parties. However, no statements were recorded and the matter was eventually concluded on 12/7/2000. The Counsel for submits that the statements indeed were not recorded. The submission placed on record.
The RTC indicates the entire extent is shown as a tenanted land, isn't it?
Yes, yes, yes.
No, my lord. In Kabjadara, sir, my lord, kindly peruse, my lord.
Annexure A.
And annexure.
72, 73, Ponuswamy, Guttige. 73, 74, Guttige. The entire extent of 4 acres, 18 guntas.
Like in column number 9 of the RTC, kindly peruse, my lord. A.M. Vishweshwara Murthy.
Correct.
Land
ಅದು ಓನರ್ ಎಷ್ಟು ಅಲ್ಲ ಕೆಳಗಡೆ ಬನ್ನಿ ಟೆನೆಂಟ್ ನಾವು ನೋಡ್ಬೇಕಿರೋದು ಎರಡು ಕಡೆ ಗುತ್ತಿಗೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
But no document has been produced before.
This is the best document, isn't it?
No, my lord, kindly peruse 2 acres 18 guntas is there.
ಎಲ್ಲಿದೆ 2 acres 18 guntas?
Column
ಎರಡು
number.
ಸೇರಿ ತರಿ ಭತ್ತ 2 ಎಕರೆ ಒಟ್ಟು 4 ಎಕರೆ 18 ಗುಂಟೆ. 72, 73, 74. Then even for 84, 85 it is shown as 4 acres. RTC is not considered by the tribunal.
No, even in the cross examination of the PW1, my lord, tenant has admitted that he is not in possession also.
ಇದೇ ತರ 76 ಸ್ಟೇಟ್ಮೆಂಟ್ ನೀವು ಹೇಳ್ತಿರೋದು.
Yes, please.
ಇದಕ್ಕೇನು ಉತ್ತರ?
ಇದಕ್ಕೆ my lord, that is only revenue records.
Order sheet ಸಿಕ್ತಾ ಮೇಡಮ್ ಫಸ್ಟ್?
Notice ಇದೆ ಪೊನ್ನಸ್ವಾಮಿಗೆ order sheet they are not noted. ಪೊನ್ನಸ್ವಾಮಿಗೆ notice should 1 acre 18.
ಏನ್ ಮೇಡಮ್ ಇದು?
Notice issued to the applicant, my lord. 1 acre 18 gunta in survey number 18. 1 acre 20 guntas.
This is after the order, alva?
Order sheet is not there.
ಇದೇನೋ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಪ್ರಕಾಶ್ ಇದು.
ಇಲ್ಲ,
Both of you reconciled and the landlord has also given a statement. ಮುಂಚೆ ನಾನು ಏನೋ ಮನಸ್ತಾಪ ಇದರಿಂದ ಹೇಳಿದ್ದು, ಈಗ ಹೇಳ್ತಾ ಇದೀನಿ 1 ಎಕರೆ 20 ಗುಂಟೆನೆ ಅಂತ. ಇವರು ಒಪ್ಕೊಳ್ತಾರೆ, ಇಬ್ರು ರಾಜಿ ಮಾಡ್ಕೊಡ್ರಿ ನೀವು ಅಲ್ಲಿ.
No, that should have been stated. The landlord has not entered.
You will have to accept your statement at least. Forget about this statement.
No. I never admitted. Kindly see page 46.
Have you seen the further statement of your client?
Yes, my lord. Further statement, my lord.
What have you said?
45, page 45, my lord. Page 45. In a writ petition.
On 9976.
9976. No, that is not. I have.
On 9976.
I have not, my lord. I have not seen.
Well,
I have not seen. That is not.
You also agree?
No, I have not seen that, my lord.
I have the original records. Both of you had settled the matter. Don't raise a dispute again.
No, my lord. It is not. No.
He also agreed 1 acre 20 guntas. You also agreed 1 acre 20 guntas.
My lord, the landlord never said that, my lord, by entering witness box to say that there was settlement. Therefore, my lord, tenant has. That's why, my lord, I invited my lord's consideration to page.
So you don't want to read?
No, my lord.
No, Prakash, read the further statement of your client.
My lord,
read the statement of the landlord and the statement of your client.
My lord, 76, my lord, the lawyers were not allowed to appear for parties, my lord. Thereafter, my lord,
you can get over the admission.
No, there is no admission.
So you can get over the admission.
No, my lord, this will be, my lord, I read page 45. My lord, this will clear the doubt, my lord, in the mind of the honorable court. Page 45. My lord, I have examined after this court, my lord, permitted me to give further evidence. My lord, as per
even if the order of the order of land tribunal is set aside, the statements given by both of you on oath would remain.
No.
Both of you consistently say.
My lord, it is not page 45, my lord. Page 45.
Yes.
Page 45. This is, my lord, my further statement on 2/7/2012. ಸರ್ವೆ ನಂಬರ್ 18 4 ಎಕರೆ 18 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 19 2 ಎಕರೆ 31 ಗುಂಟೆ ಸಾಗುವಳಿ ಮಾಡುತ್ತಾ ಇದ್ದೇನೆ. ಈ ಜಮೀನುಗಳನ್ನು ಉಮಾಪತಿ ಎಂದರೆ ಒಂದೇ ಪತಿ ಗುತ್ತಿಗೆ ನೀಡಿದ್ದಾರೆ. ನಾವು 40 ವರ್ಷಗಳ ಸಾಗುವಳಿ ಮಾಡುತ್ತಾ ಇದ್ದೇವೆ. ಗುತ್ತಿಯಾಗಿ 8 ಬಲ್ಲ ಭತ್ತವನ್ನು ನೀಡುತ್ತಿದ್ದೆವು. ಕಾನೂನು ಬರುವವರಿಗೆ ಗುತ್ತಿಗೆ ನೀಡಿದ್ದೇವೆ. ಸರ್ವೆ ನಂಬರ್ 19ರಲ್ಲಿ 35 ಗುಂಟೆ ಮಾತ್ರ ಮಂಜೂರಾಗಿದೆ. ಉಳಿಕೆ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 21ರಲ್ಲಿದೆ ಎಂದು ತಿರಸ್ಕೃತವಾಗಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 18 1 ಎಕರೆ 70 ಗುಂಟೆ ಮಾತ್ರ ಮಂಜೂರಾಗಿದೆ. ಅದರಲ್ಲಿ 4 ಎಕರೆ ಜಮೀನು ಈಗಲೂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಾ ಇದ್ದೇನೆ. ಪ್ರತಿವಾದಿಯಾಗಲಿ ಅವರ ಕುಟುಂಬದವರಾಗಲಿ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡಿಲ್ಲ. ಈಗಲೂ ಅವರಿರುವ ಜಮೀನನ್ನು ಬೀಳು ಬಿಟ್ಟಿದ್ದಾರೆ. ಜಿಲ್ಲಾಧಿಕಾರಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಹಾಜರುಪಡಿಸಿ ನನ್ನ ಜಮೀನು ಸಂಬಂಧ ಪ್ರಾರ್ಥನೆಯನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ಈಗಲೂ ಎಲ್ಲಾ ಜಮೀನು ನಾನೇ ಸಾಗುವಳಿ ಮಾಡುತ್ತಾ ಇದ್ದೇನೆ. ಮೊದಲು ಕಬ್ಬು ಭತ್ತ ಬೆಳೆಯುತ್ತಿದ್ದು, ಈಗ ಮೆಕ್ಕೆಜೋಳ ಬೆಳೆಯುತ್ತಿದ್ದೇವೆ. This is what my statement. Kindly
you have never said in this subsequent statement that the first statement given by you was false.
No, it was not, my lord. I was tendered myself to their cross-examination. An advocate appearing for the landlord has cross-examined me. They kindly see, my lord, 17/9/2012 cross-examination. If the landlord have suggested, my lord, and I understand, my lord, my party is an illiterate person. Merely because the statement is recorded, it doesn't mean that. Kindly permit me to read, my lord. I will not read the whole thing. My lord, kindly see page 46. ಸರ್ವೆ ನಂಬರ್ 18-19 ಜಮೀನಿಗೆ ಅರ್ಜಿ ಹಾಕಿದ್ದೇನೆ. ಈ ಅರ್ಜಿ ಹಾಕುವ ಮುಂಚೆ ಒಂದು ಅರ್ಜಿ ಹಾಕಿದ್ದು 1 ಎಕರೆ 20 ಗುಂಟೆ ಭೂಸ್ವಾಧೀನ ಕಾನೂನಿನಡಿ ಮಂಜೂರಾಗಿದೆ. 18ರಲ್ಲಿ 4 ಎಕರೆ 18 ಗುಂಟೆ ಇದೆ. ಈ ಹಿಂದೆ ಸರ್ವೆ 19 ಸೇರಿಸಿಲ್ಲ. Milord, he made a separate application for survey number 19. Milord, there are no records. I am not troubling your lordship, Milord, against the order of the land tribunal rejecting my application survey number 19. Milord, he says about, my lord, separate application made in respect of survey number 19, for which, my lord, there is only oral evidence, no documentary evidence. My lord, kindly now come to page 47. ಗೋವಿಂದಪುರದ ಸರ್ವೆ ನಂಬರ್ 18ಗೆ ಸಂಬಂಧಿಸಿದ ವಿಚಾರಣೆ ಆಗಿ ಸ್ಥಳ ತನಿಖೆ ಆಗಿ ಆದೇಶ ಮಾಡಿದ್ದಾರೆ. ಆಗ 1 ಎಕರೆ ಮಂಜೂರಾಗಿರ್ತದೆ. ಉಳಿದ 3 ಎಕರೆಗೆ ನನ್ನ ಅರ್ಜಿ ಮೋಸದಿಂದ ವಜಾ ಆಗಿರ್ತದೆ. ಸರ್ವೆ 18ರ ಉಳಿಕೆ ಜಮೀನು 2ನೇ ಬಾರಿ ಅರ್ಜಿ ಹಾಕಿದ್ದೇನೆ. ಅದು 238 ಎಕರೆ ಆಗಿದೆ. ನನಗೆ ಮೋಸವಾದ ಮೇಲೆ ಪುನಃ ಅರ್ಜಿ ಹಾಕಿರುತ್ತೇನೆ. ಸರ್ವೆ ನಂಬರ್ 18 1966 ಸಾಗುವಳಿ ಮಾಡ್ತಾ ಇದ್ದೇನೆ. ದಿನಾಂಕ ಗೊತ್ತಿಲ್ಲ. ನನಗೂ ಜಮೀನು ಮಾಲೀಕರು ಯಾವುದೇ ಬರವಣಿಗೆ ಆಗಿರುವುದಿಲ್ಲ. ನಾನು ಸರ್ವೆ ನಂಬರ್ 19 ಎಂದು ಸರಿಯಾದ ಸರ್ವೆ ತಿಳಿಯದೆ ಸರ್ವೆ 19 ನಮೂದಿಸಲಿಲ್ಲ. ಈ ಜಮೀನು ಯಾವ ಆಧಾರದ ಮೇಲೆ ಮಾಡ್ತಾ ಇದ್ದೇನೆ, ನನ್ನಲ್ಲಿ ಯಾವುದೇ ದಾಖಲಾತಿ ಇಲ್ಲ. 18ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಮಂಜೂರು ಮಾಡಬಹುದೆಂದು ಮಾಲೀಕರು ಒಪ್ಪಿಗೆ ಕೊಟ್ಟಿದ್ದರು. Milord, why there is no suggestion? Why there was a settlement? Nothing is said. ಸರ್ವೆ ನಂಬರ್ 18ರಲ್ಲಿ 4 ಎಕರೆ 3 ಎಕರೆ ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿದೆ, ಕೇವಲ 1 ಎಕರೆ ಇಪ್ಪತ್ತು ಮಾತ್ರ ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿದೆ ಎಂಬುದು ನಿಜವಲ್ಲ. Milord, it is a cross examination, my cross examination. Then they should have suggested to me that there was a settlement pursuant to which, my lord, I agreed to accept the occupancy rate only 1 acre 20 guntas. That they should have been suggested by the landlord. My lord, I was cross-examined by the landlord's counsel. He should have said.
Prakash, you have not resiled from the statement that you gave earlier.
No, my lord.
Second statement does not disown the statement given by you earlier.
No, my lord.
Yes.
My lord, let us take that, my lord. Then landlord should have said what was that, my lord, settlement between them when that settlement was arrived at. Nothing is.
I'll consider. Mr. Alva.
My lord, I have to argue further, my lord. I may require another 10 minutes, my lord.
Lords, my apologies, my lords. Serial number 2, your lordships have passed it over. It's 2:30, there is some inquiries. Can I argue this matter tomorrow morning, my lords? In the first hour itself, I'll come. Serial number 2. So grateful, my lords.
Serial number 64, my lord. The council on the record is there.
My lord.
Serial number 7.
60. No, I want to, my lord, bring to your lordship notice, my lord, 2 more documents and I close, my lord. 2:30.
My lord. The council on the record is not in place. Family will be temple. 54, my lord. Certain in 2 days.
We have received the records, my lord.
2 days.
For the respondent. Please wait. Please let him come.
71.
Kindly extend the interim order.
Well, my lord's kind leave, my lord.
Serial number 7, my lord.
Seal number
7.
7. ಅಡ್ಜರ್ನ್ ಆಗಿದೆ.
Interim order extend ಮಾಡ್ತೀನಿ.
71 ನಲ್ಲಿ ಅದು ಸ್ವಲ್ಪ ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಳಕ್ ಹೇಳಿದ್ರಿ, ಅದು ತಗೊಂಡಿದೀವಿ. ಅದೊಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲೇ ಇದ್ದಾರೆ.
ಸೀಲ್ ನಂಬರ್
71.
ನೀವಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
ಅದು ಸೂರ್ಯ ಅಂತ ನಮ್ಮ ಕೊಲೀಗ್.
ರಿಕೆಟಿಂಗ್ ಸ್ಟಾಕ್ ಇದ್ದಾರೆ, ಅವ್ರು ಇಲ್ಲಿದೆ.
ಅವ್ರು ಅದು ಹೇಳಿದೀನಿ.
Yes, my lord, they want some time to file.
ಲಿಸ್ಟ್
ಇಂಟ್ರಿ ಮಾಡ್ರಿ.
My lord, my lord. Sorry, my lord, ಆಯ್ತಲ್ಲ. What up, sir?
Sir, reserve, sir.
Reserve. 2 ನಿಮಿಷ ಹೇಳೋದಿದೆ ಅಂದೆ. ಇದು.
ಈಗ ಹೇಳಿ ಸರ್, ಈಗ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
ಯಾವ ಈಗಲ?
Sir, ಬಂದ್ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿ ನೋಡೋಣ.
ಈಗ ಮಾಡಿ ನಾವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀವಿ.
2:30.
ಪ್ರಕಾಶ್ ಸರ್.
ಹಾ.
ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸರ್ ಅಂದ್ವಿ.
ಹಾ, ನೀವು ಕೂತ್ಕೊಳ್ಳಿ ಮೇಲೆ. ನೀವು ಎಲ್ಲಿ ಹೇರ್ ಮಾಡ್ತಾರೆ ಕೂತ್ಕೊಳ್ಳಿ.
2:30 ಬಂದ್ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್.
ನೀವು ಕೋರ್ಟ್ಗೆ ಬರ್ಬೇಕಲ್ಲ ಸರ್. ಹೌದು. ಎಲ್ಲಿಂದ ಸರ್?
ಜಿಲ್ಲಾ ಪರಿಷತ್
ಹಾಸನ್ ಡಿಸಿ ಏನಲ್ಲ ಸರ್ ಅದು? ಸೈಟ್ಸ್ ಅಲ್ವಾ? ಸೈಟ್ಸ್ ಎಕ್ಸ್ ಸರ್ವಿಸ್ ಮಂಡ ಸರ್ ಇದು? ಎಕ್ಸ್ ಸರ್ವಿಸ್ ಮಂಡ. ನೋಡ್ತೀನಿ ಸರ್. ಹಾ, ಹಾಸನ್ನವರ ಕೊಡಿ ಸರ್ ನಂಬರ್. ಏನಪ್ಪ ಎಷ್ಟನೇದು ಕೊಡಿ ಸರ್ ನಂಬರ್ ಇದೆ. ಬಂದಿದ್ರೆ ಹಂಗ್ ಮೆನ್ಷನ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ ಸರ್.
Last time ಕೇಳಿದ್ರು ಆಗಿದೆಯಾ ಆರ್ಡರ್
ನೋಡ್ತೀನಿ ಸರ್ ಈಗ. ನೀವು ಪಿಟಿಷನರಾ? ಏನು ಇದರಲ್ಲಿ ಗ್ರಾಂಟ್ ಇಲ್ಲ ಅಂತನಾ?
ಯಾವತ್ತು ಈ ಡೈರೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ. ಆ ಡೈರೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಅಂದ್ರೆ ಇದೆಲ್ಲ ಇದು ಮಾಡ್ತಾರೆ ಈ ಕೋರ್ಟ್ಸ್ಗೆ ಅವ್ರದೆಲ್ಲ ಇದು ಮಾಡೋದು ಯಾವ ಕೇಸ್ ಇದೆ ಗೊತ್ತಾಗುತ್ತೆ.
ನೋಡೋಣ ಸರ್, ಆಯ್ತು ಫೋನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಸರ್. ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್, ಅದೊಂದು ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ.
ಪಾಸ್ವರ್ಡ್ ಕಂಟಿನ್ಯೂಷನ್
ಇಷ್ಟು ಆಮೇಲೆ ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಇದೆ, ಆಮೇಲೆ ಪಾಸ್ವರ್ಡ್ ಹೇಳ್ರಲ್ಲ ಕಂಪ್ಲೈಂಟ್ ಮಾಡ ಅಷ್ಟೇ ಕಂಪ್ಲೈ ಮಾಡಿದ್ಮೇಲೆ
ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್. ಫೋನ್ ಮಾಡಿದೆಯಲ್ಲ
76 ಏನು ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
ಇವತ್ತು ನೋಡು, ನೀನು ಇವತ್ತು ಕಾಣಿಸ್ಲಿಲ್ಲ, ಫೋನ್ ಮಾಡಿಲ್ಲ, ನನಗೊಂದು ಇಲ್ಲ ನೋಡು. ಓ ಅದಾ, ಓ ಮೈ ಗಾಡ್, ಅದಾ ಇನ್ನೂ ಟೈಮ್ ತಗೋಬೇಕಲ್ಲ ಯೋಗೇಶ್. ಇಲ್ಲೂ ಬಂದ್ಬಿಡುತ್ತೆ ಫಸ್ಟ್ ಮಾಡಿದ್ರು. ಸರಿ ಸರಿ ಬರ್ತೀನಿ. ಓಕೆ
ಇದಕ್ಕೆಲ್ಲ ಈ ಟೈಪ್ ಕಾಫಿ ಮಾಡ್ಕೊಂಡು
ಏನ್ ಹೇಳಿಪ್ಪ? ಆಯ್ತು, ಈಗ ಆಮೇಲೆ ಬನ್ನಿ.
ಮೇಡಮ್ ಇಷ್ಟ 76
76 ಏನೋ ಡೇಟ್ ಹೋಗಿಲ್ಲ.
ಎಲ್ಲಿದ್ದೀರಪ್ಪ? ಯಾರು ಕೇಳಿದ್ರು ನಿಮ್ಗೆ? ಸರಿ ಇವಾಗ ಆಯ್ತು, ಟೈಮ್ ಇಲ್ಲ ಈಗ.
ಮಾಡಿದ್ರೆ ನಾನೇ ಬರ್ಬಿಡ್ತೀನಿ ನಾಳೆ.
ಸರಿ 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 ಆಯ್ತು ಆಯ್ತು ಬಿಡಿ. ನೀವು ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾವ್ದು? ನೀವೇ ಆಯ್ತು ಯಾರು ಉಡುಪಿಯವರು, ಹಾಸನ ಅವರು
ಈಸಿ ನಮ್ಗೆ ತಿರುಗಿ ಬರೀತೀನಿ. ತಗೊಂಡ್ರೆ ನಾನೆಲ್ಲ ಬರ್ತೀನಿ. ಒಂದಿನಕ್ಕೆ ಬ್ರಾಂಚಿಯಲ್ಲಿ ಕೆಲಸ
ಊಟ ಮಾಡ್ಕೊಂಡ್ಬನ್ನಿ.
ಇಲ್ಲ ಬ್ರಾಂಚ್ ಕಳ್ಸೋದಿಲ್ಲ. ಡೇಟ್ ಯಾರು ಪುಟಪ್ ಇದ್ರೆ ಮಾತ್ರ ಅವ್ರು ಕಳಿಸ್ತಾರೆ.
18 ಅಪ್ಪ ನಿಮ್ದು? ಬಂದಿದೆ ಏನದು ಕೇಸು? ಶಂಕರ್ ಅವರು ಒಂದು WP ನೋಡಿ ಸಾಟರ್ಡೆ ತಂದ್ಕೊಟ್ಟಿದ್ರಂತ ರೆಕಾರ್ಡ್ಸ್ ಹಾಸನ್ ಕಡೆಯಿಂದ, ಹಾಸನಿಂದ. ನಂಬರ್ ಮೆಸೇಜ್ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ, ಬೇಗ ನೋಡ್ಬಿಟ್ಟು ನನಗೆ ಬೇಗ ಹೇಳಿ ಸರ್. ಅದು ರೆಕಾರ್ಡ್ಸ್ ಹೆಂಗ್ ಸರ್? ಅದು ಇಟ್ಕೊಳ್ತಾರಾ ಸಾಹೇಬ್ರು?
ಮೇಡಮ್ ಇರ್ಲಿ ರೆಕಾರ್ಡ್.
ನಾನು ಅದನ್ನ ಸ್ವಲ್ಪ
ಅವತ್ತು ನೀವು ಕೊಟ್ಟಿದ್ದು 2 ಇದೆ ಮೇಡಮ್.
ಎಲ್ಲ ಇದಾವ? ಅದು ಕೊಡಿ ಸರ್ ರೆಕಾರ್ಡ್. ಇನ್ನೊಂದು ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಸಾಹೇಬ್ರಿಗೆ. ಪಾಪ ಅದು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು ಲ್ಯಾಪ್ ಹಾಕೊಡ್ತೀನಿ. ಎಷ್ಟು ಬಂದ್ರು? 64 ವರೆಗೂ ಬಂದಿದೆ. ಇಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಆಗಿಲ್ಲ. ಲಂಚ್ ಆಯ್ತಲ್ಲ?
ಇಲ್ಲ ಮೇಡಮ್, ಬೆಳಿಗ್ಗೆ ಬಂದೆ ಮತ್ತೆ ಆಫೀಸ್ಗೆ ಹೋದೆ.
ಮತ್ತೆ 2:30 ಲಿಸ್ಟ್ ಒಂದಿದೆ, ಅದ ಮುಗಿದ್ಮೇಲೆ ತಗೊಂಡು ಬೇಗ ಮುಗೀತು.
ನನಗೆ ಸದಸ್ಯರನ್ನ ಕಾಂಗ್ರೆಸ್ನ ಅಟೆಂಡ್ ಮಾಡಿದ್ರು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಸಿದ್ರು.
ಕೊಡ್ತಾರೆ ಟೈಮ್ ಯಾವಾಗ? ಈಗ ಮಾಡ್ಬೇಕು ಇನ್ನೂ ಕೆಲವೊಂದು அதனால போய்
ಇಲ್ಲಿ ಇದೆಯಲ್ಲ, ಮ್ಯೂಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಅಲ್ಲೇ ಮಾಡ್ಬೋದು. ಇಲ್ಲಿದೆಯಲ್ಲ ಅದು ವಾಲ್ಯೂಮ್ ಮಾಡಿತ್ತು. ಇಲ್ಲೇ ಅವ್ರ ಹೆಸರು ಪಕ್ಕನೇ ಇಲ್ಲಿ ಮಾಡಿದ್ರೆ ಮ್ಯೂಟ್. ವಿಡಿಯೋನು ಬೇಕಾದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡಿ. ಇದು ವಾಲ್ಯೂಮ್ ಯಾವುದು ಇದಾ? ಅದು ಪಿನ್ ಮಾಡೋದಕ್ಕೆ ಪಿನ್ ಮಾಡೋದು ಅಂತ ಹೇಳಿದ್ರಪ್ಪ. ಮಾಡಿದ್ರೆ ಅದು ಅವರು ಇದಾಗತ್ತೆ. ಫಸ್ಟೇ ಇಲ್ಲೇ ಮಾಡ್ಬಿಡ್ತಾರಲ್ಲ ಪಿನ್. ಇದೇ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಫಸ್ಟೇ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಏನೋ ಗೊತ್ತಿಲ್ಲ. ಇದು ಅದೇ ವಿಡಿಯೋ ಆಡಿಯೋ ಅದೇ ಪಿನ್ ಇಲ್ಲೇ ಮಾಡಿರ್ತಾರೆ. ಇದು ಕ್ಲೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ, ಅವ್ರನ್ನೇ ತೆಗ್ದಾಕ್ಬಿಡು.
With lordship kindly, my lord.
Yes.
My lord, I will produce, my lord, two judgments for your lordship consideration. Tomorrow,
I'll reserve it for continue.
and after serving.
I will reserve it. You give me the judgments and go through that.
Oh, bless you. Oh, bless you.
List number 2.
My lord, serial number 2 of first list, my lord. That was passed over in the morning. I think
Somebody took time.
Learned Senior Counsel has taken time. May I kindly have this matter next week, my lord? Because
I have told him tomorrow. Tomorrow, Bani.
In serial number 2.1, which is a connected matter, the counsel on record 2.1 ನಲ್ಲಿ he has issued NOC, and I have to take certain.
Come tomorrow. Let us see what will happen tomorrow.
My lords, what has happened is I have to take certain steps towards.
Come tomorrow. Let us see. Come tomorrow.
Number 2.
Six. Six delete.
And my lord, serial number 5 also, my lord, still SC is not passed any order, my lord. It is a pending proceedings, my lord. Serial number 5, my lord.
Same order than other.
Please, it is pending.
List number 2, serial number 1.
All right. Allowed.
1 week time ಬೇಕು ನನಗೆ. Impeding ಆಗ್ಬೇಕು.
They are
Impeding, Asian impeding.
serial number 5 ಅಲ್ಲಿ, my lord, 79 AB. Their ground is, my lord, within 18 kilometers. It's not come under the 79 AB and petitioners.
96 grant, my lord. 2023, the proceedings initiated for
ಅವ್ರು
cancellation.
ಯಾವ್ದು ಕೇಳ್ತಾರೆ?
Serial number 5.
Serial number 1, list number 2. 1 week time ಬೇಕು.
Sir,
ಏನಕ್ಕೆ?
ಅದಾಯ್ತು.
ಅವರು impede ಆಗ್ಬೇಕು.
ಯಾರು ಇಂಪ್ಲೀಟ್ ಮಾಡಿ?
Asian.
ನಾನು ಅಲೋ ಮಾಡ್ತಿದ್ದೀನಿ, ನೀನು ಬೇಡ ಬಿಡಿ.
ಅವ್ರಿಗೆ ಹೇಳಿ ಸರ್,
ಅಲ್ಲ,
ಆಗಿದೆ ಅಂತ.
application ಹಾಕ್ಲಿಲ್ಲ.
ಬೇಡ ಬಿಡಿ ಪರವಾಗಿಲ್ಲ.
ನನಗೆ ಹೆಲ್ತ್ ಸರಿ ಇಲ್ಲದೆ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ನಿಮ್ದು ಯಾವ ಚಕ್ರರೆಡ್ಡಿ?
Serial number 5. That is 96 grant, my lord. 2023.
ಬಿ ಅಲ್ವಾ?
79 AB under AC has initiated proceedings and it's still pending, my lord.
Lord, that is wrong proceedings, my lord. Lord,
ಅದನ್ನ
what
ಅಲ್ಲೇ
happened,
ಹೋಗಿ
the
ಹೇಳಿ
assistant
ಅಂತ.
commissioner, my lord, 96 land was granted to the 20 persons, except the petitioner has not issued the Sagwal sheet, my lord. Lord, 2023, after the petitioner approached 2023 before the honorable court. Honorable High Court, my lord, issued direction. This is the matter in the report to 23 kilometers from the distance in their report. The, my lord, the writ petition allowed within the 30 days, the Sagwal sheet should be issued. Till date, they have not issued. Again, the representation.
ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಲ್ವಾ?
We don't know, my lord.
My lord,
Today is
in
the
the
first day, my
preamble
lord.
that-
5 separate, it will come separately.
Please, my lord.
And date may be fixed, my lord. This is the 26 years matters.
Serial number 110.
Regarding my lord, kindly pass over. Senior will come. So
I'm raising at 4 o'clock.
Please, my lord. Before my lord.
230 mode matter. Serial number 1, Sri Nayak NR. 230 mode matter.
ನೋಡಿದ್ದೀರಾ?
Bench ಗೊತ್ತಿಲ್ಲ.
Kaladari Otturi. AG accepts notice for respondents. 1 to 6. Released on till the next date of hearing. No coercive action shall be taken pursuant to Annexure F and delivery permitted.
Passed over matter, list number 1, sheet number 42. Sheet number 42.
Appearing for the petitioner, my lord, kindly have this matter next week, my lord. Senior head up in other court.
Please, my lord, records, there is no application has been adhered to the next time, my lord, any date.
Released.
Date 21st.
For hearing on IA. Sheet number 62. MS Nagaraja.
My lord,
Yenaita.
but I called my lord the president because of present before the court. What he is saying, my lord, my secretary is also both. What they are saying, my lord, they have to, because of his ill health, he is not able to conduct the meeting. They said that, my lord, today at least they need 10 days time to reporting that.
I will decide this, you will lose the entire land if they want to.
My lord, they have not made. Lord, the petition, the para number 7 itself, my lord, it's very clear that, my lord, they have filed a case against the beneficiary, not against the landlord.
Argument mabidi sumne yake. I thought I'll save you some land if you don't want to.
That's what I filed an application, my lord.
For what
grounds? My lord, it has to be considered and I will.
Seeking for amendment of the petition.
Amendment,
filed by-
incorporation of additional grounds.
Really? Take it as allowed, argue.
Yes, my lord. If that is the case. My lord, the land which, my lord, in question, it belongs to the trust. My lord, first I take your lordship that the cause title of the order itself, because the original tenant, my lord.
Annexure CL, which is that order? Order?
That annexure E, my lord.
Annexure
E. Page number 48.
Yes.
My lord, the petitioner, Ishwarappa, he died, my lord. He died. During the pendency of the proceedings, my lord, he executed a power of attorney in favor of his son, Chandrasekhar. My lord, he died in 1997. During the pendency, after, once, my lord, the land tribunal rejected, they filed a writ petition, remanded the matter for this. After remanding 1996, my lord, after it was remanded on 14/6/1996. He died on 31/7/1997. My lord, his LRs not brought on.
31?
He's died on 31/7/1997. 31/7.
Yes.
37/97. The original tenant, he died, my lord. His LRs, they are not on brought on record. My lord, the tribunal, my lord, after that night, after remanding that matter, no evidence has been recorded. My lord, after the
Where is the order of remand?
Say in annexure, my lord. Annexures.
D, na?
Annexure D. Annexure D is the order.
This was the order of remand.
Remand. See, earlier, my lord, the tenancy application has been rejected.
Ishwarappa was a petitioner.
Petitioner.
He
He died. His LRs are not on brought on record. Maybe your lordship also held in one other matter. See, because the LRs, they are not on brought on record. The against the land, the occupancy rights have been granted, my lord, in favor of the death person.
That is an order in his favor. If it was an order against him, then you're right, because that order can't be passed into person. If an order passed in favor of a dead plaintiff, it renews to his LRs. How are you aggrieved?
Correct. They are not brought on the record, my lord. Now, my lord, the tribunal is granted 4 acres of land, my lord.
Now, suppose the firm number had been rejected against a tenant who had died, then it is a void order because he had the right to challenge it. But if it's an order in his favor, there's no prejudice caused to him.
Not acted as, my lord, there is a 4 acres land granted in favor of the tenant, my lord. Please. Rest of the land is retained in the favor of the school. My lord, Form 7.
So they'll have a good ground to say that the order is bad because the order of rejection is against a dead person.
That's one thing. My lord. Secondly, my lord, Form number 7. My lord, I have produced the Form number 7 also. My lord.
Application,
Application, Form number 7.
Page?
My lord, additional documents I produced on 12/2/2024. They are also filed, they produce the application. There are two applications, Form number 7 is produced. He filed. Additional
Memo documents.
12/2/2024.
Got it.
Adralli, Form number 7 I have produced as a document number 3, page 8. Page 8. My lord, the school is the beneficiary. School is, they have filed a case, my lord, Form number against the beneficiary.
School is new
Type middle school.
NTMS.
Yes. School is a beneficiary, my lord, is not the owner. School is a beneficiary. The trust is the school owner, my lord. That is, the trust has been formed by the original owner. Original owner of the land is one Chiluru Rudrappa, who gifted the land to the in favor of the trust. With a condition, my lord, the trust has to be manage the land. My lord, whatever the profit it derives from the land, my lord, it has to be utilized for the benefit of the students pursuing in the school. School is the beneficiary. The Form number 7 itself, my lord, it has filed against the beneficiary, not against the owner of the trust. My lord, in fact, he is himself has admitted, my lord. The next document I have produced.
Did you raise this objection there saying that the trust should have been made a party and the trust is not made a party? Did you say anything there in the land tribunal? You contest the proceedings on all the three grounds.
They have not been, Allah now evidence put it. Our school is only the beneficiary.
You represented the interest of the trust.
Yes, my lord.
Throughout.
Yes,
so what argument are you advancing saying that the trust should have been a party?
Trust, my lord, they are not, because they are deliberately they are showing that the school beneficiary as an owner of the land in so.
If the beneficiary comes to the tribunal and defends the case of the trust,
he is also, because the trust is the owner. Trust is Malay contending, the trustees contested the tribunal proceedings before the.
So then I can dismiss your writ petition on the ground that you have no interest.
No, now we are the owner. That's what we are before the court, my lord. Because we contested the Form number 7. Owners, they are deliberate. My lord, the Form number 7.
Who is the petitioner here?
Here the trust, my lord. It's undisputed fact, trust is the landowner.
And represented by Nagendrappa.
Nagendrappa is the man.
Who represented you before the land tribunal?
Is the president, my lord.
Nagendrappa.
Nagendrappa subsequently, my lord. Prior to that, Rudrappa, Patel Rudrappa is the president.
Who was in the trust? What was his position in the trust?
Patel Rudrappa. By that time, when proceedings are initiated in 1974, Patel Rudrappa was the president of the trust, my lord, who happens to be the brother of the applicant.
Patel Rudrappa is the author of the trust.
Yes, he was the author. He was the president of the trust. Patel Rudrappa. My lord, who cultivating the land? Because that is the president. The land was entrusted to the trust by the original owner. He is called Chiluru Rudrappa.
Chiluru
Rudrappa. That is the trust deed I have produced before the court.
He had gifted the property.
Yes, my lord, gifted the property in favor of the trust. He created the trust.
When was the trust?
Trust was in 17/12/1951. My lord.
In the trust, he had created the trust. Who created the trust?
The original owner, my lord.
That is
Chiluru Rudrappa. Chiluru, CHELUR.
He is the author. He is the author of the trust.
He's the owner who created the trust and transferred the land in favor of the trust itself. He constituted the committee consisting 10 members.
How was the Patel Rudrappa and Chiluru Rudrappa related? Sanna?
Illa, they are district families. Patel Rudrappa was the first president of the trust. My lord, the applicant Ishwarappa is the brother of first president Patel Rudrappa.
Yes.
Patel Rudrappa. My lord, as per the trust, my lord, the trust has to be manage the land because the president is Rudrappa. He cultivated the land. He cultivated the land till 1976, till his till the date of his death. He cultivated the land as a president of the trust.
So the trust did not make any application to declare that it was descendant to hold the land. After the land reforms came into force, the trust could not have held the land, isn't it? You have to give a declaration.
Because the file number 7 filed by Ishwarappa.
No. You were a trust.
Yes.
You could not hold the land after 74. You were required to file a declaration under section 66, declaring your holding.
Yes, but they have made it.
So you, where is that form 66? So if the landowner passed an order permitting you to hold up to 20 units, you are entitled to hold. Or else how can you hold the land?
The trust is the owner. They have cultivated the land.
Trust was the owner, but what is the effect of section 66? Should you not file a declaration?
1957 in the trust is there.
Irbodu. Problem ಬರೋದು ಆಮೇಲೆ ತಾನೆ 74 ಮೇಲೆ ತಾನೆ.
Correct. The land is the land, my lord, is not being leased out to anybody else.
No, I am questioning your locus standi since you did not file a declaration. What is the effect of?
ಮಾಡಿದ್ದಾರೆ ಟ್ರಸ್ಟ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ reconstitution. They made as
63 ನೋಡಿ descended to hold land.
Take the hillock.
You are supposed to file a declaration, isn't it, that you are not entitled to hold land. Yes.
My lord, we have placed the evidence even before the land tribunal also. The proceedings of the trust from 1957, my lord. Particularly, my lord, he is claiming that the applicant, my lord, the respondent number 3 is claiming that he was cultivated the land in 1967 onwards. 67 onwards, his contention is 1967. Onwards, he is cultivated the land in question. My lord, forum number 7, there are two forum number 7 he has filed, in which my lord is claiming that for 50 years. First time he is himself is made a statement in the writ petition. In the statement also, 1969 onwards he is cultivating the land. My lord, the trust proceedings, my lord, is very clear that Patel Rudrappa, he himself is the president of the chairman and preside over the matter and pass the resolutions stating that, my lord, 1967, my lord, I have in page number 14, my lord, additional documents I produced.
In page?
In page number 14, document number 2, my lord.
Yes.
Proceedings of the trust.
Yes.
Page 14.
Page 16.
14, page 14. In page number 14. Adralli para 4, 1967 and 68. ಸಾಲಿನ ಉತ್ಪತ್ತಿಯ ವಿಚಾರ. ಸದರಿ ಜಮೀನನ್ನು ಈ ಹಿಂದಿನಿಂದಲೂ ಸಾಗುವಳಿ ಮಾಡಿ ಬಂದಿರುವ ಪಟೇಲ್ ರುದ್ರಪ್ಪನವರೇ ಸಾಗುವಳಿ ಮಾಡುವುದರಿಂದ ಮಾಘಬಹುಳ ಅಮಾವಾಸ್ಯೆಯ ಒಳಗಾಗಿ ಟ್ರಸ್ಟ್ ಕಮಿಟಿಗೆ 6 ಕ್ವಿಂಟಲ್ ಭತ್ತ ಕೊಡಬೇಕೆಂದು ತೀರ್ಮಾನಿಸಲಾಯಿತು. That's my lord. Subsequent also, the Patel Rudrappa my lord is being a president, because that being a president, who cultivated the land?
He was a tenant antana.
Tenant alla. Owner my lord, because that he's the.
Then there is a question of 6 ಕ್ವಿಂಟಲ್ ಭತ್ತ ಕೊಡಬೇಕೆಂದು ತೀರ್ಮಾನಿಸಲಾಯಿತು.
ಅದ್ರಲ್ಲಿ ಬರೋದನ್ನೆಲ್ಲ ಸ್ಕೂಲಿಗೆ ಕೊಡ್ಬೇಕು. ಅದನ್ನ ಮಾರಿ ಆ ಅಮೌಂಟ್ ಅನ್ನ ಸ್ಕೂಲ್ ಮಕ್ಕಳಿಗೆ ಯೂಸ್ ಮಾಡ್ತಾರೆ. This is the trust deed alle very clear ಇದೆ. My lord, what are the property derives from the land, cultivation of the land? That has to be given to the students who are studying in fourth respondents.
The trust deed says who should cultivate.
ಅದನ್ನ ಬೇರೆ ಯಾರಿಗೂ ಕೊಡ್ತಾ ಇರಲಿಲ್ಲ, ಇವರೇ ಟ್ರಸ್ಟ್ ನವರೇ ಮಾಡ್ತಾರೆ.
What does the trust deed say about cultivation?
ಅವ್ರಿಗೆ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ನೀವು ಟ್ರಸ್ಟ್ ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು, ನೀವಾದ್ರೂ ಉಳಿಮೆ ಮಾಡ್ಬೋದು ಅಥವಾ ಮಾರಿ ಅದನ್ನ ಮಕ್ಕಳಿಗೆ ಉಪಯೋಗಿಸಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಟ್ರಸ್ಟ್ ಅಲ್ಲಿ ಎಂಟೈರ್ ಪವರ್ ಇಸ್ ಗಿವನ್ ಟು ದ ಟ್ರಸ್ಟೀಸ್. ಮೊದಲ ನೀವು ಅದನ್ನು ಉಳುಮೆ ಮಾಡಿ ಬಂದಿರಕ್ಕಂತ ಉತ್ಪನ್ನವನ್ನ ಮೊದಲು ನೀವು ಸ್ಕೂಲ್ ಮಕ್ಕಳಿಗೆ ಉಪಯೋಗಿಸ್ಬೇಕು, ಇಲ್ಲ ಮಾರಿ ಆದ್ರೂ ಅದನ್ನು ಮಕ್ಕಳಿಗೋಸ್ಕರ ಉಪಯೋಗಿಸಬೇಕು ಅಂತ. That is a condition. The Rudrappa Malad, who has cultivated the land 1976 till 1970s, he died in 1976. But he happens to be the brother of the Patel Rudrappa. He made an application.
Patel Rudrappa's name was there in the RTC?
Patel Rudrappa bandri trust SL ಬರ್ತಾ ಇದೆ.
Whose name was there in the cultivator's column?
Cultivation Ishwarappa's land, first time it was reflected in 1969.
For how many years?
1969 in that till 1974 as on the date of filing the application.
And the mode of cultivation?
Mode of cultivation is not been stated. They are not aware, because that he is the president, he has to look after Malad. And Malad, one of the son of the Ishwarappa, who is working in as a village accountant in the same village, by name Devendrappa. Malad, they have manipulated the records. Even Patel Rudrappa, he made a statement before the land tribunal. He has categorically stated that he himself has cultivated the land. ನಾವು ಯಾರಿಗೂ ಸಾಗುವಳಿ ಕೊಟ್ಟಿಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. That is the evidence is available on record, my lord. There is no saguwali, my lord. There is no receipt for having paid the GD to the school. The trustees consent. They have not placed any material except the one of the, my lord, except the oral evidence. There is no.
You have produced the 67 minutes.
67, 68 onwards ಎಲ್ಲ ಇದೆ.
73 ಏನು ಅಂತ
ಮಾಡಿದ್ದೀರಾ? Yes, my lord. It continued till, my lord, up to, my lord, 76. 15/1/1976.
What is the proceedings relating to 74?
74, my lord.
Record produce ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀವಿ. I have produced those records.
ಇಲ್ಲ ಇದೇ ತರ ಮಿನಿಟ್ಸ್ ಆಫ್ ದಿ ಇಯರ್ 73
till today we have maintained the records.
ಇಲ್ಲ 73 74 ತೋರಿಸಿ ಸಾಕು.
74. 1969. 70.
Only for 67 you produce, you have
The
not.
70 ಎಲ್ಲ ಇದೆ. ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ ಇದೆ records, original records ಇದೆ.
Have you produced with the tribunal?
No, my lord. There they, my lord, contention it is stated, my lord, page 54 and my lord, 52, my lord. 52 second paragraph, my lord, B ಅಲ್ಲಿ annexure E, my lord, page 52. B, my lord, third, fourth paragraph, my lord, there.
Page 50?
52, my lord. ಪ್ರತಿವಾದಿ ಪರ ಸಾಕ್ಷಿದಾರರು ಪರಮೇಶ್ವರ್ ಬಿನ್ ಸೋ ಅಂಡ್ ಸೋ ಅಲ್ಲಿ. ಟ್ರಸ್ಟ್ ನ ಅಧ್ಯಕ್ಷರಾಗಿದ್ದ ಶ್ರೀ ರುದ್ರಪ್ಪನ ಇನ್ ಬಿಟ್ವೀನ್ ಮಲ ರುದ್ರಪ್ಪನವರು ಶ್ರೀ ಈಶ್ವರಪ್ಪನವರಿಗೆ ಕಾಸ ಅಣ್ಣನಾಗಬೇಕು. ಪಾಟೀಲ್ ರುದ್ರಪ್ಪನವರಿಗೆ ಮಕ್ಕಳಿರಲಿಲ್ಲ. ಇವರು ಪತ್ನಿಯು ಚಿಕ್ಕ ವಯಸ್ಸಿನಲ್ಲಿ ತೀರಿಕೊಂಡಿದ್ದರಿಂದ ರುದ್ರಪ್ಪನವರು ಮತ್ತು ಶ್ರೀ ಈಶ್ವರಪ್ಪ ಒಂದೇ ಕುಟುಂಬದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು 1985ರಲ್ಲಿ ಆಸ್ತಿಯನ್ನು ಪರಸ್ಪರ ವಿಭಾಗ ಮಾಡಿಕೊಂಡು ಸದರಿ ಜಮೀನ ಪಹಣಿ 68 69ರಿಂದ ಈಚೆಗೆ ಈಶ್ವರಪ್ಪನವರ ಹೆಸರಿಗೆ ಬದಲಾವಣೆ ಆಗಿದ್ದು, ಈ ಬದಲಾವಣೆ ಬೆಂಬಲವಾಗಿ ಟ್ರಸ್ಟ್ ಯಾವುದೇ ತೀರ್ಮಾನ ಅಥವಾ ನಡವಳಿಕೆಗಳು ಆಗಿರುವುದಿಲ್ಲ. ಈ ಎಲ್ಲಾ ಅಂಶಗಳಿಂದ ಜಮೀನನ್ನು ಶಾಲೆಗೆ ಉಳಿಸಿಕೊಡಬೇಕೆಂದು ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಈ ಅಂಶವನ್ನು ನ್ಯಾಯಾಲಯವು ಪರಿಶೀಲಿಸಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಸಿ ಯಲ್ಲಿ ದಾನ ಪತ್ರದಲ್ಲಿ ಹೇಳಿರುವಂತೆ ಕೊನಗಾವಲ್ಲಿ ನೀವು ಟೈಪ್ ಮಿಡ್ಲಿ ಸ್ಕೂಲ್ ಟ್ರಸ್ಟ್ಗೆ ಸದರಿ ಜಮೀನು ದಾನವಾಗಿ ನೀಡಿದ್ದು, ನೀವುಗಳು ನಾನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಜೀವಿತವಾಗಿರುವಾಗ ತನಕ ಸದರಿ ಸತ್ತಿನ ಉತ್ಪತ್ತಿಯನ್ನು ಕೊಟ್ಟು ಕಾಪಾಡತಕ್ಕದೆಂದು ಪರ್ಯಂತ ಕೆಳಗೆ ಜಮೀನಿನ ಉತ್ಪತ್ತಿಯನ್ನು ಸೂಕ್ತ ಕಂಡ ರೀತಿಯಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿಗಳ ಹಿತಕ್ಕೆ ಉಪಯೋಗಿಸಬೇಕೆಂದು ಹೇಳಿರುತ್ತಾರೆ. ಈ ಅಂಶವನ್ನು ನ್ಯಾಯಾಲಯವು ಗಮನಿಸಿದೆ. ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ರೈಟ್ಸ್ ದಾಖಲೆಯಂತೆ ಸದರಿ ಜಮೀನು ಪಿತ್ರಾರ್ಜಿತ ಜಮೀನು ಆಗಿರುತ್ತದೆ. ಜಡ್ಜರು ಸರ್ವೆ ನಂಬರ್ 82ರಂತೆ ರುದ್ರಪ್ಪ ಚೇಲು ವೀರಬಸಪ್ಪ ಇವರಿಂದ ಚೆನ್ನಪ್ಪ ಬಿನ್ ನಡವಲ್ಮನೆ ರುದ್ರಪ್ಪ ಇವರಿಗೆ SR 1872 ದಿನಾಂಕ 24/6/44ರಂತೆ ವ್ಯವಸ್ಥಾ ಪತ್ರದಂತೆ ಬಂದಿರುತ್ತದೆ. ಜಂಜರು ನಂಬರ್ 87ರಂತೆ ಸದರಿ ವ್ಯವಸ್ಥಾ ಪತ್ರವನ್ನು SR 561 ದಿನಾಂಕ 4/10/46ರಂತೆ ರದ್ದುಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಇದರಂತೆ MR 1 46/47 ಎಂದು ದಾಖಲಾಗಿರುತ್ತದೆ ಮತ್ತು ಜಂಜರ್ ನಂಬರ್ 93ರಂತೆ ಶ್ರೀ ಚೇಲೂರು ರುದ್ರಪ್ಪ ಇವರಿಂದ ಶ್ರೀ ಕಂಚೀರಪ್ಪ ಬಿನ್ ವೀರಪ್ಪ ಇವರಿಗೆ ದತ್ತು ಪತ್ರ SR 1799 46/47 ದಿನಾಂಕ 15/5/47ರಂತೆ ಆಗಿರುತ್ತದೆ. ಇದರಂತೆ MR H 228 46/47 ದಾಖಲಾಗಿರುತ್ತದೆ. ಈ ದತ್ತುಪತ್ರ ರದ್ದುಪಡಿಸಿದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ನಮೂದಿರುವುದಿಲ್ಲ ಮತ್ತು ಮಾಹಿತಿಯೂ ಇರುವುದಿಲ್ಲವಾಗಿದ್ದು, ಈ ಅಂಶವನ್ನು ನ್ಯಾಯಾಲಯವು ಪರಿಶೀಲಿಸಿರುತ್ತದೆ. ವಾದಿ ಪ್ರತಿವಾದಿಗಳ ಹೇಳಿಕೆ ಪರಿಶೀಲಿಸಲಾಗಿ ನ್ಯಾಯಾಲಯವು ಕೆಳಗಿನಂತೆ ತೀರ್ಮಾನಿಸಿರುತ್ತದೆ. ಮೇಲೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇಲೆ ದಿಸ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮೇಲೆ continuous dispute 4 acres of the eastern portion my lord, it is given to the school and thing. They never produced before the minutes of the meeting and order my lord, before the tribunal.
The order it observes that they have not made an application for change also.
Is the third round litigation apparently.
Because records ಯಾಕೆ ಚೇಂಜ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬಿಕಾಸ್ ಅವ್ರ ಬ್ರದರ್ ಪ್ರೆಸಿಡೆಂಟ್ ಇದ್ರು, ಅವ್ರು ದೇ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಅ ಡಿಸಿಷನ್. ಅವರ ಸತ್ತಾದ ಮೇಲೆ ಬೇರೆಯವರು ಯಾರು ಟ್ರಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಬಿಕಾಸ್ ದಟ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಲೋಡ್ ದೇ ಆರ್ ನಾಟ್ ಟೇಕನ್ ಇಮಿಡಿಯೇಟ್ ಸ್ಟೆಪ್ಸ್ ಟು ಕೊಟ್ಟಿದ್ದಾರೆ, ದಟ್ ಈಸ್ ಪೆಂಡಿಂಗ್. ಇಮಿಡಿಯೇಟ್ ಆಗಿ ದೇ ಹ್ಯಾವ್ ಚೇಂಜ್ ದಿ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಟು ರಿಮೂವ್ ದ ನೇಮ್ ಆಫ್ ಈಶ್ವರಪ್ಪ. The proceedings are pending before the concerned authority because the proceedings are pending before the land tribunal, my lord. Therefore, they are not been considered. My lord, without there being any evidence as to the gain is concerned, my lord, they have to pay some gain to the trust if he is cultivated as a tenant.
No, your records indicate up to 67, Rudrappa was taking care of the property.
ಎಲ್ಲ ಇದು 76 ವರೆಗೂ 76.
Why did not produce all those records from 67 up to 76?
ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ 70.
You are aware, your headmaster was aware that the Kata, the Pani was showing the name of Ishwarappa.
It's only suggestion, my lord.
He has admitted.
The
And you
suggestion.
did not produce documents to show that even in the rest of the years after 67, 70, the same Rudrappa, what's his name? Rudrappa was cultivating the land. There's nothing on record produced by you. If you had maintained records up to the year 67, 70, you must have maintained records after 70 also.
Yes, my lord, we produced before the land tribunal itself, my lord.
Show me that, where is that?
Our records ನಾನು ನೋಡ್ಬೇಕು ಅದಕ್ಕೆ.
ನೀವು ನೋಡಿ ಹೇಳಿ ಸುಮ್ಮನೆ ನೀವು.
ಇಲ್ಲ, my lord, they produced the entire, even my lord in the.
Show me, you have produced additional document. Show me for the year 71, 72, 73, 74, something from the trust accounts that this money was being paid by Rudrappa only, not by.
Yes, my lord, definitely. ಇದರಲ್ಲೇ ಇದೆ. ನಾವು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೇ, my lord.
73, 74 ತೋರಿಸಿ. If Rudrappa has cheated you by creating a tenancy, you can't do anything about it.
Because he is the president, my lord. He is managing the land.
Show me from your records, from the trust records, that from the year 70, 71, 71, 72, 73,
Original
74.
proceedings ಕೊಟ್ಬಿಡ್ತಾರೆ.
You
Book ಕೊಡ್ತಾರೆ.
ಈ ಕೊಟ್ರಲ್ಲ, you produce it there.
Yes, my lord, we produced before the land tribunal itself.
Please show me which document.
ಅದನ್ನ ನಾನು I will pursue the original records. Records ಅಲ್ಲಿ. Original records are secured. I will verify it and I will submit.
ಮಾಡಿ.
ನೋಡ್ತಾನೆ.
I heard the matter 3 times.
ಇಲ್ಲ, my lord, ನಾನು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ, my lord, your lordship has suggested because that they are.
After hearing only, I suggested. I wanted to save you 4
Lord,
acres.
there before I have conveyed this, my lord, because of his account, they are not conducted. They have to take a decision. That's what I'm fairly submitted before the
I
court.
gave you at least 4 weeks time. After I heard the matter, I urged the matter thrice or 4 times, only to see that both of you live and let live.
Lord, he is taking treatment, my lord. They have to call the meeting. Even secretary also, today I asked him to come before the court, saying that this is the suggestion is given by the honorable court. He pursue it and take a decision to tell me the result.
I'll consider reserved.
My lord, I have to produce, my lord, I have to produce that document.
I look at the records. If it is there, I look at the records.
Yes, I have to verify and I will submit my.
ನಾನು ಮಾಡ್ತೀನಿ ಬಿಡಿ. I gave you 4 weeks time. ನೀವು ಸೆಟ್ಲ್ ಮಾಡಲಿಲ್ಲ, ರೆಕಾರ್ಡ್ ನೋಡ್ಲಿಲ್ಲ. I will not allow the matter to be adjourned. I heard the matter.
I need 1 week time, Lord. Next week I will convene on Monday. Next
file your written arguments.
That records I will, if it is not, my lord, original records, even trust records, I will place it before the court.
Reserve.
Number 63, Shri G.S. Shrikantagowda.
I mean, with a liberty, my lord, I have to produce that document. Please.
File your written arguments, I'll permit you. I look at the records, then make up my mind.
Otherwise, my lord, I take this matter, my lord. Original record, the trust proceedings, I will.
ಈ ಕೊಟ್ರೆ ಆಗಲ್ಲ. You should have, you had an opportunity 3 times remand ಆಗಿದೆ. You should have done it earlier, not now.
My lord, they have placed. That's what I know. Look into the original records.
No. Yes.
G.S. Shrikantagowda.
In this case.
My lord, in this case, appears for respond number 4, 6 and 7, my lord.
Yes.
Directed, let the Tahsildar to
contempt.
appear before this honorable court. Under 49A, my lord, he has no such jurisdiction. Let sumo to appeal, my lord, he has registered.
Come before 345.
Please. Hello, other.
Number 64, Shri Anjaneya AB.
Somebody sought for time in the morning.
I for the
Not
applicant.
this, Lord, I have filed in the
colleagues
for vacating interim order. Not that,
He sought for time. You have any objection?
really, sites allot ಮಾಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗ್ಬಿಡಿದೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ. ಸೊ ಅದು ಒಂದು ಡಿಫಿಕಲ್ಟಿ ಇದೆ ನಮಗೆ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ನನ್ನ ಆರ್ಡರ್ನ ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ. My lord has last time modified it for a status quo. It's difficult.
Next time ಬರಕ್ಕೆ ಹೇಳಿ.
ನಾಡಿದ್ದು ಕೊಟ್ಬಿಡಿ ಸರ್, 9ನೇ ತಾರೀಕು ಕೊಡಿ ಸರ್.
24, 21st. 21st.
21st. Number 65, Shri.
Matter was heard for time, some time, and lordship has called for the records of the deputy commissioner.
Next week, my lord, Udupi, it has to come from Udupi, my lord, and second.
Realist.
Sir?
16. Number 66.
I'm appearing for petitioner. I'm appearing for petitioner. Senior counsel has been engaged in this matter. Some inconvenience.
Last occasion, same submission was kindly, your lordship may kindly see the memo filed by me.
Is out of
The Tahsildar has issued an endorsement stating that they have never filed an application for regularization of the property in question. In spite of that, this is second round litigation.
What is the next area?
The orders of Assistant Commissioner and Deputy Commissioner. Well, the main issue is whether first round and second round, both authorities said that they have not filed applications and they are not entitled for regularization of. And now even the Tahsildar has under RTA Act issued stating that now.
Then the matter on more than one occasion.
Senior is out of station. Senior is out of station.
Last occasion also same submission was made. And kindly see the interim order, now status quo has been granted. And it is troubling this respondent's position.
After tomorrow. Realist.
Interim order.
If it does not come next time, I'll dismiss the writ petition.
Number 67, Prasanna Ria.
The application may be considered on its main, I will argue next.
A1/24 to be considered along with the main matter.
Date might be fixed, my lord. Date might be.
Any date.
B group, post in B group.
17.
29th.
17th.
Number 68, Akshay Kumar Dev. Number 68.
Realist.
Number 69.
ನೀವು ಹಾಕಿದ್ರು
ಅವರು ಏ ಹಾಕಿದ್ದಾರೆ ಈ ಒಂದು
ಐಎ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಹಾಕಿದ್ವಿ ನಾವು. ಅವರು ಹೋಸರಿ ಟೈಮ್ ತಗೊಂಡು
ರಿವ್ಯೂ ಹಾಕಿದ್ರು ರಿಜೆಕ್ಟ್ ಆಯ್ತು. ಈಗ ಐಎ ಫಾರ್ ಕ್ಲಾರಿಫಿಕೇಶನ್
ಅಲ್ಲಿ ರಿವ್ಯೂ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದ್ರಿಂದ ಏನೋ ಹೇಳಿದ್ರು.
ರಿಯಲಿಸ್ಟ್.
70. Number 70. Mahesh Inshetti.
I appear for the petitioner in this matter. If my lords could kindly recollect, in this matter, what has happened is your lordships directed them to produce the survey which was conducted with regard to that report. Now, my lord, they are redoing now during the pendency of this matter and there being an interim order. All the revenue officials, my lord, the other day they trespassed into the property and they tried to conduct the survey. My lord, I have the photograph transcripts I can produce before your lordship along with an affidavit.
Not for the
My lord,
survey.
they are doing it
is
now.
Not for the survey, my lordship. It is not for the survey. Additional Advocate General has sought for some information regarding the property that he want to explain. Kindly, it may be pass over, my lordship.
Unrecorded habitation,
The unrecorded habitation. If your lordships, my lord, directed them to produce the survey report, which was joint survey, which was conducted according to them. Now they are doing it, my lord. My lord, I have the transcripts which I can produce it before your lordships.
70.
Please present
If you wanted you to come and argue.
Please, let's, we have, I've secured the instructions. Lords, in respect of this matter, lords, if pleadings have to be completed, there is a vacating stay application filed by the other side. Our pleadings, lords, could be completed in 2 days because we have received all the instructions today. If it could be argued now also, lords.
What is this complaint that you try to conduct a survey?
No, lords, we are taking, lords, I had asked them to produce a photo, the drone shots, lords, of the property because I wanted to produce it to the court. So that drone shots, they were objecting. Lords, the drone shot, lords, we wanted a photograph, lords, of the land from an aerial view of the land, lords. Since there was no high-rise building, lords, in the surrounding area, lords, in order to give, lords, to show, lords, what exactly is the position with regard to the entire survey number, lords, as on date, we had asked, we were only taking, lords, photographs of the land to produce it before my lords. For a photographs tagdid ashte.
Oh, they are not entering anyway such a way.
The village accountant, everybody, surveyor. My lord, what work the surveyor has that? Even I have the videos of that also, my lord. My lord, a private land is sought to be declared as unrecorded habitat.
Lords, it is a private land, my lords, no doubt about it. My lords, but we have, my lords, passed a notification under section 94D, my lords, with regard to unrecorded habitations, my lords. Lords, what had happened if private lands are there, my lords, and if for over many years, my lords, they have allowed, my lords, some tandas or hamlets or camps to come up. My lords, thereafter, my lords, we have a power under section 94D, my lords, for regularization and grant of lands for dwelling houses. So in respect of that, my lords, we have
On your land, you can do whatever you want.
Please, my lords.
On private land,
Please.
how can you?
No, private land over a period of time, my lords, that it is in respect of private.
Nevertheless, title remains with them. They can always file a suit for possession. They may have allowed people to put up an habitation.
No, lords, this is.
But how will you get a right?
No, we have issued a notification to get a right, my lords. I don't have a direct.
A notification suit of your land.
No, my lords.
You
It is
may
in
declare a particular survey number.
No, even in respect of a private land, my lords, I can do that. I will demonstrate that. I will demonstrate that. Lords, in fact, we want to complete it, the pleadings, my lords, and make that submission.
Relist.
Interim order may kindly be extended.
That was a doubt that I had as to how you
It can be done even in respect of private lands. Lords, even in the.
Without hearing them, without compensating them?
No, lords, compensation is already provided under the act itself. I think it's, but it might not be a
In fact,
compensation in terms of the Land Acquisition Act.
They are
but
confused
ಸ್ವಲ್ಪ
with
ಕಡಿಮೆ
the
ಇದೆ.
land revenue as well as
The
38.
1908 village map, there is already a hamlet.
Even if there's an hamlet, so
Please.
long as you admit it's in the private land.
It is in
And your record reflects it's a private land.
Please, my lords.
How can you declare somebody's have a land as?
Lords, that was the exact same question I had, my lords. Authorities have clarified. I'll put it across, my lords, the legal
With the
portion.
permission,
In
my
respect of the private land itself, it can be done.
The permission.
You acquire it, there's no difficulty. Pay compensation and acquire it.
Acquisition ಇಲ್ಲ ಹಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ it'll be as it is. Now, we don't even need to, my lords, get into this because if some people have built up houses there, now it's a larger extent. 3 acres, wherever, my lords, he has plantation, 3 acres odd, we have left it out. Adana Mutila, wherever, my lords, he is not in possession. And even in respect of those acres, there are 8-9 houses, my lords, belong to the petitioner. They will also get those sites. And, my lords, the problem is it is not part of, if it is not part of, my lords, we don't make this arrangement, they will not be part of any local self-government because it is outside a survey number and outside a Gram Panchayat.
You acquire it, that's the only alternative. You can't get it free.
No, it's we compensation is provided under the provisions of the act. There he has to challenge those provisions, my lords. I think it's around 200 times of. I get it, my lords. It's a minuscule amount. I cannot even say.
I don't think I'm prepared to buy this argument.
With the
That, we'll issue a notification after we conduct a survey and drop a major. I will declare this particular land as, even if he has permitted habitations.
Please.
And which is not recorded in the records, does not mean that you can declare somebody's land to be.
No, it can be done in private land.
It is vested free from all encumbrances in your favor.
To be again, my lords, for the purpose of, my lords, giving
How
it
can
as
you
a
get
grant.
free from encumbrance? You pay compensation, take whatever you want to do.
No, my lords, even other, I can leave it at that.
Leave it at that.
I don't even need to get into this.
Then they will fight it out and they'll get it back if they can.
Please.
No.
Why do you interfere?
My lords, there has been a representation, my lords, for the purpose of, my lords, exercising 94.
It cannot be done on the
It is
basis
from
of.
the villagers. It is in public
People
interest.
in possession will not get title. That is all.
Please.
The people in possession will never get title.
They have to, my lords, if they are in adverse possession, they have to go and seek for.
That is between them, but they will never get title.
They will never get, unless, my lords, it is.
You are now giving them title.
Lords, under the provisions, there are specific provisions for that, made for that, my lords. Lords, this is over more than 50 years. You allow, my lords, some camps, some tandas to come up. And, my lords, they don't, they're like.
When I am very benevolent, I allow my land to be used by a group of people for 100 years.
Please.
Does not mean they are never claiming adverse possession against me. I have allowed them to be there. They be.
In law, my lords, the other persons could have claimed adverse possession. He could have filed a suit for eviction.
If they
and
claim
I could have
adverse
also.
If they claim adverse possession today, they
Please.
have 12 years time to file a suit. If they don't claim adverse possession, they are happy.
Please.
Why can you?
No, I did not even get involved, my lords, but since there are statutory provisions in public interest, I'll demonstrate the bona fides, my lord. Please.
Interim order may kindly.
71 urgent, seal number 72, Sri Radhanandan PS.
lands were granted in my favor and my lords would get the grant orders. Data from annexure B onwards.
21st.
Court officer ಎಷ್ಟು?
72. 21st.
ಎರಡು time ಬೇಕು.
72.
Annexure 51, annexure D at page 51.
My lord, my colleague wants, he's not there, he wants time, my lord. Kindly have it next week, my lord.
Idರಲ್ಲಿ the lands which were granted in short date.
ಬರ್ಲಿ ಬಿಡಿ ಅವ್ರು.
Short date.
21st.
Next
Syllabus
week,
73.
For petitioner, there are two applications filed, madam. The ADRR and DCR, the necessary parties in this petition, madam. The Tahsildar has submitted the entire report for the approval for issuing the Kodi and Durasti, madam.
The pleading is allowed. Costly to be amended.
Copies may be.
Amendment ಏನು?
Amendment, madam, the direction to the implement the report of the Tahsildar to the DDL.
Incorporate additional facts and prayer ಇದೆಯಾ? Additional prayer.
The additional prayer.
Also allowed. Copies be furnished to the Illinois advocate.
Wait. ಅದೊಂದು ಮಂಜುನಾಥ್ ಕೈ ಕೊಟ್ಟು. ಮಂಜುನಾಥ್ ಇದೆ.
AG accepts notice. ಅವರೇನು R5 and R6. ನೀವೇನು R5 and R6?
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
Please, my lord, copy I have order ಮಾಡಿದ್ದಾರೆ sir. ಕೊಡಕ್ಕೆ, please.
And date may be fixed, madam.
Syllabus 74.
74 need to file objections. Lord.
Application to conversion agricultural land to non-commercial purpose.
There was some
That has been
ambiguity in
rejected.
this.
On what ground?
On the ground that section 5 of the Land Reforms Act prohibits lease of agricultural land, your lordship. That is prior to 79 AB repealing also, they have produced a document.
Some time,
in
my
which-
lord. Need to file objections. There was a, my lord, the state government has, my lord, has issued a notice to the, my lord, the concerned authority to not to create the, my lord.
Like 79 AB ಇದ್ದಾಗಿದ್ದೇನೆ. How can you?
I will get the instructions further, my lord.
ಅಲ್ಲ,
I need to file objections. Today.
ಏನಕ್ಕೆ ಕನ್ವರ್ಷನ್ ಕೇಳಿದ್ ನೀವು?
Lordship,
ಏನಕ್ಕೆ ಕನ್ವರ್ಷನ್ ಕೇಳಿದ?
now commercial conversion ಕೇಳಿದ್ದು, in the lease deed, there is specifically it has been mentioned that the agricultural holder has given the property on lease for putting up a petroleum outlet, your lordship. But subsequently the owner himself filed an application for conversion, your lordship. That has been rejected because of the rival applications, your lordship. ಬೇರೆ ಯಾರು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದ್ರು ಇಲ್ಲಿ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಅಡಚಣೆ ಮಾಡಿಕೋಸ್ಕರ ಫಾರ್ ದಟ್ ಆನ್ ದಟ್ ಗ್ರೌಂಡ್ ಇವನ್ ದ ಕರಡಿ ಸಂಗಣ್ಣ MP has also given a letter not to issue conversion in this case, your lordship. May beg your lordship to page number 138, if your lordship may beg your lordship to
Need some time, my lord.
138, your lordship.
ಇಲ್ಲ ನೀವು ಪೆಟ್ರೋಲ್ ಬಂಕ್ಗೆ ನೀವು ಕನ್ವರ್ಷನ್
Before, what happened, my lord, in this, my lord, before the taking to conversion, my lord, the utilized for the conversion activities.
No, but now that 79 AB is no longer on the books, where is the question of you?
I will get further instructions, otherwise, next week, my lord.
I'll grant him an interim order ಇದೆ.
By next week, my lord, I will file my statement.
2 ಸಲ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಲ್ವಾ ನಾನು?
Next week. Today morning, I received the instructions from the department saying that.
Tuesday ಇದೆಯಾ?
15th, my lord.
15.
For further consideration, Syllabus 75. Deepak.
Yeah, Lordship, I appear for pleading applicant, my lord. I have filed an application now, the proposed.
Where's Naik? ನೀವು ಯಾರು ಮೇಡಮ್?
Your Lordship, I am for pleading applicants because we are the neighbors. Now the proposed alternate road proposed.
ಅವ್ರು ಯಾರು ಇದ್ದಿದ್ದು ಹೋದ್ ಸಲ?
ಅವರು ಹಳೆ impleading applicants.
One more submission, your Lordship. in
Fresh
this matter.
objectors.
Yes, my lord.
Fresh set of objections.
Yes, yes, my lord. My lord, because in this matter we have engaged service of senior counsel, Mr. Panindra, is not in station because he requested me to take time, 2 days time may be granted me.
The planning authorities filed an affidavit.
Yes, your Lordship. Because that's the reason, your Lordship, I filed an application. Impleading application is filed based on that ground because that alternative road.
You're saying that you are.
Yeah, it's completely because there is no road for me because of that, because there is no connection to my road, my land, because agricultural lands are there. We are not the owner of the agricultural lands. But there is no, this proposed road does not provide me with access, my lord.
Used.
Great.
16. Great. Serial number 76. Srimati Lata Shetty.
Serial number 76.4, my lord. I'm filing objections, my lord, because they are recently got it amended petition. I am permitted to file it.
Demolition. Demolition tane?
House measures.
And your lordship may kindly have this matter by next week, any date, my lord.
17.
My lordship, 16th. 16th, my
Statement
lordship.
objection is filed.
16th.
Serial number 77.
Pleasure.
Seventeen.
Serial number 78. Ajay Kumar Patil.
Appear for that.
ಹನ್ನೆರಡು ಕೇಸ್ಗಳಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ದಟ್ ಇಟ್ ವಾಸ್ ಇನ್ ದಿ ಜಾಯಿಂಟ್ ನೇಮ್ಸು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಂತ. ಉಳಿದ 6 ಕೇಸ್ಗಳಲ್ಲಿ ಪಾರ್ಟ್ನರ್ ಅಂತಾನೆ ಮೆನ್ಷನ್ ಆಗಿದೆ. ಯಾವ ತರಲ್ಲೂ ಅವ್ರ ಇಂಡಿವಿಜುವಲ್ ಹೆಸರು ಬರಲಿಲ್ಲ. ಈವನ್ 2016ರಲ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳೋದು ಅಂತ ಹೇಳಿದ್ರೆ ನಾವೇನು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ. ಪಾರ್ಟ್ನರ್ ಅಂತ ನಮೂದಾಗಿರೋದ್ರಿಂದ ವಿ ಡಿಡ್ ನಾಟ್ ಆಬ್ಜೆಕ್ಟ್. It is not a case where his name was appearing at any point of time in his personal capacity. It was always being reflected in the permits as a partner. Kindly turn to the affidavit filed by the government.
ಹನ್ನೆರಡು ವಿಜಯ ಮೋಟರ್ ಸರ್ವಿಸ್ ಅನ್ನ
ಹೌದು 12 ಇಬ್ರು ಪಾರ್ಟ್ನರ್ಸ್ ಹೆಸರು ಅಂಡ್ ವಿಜಯ ಮೋಟರ್ ಸರ್ವಿಸ್. ಟೋಟಲಿ 3 ನೇಮ್ಸ್ 12ರಲ್ಲಿ.
My specific contention is on 2016 there are 2 names. Vijaya Motor Service ನಲ್ಲಿ ಶ್ರೀನಿವಾಸ್ ಶೆಣೈ ಮತ್ತೆ ಕೆ ವಿಜಯ ಪ್ರಕಾಶ್. ಅವ್ರದನ್ನ ಶ್ರೀನಿವಾಸ್ ಶೆಣೈ ತೀರ್ಕೊಂಡ ಮೇಲೆ ಕೆ ವಿ ಜಯಪ್ರಕಾಶ್ ಅಂತ ಅವರೊಬ್ಬರ ಹೆಸರಿಗೆ ಮಾಡಿದ್ರು 2016 ಅಲ್ಲಿ. That order they have not challenged it. Then your lordship has directed the RTO whether the application was filed in his individual capacity or on behalf of the firm anta. In the affidavit it does not disclose that fact.
What is the meaning of this para 17? Was transferred to one KV Jayaprakash Shenoy. Subsequent to the death of Shenoy, the permit was transferred to Jayashree Shenoy. Recently, it was transferred in the name of Messrs. Vijaya Motor Services.
They have floated a new partnership firm in the name of herself and her son-in-law.
There is no new partnership.
That is a new partnership firm.
New
That is why
partnership dissolved.
recently it has been
Resolution
transferred.
proceedings are pending before the civil court. Even from 2013 itself. The OS is pending in commercial court.
ವಿಜಯ ಮೋಟಾರ್ ಬಸ್ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಕೆಳಗಡೆ ಇದೆ.
So in 2016 ನಲ್ಲಿ that individual name, the permits were in the name of transferred to individual name.
ವಿಜಯ ಮೋಟಾರ್ ಬಸ್ ಸರ್ವಿಸಸ್.
Now thereafter that the Jayaprakash dies and his wife now permits are transferred. That have been cancelled, challenged. Both the authorities have held that it is subject to civil jurisdiction.
The applications ilva ಯಾರದು?
Applications ನೋಡಿ ಫೈಲ್ ಮಾಡಬೇಕು. ಅದಕ್ಕೆ ಯಾರ ಅಪ್ಲಿಕೇಶನ್ ಇಂಡಿವಿಜುವಲ್ ಕೆಪಾಸಿಟಿ ಹಾಕಿದಾರ ಅವರೇ ಹಾಕಿದಾರ ನೋಡಿ ಅಫಿಡವಿಟ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು.
Document original the record my lord. Upon the documents only my lord the
No, but he's silent about who made the application.
That is the important
transfer.
point. That is the important point. Your lordship directed them
But
to.
for 6, the other 12, there's no difficulty now.
ಅಲ್ಲ 6 ಗೆ ಅದು ನಮ್ಮ ಈ ಜಯಪ್ರಕಾಶ್ ಹೆಸರಲ್ಲಿ ಇರೋದು. 12 ದೇವರ ಜಾಯಿಂಟ್ ನೇಮ್.
ಆ ಜಯಪ್ರಕಾಶ್ ಹೆಸರಲ್ಲಿ 6 ಜನಕ್ಕೆ ಅವರು ಅಲ್ಲಿ ಪಾರ್ಟ್ನರ್ ಏನಾದ್ರು ಸೀಲ್ ಹೊಡೆದು ಹಾಕಿದ್ರ ಇಲ್ಲ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಹಾಕಿದ್ರ?
ಇಲ್ಲ ಜಯಪ್ರಕಾಶ್ ಹೆಸರು ಅವ್ರ ಹೆಸರಿಗೆ ಇದಾಗಿರೋದು. Permit 12 were in the name of 2, Srinivas Shane and Jayaprakash Shane. That partnership.
So you're saying in the substance of the partnership, he was running a parallel business in his own name?
Yes, that is, so he was running a parallel business. That is the dispute is pending now. The firm also now dissolved. Firm dissolved. Dissolution proceedings are pending. In the meanwhile, Jayaprakash dies. That the authorities have they transferred the name in the name of wife. Because earlier also it was individual name only. Now it is always subject to jurisdiction of the civil jurisdiction. That will be there.
Our original application ankonde, our permit which is standing in his name, the applications I want.
And on this also, your lordship kindly say whether that individual capacity has filed, because in 2016, when he got it to his own name, whether he paid or application filed in his individual capacity or firm, that has to be clarified. That's only on that point lies.
Right.
Please, ma'am.
ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಹೆಸರು ಇರುತ್ತೆ, ನೀವು ಸೀಲ್ ಕೊಡ್ಲಿ ಯಾರು ಗೆಲ್ತಿರೋ
ಅದಿದ್ದೇ ಇರುತ್ತೆ. ಈಗ ಈವನ್ ನಾವು ಓಡಿಸಿದ್ರು ಕೂಡ ವಾಟ್ ಎವರ್ ದಟ್ ದಿಸ್ ಬುಕ್ಸ್ ಆಫ್ ಅಕೌಂಟ್ ದಟ್ ವಿಲ್ ಬಿ ದೇರ್. ದಟ್ ಐ ಕ್ಯಾನಾಟ್ ಎಸ್ಕೇಪ್ ಇಟ್. ದಟ್ ಐ ಹ್ಯಾವ್ ಟು ಆನ್ಸರ್.
Get those 6 applications.
Please, I will.
ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕು ಸರ್. ಯಾವ ತರ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕು?
The second matter, I have not yet amended. I'll amend it in the office. One I have amended, the other one, I apologize, I have not yet amended. 16:4.
Number 79, Janardhan Ji.
Serial number 76.
It will be extended.
Number 79, Janardhan Ji.
ಆಗ್ತೀರಾ?
Like.
But verification sign ಬಿಟ್ಟು ಹೋಯ್ತಂತೆ.
Suit for partition ಅಲ್ವಾ?
Yes, madam.
Where is the other judgment that I rendered? Do you have a copy of that? Right? There were 2 suits, one for physical performance and one for partition.
That to your lordship, my, the another appeal by original owner has been dismissed by your lordship. And this is for partition by the respondent, that has been decreed by the trial court.
No, RFA 243 was for
Declaration.
Declaration. 1646 of 2014 is for specific performance.
Yes. That has been dismissed, that has been decreed over by court and
Declaration is dismissed,
confirmed the same.
what is the interim order granted in this SLP?
Not to, the status quo as on that date.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿ status quo ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ ಅದನ್ನ.
No, will that interim order come in the way of this
That is, no,
compromise?
my lord, that is not coming the way because we are not saying anything about that property, my lord. We are only resolving that issue his 1/3 share, we are resolving that issue. And that may not in any way affecting the changes of the nature of the property. That may refer that also.
But you not mentioned anything about the Supreme Court matter.
Because this matter not that there, but in a larger.
Suppose the SLP is allowed
Yes.
and their suit is decreed.
Yes.
Then there was something mentioned in this about this matter, isn't it?
But this matter we are settled without reference to that
No.
SLP, the effect of the SLP, not because we are taking that risk.
You should say that, isn't it?
I'll try one more. I'll report. I'll write it. One more.
ಜಾಗ ಇಲ್ಲ ಅಂತ ಕಾಣಿಸ್ತೆ ನಿಮ್ಗೆ.
ಹಾಕ್ತೀನಿ. Right by side I'll write.
Because you must state that this is subject to the ultimate result of the Supreme Court and you will take the responsibility for all that.
Right. That I'll say. Yeah.
Now Sitharama is giving up his right.
Yes.
Alva?
Yes, madam.
ಅವ್ರು ನರಸಮ್ಮವ್ರು ಯಾರಿಲ್ವ ಈ ಪಾರ್ಟಿ ಈ ಅಪೀಲ್ ಅಲ್ಲಿ?
ಅವ್ರು ನರಸಮ್ಮ ಅಲ್ಲಿ ಹೋಗಿರೋದು SLP ಹೋಗಿರೋದು ಅವರು. That is larger extent of the property. That is only a portion of it.
But I'll have to say that you'll maintain status quo as ordered by the Supreme Court. You can't do anything.
No, we are not saying anything regarding immovable property. We are only regarding his undivided share only you are saying.
When you are buying a share,
Yes.
then you will not do anything.
No, I will not do anything because that order is, I am there, I am contesting. I am not changing the nature of the property anymore. I will obey the court order and I will not do anything with the social properties.
ಬರುದಾ?
Appellant risk. Hearing settled disputes also subject to outcome of the SLP solution and it is at the cost of the appellant. Appellant risk. Sign. Client can sign. Client can sign. Outcome subject to outcome of the SLP numbers also. So it's connected with so also, and it is at the risk appellant's risk.
This appeal arises out of a suit for partition filed by the respondent plaintiff. The said suit has ended in a decree whereby the respondent plaintiff is granted 1/3 share. As a result, the appeals are filed by defendants 1 to 3. In this appeal, parties have arrived at a settlement whereby the respondent plaintiff have relinquished their share by receiving a sum of rupees 3 crore 5 lakhs in favor of ಮೂರು ಜನಕ್ಕೂನಾ ಫೇರ್ ಆಫ್ ದಿ appellant.
ಅವ್ರ ಮೂರು ಜನ ಕೇಸು
In
legal
favor
aids of
the appellants
Appellant 1
slash
and
defendants.
1A and B.
It is also stated, the terms of the compromise read as follows. It is also stated that the settlement is arrived at subject to the outcome of SLP 16732 bar 2023, which has been filed by Narsamma and others
To the larger extent of the property.
of RFA 243 of 2008 and RFA 1646 bar 2014. So it is also stated that there is an order of status quo granted in those SLPs, and the appellants herein undertake that they would maintain the status quo as ordered
As
by
per the court.
apex court. In the light of the above, subject to the outcome of the decision in SLP 16732 by 22 and subject to the appellants maintaining status quo as ordered in the said SLP, this appeal is disposed of in terms of the compromise.
The Tahsildar, my lord, is present. He is present, my lord Tahsildar. Sixty-three, my lord, serial number 63.
63, serial number. Petitioner, madam.
Interim order was granted, my lord. After granting of interim order also, mutation was changed.
Lord, that is,
By way of mutation, the body was cancelled, my lord.
my lord, the same was not brought to the knowledge of the notice.
It was brought,
Tahsildar.
my lord, by way of representation, we have only produced.
Previous Tahsildar has done it, my lord. Tahsildar, Tapalal Bandmele, it is not communicated to the Tahsildar, my lord. They have given to interim order copy to.
ಏನ್ ಮಾಡ್ತೀರಿ ಅವಾಗ?
My lord. Now we, my lord, will enter it, my lord. Tahsildar is present, my lord, in court direction.
You undertake to undo the wrong, I'll keep quiet.
This is, my lord, no, interim order will reflect in the RTC, my lord. But JDLR order, my lord, Tahsildar doesn't have any power.
What is the order that is passed?
Deputy GD, my lord, Jilladhikari, Joint Director of Survey has passed this order, my lord.
What is the interim order that is granted here?
Interim order, my lord, this is the
Stay of the order, my lord.
stay of the order passed by the DDL.
On 24 on 2023, HCGB 6 for a short accommodation to secure instructions from the respondent deputy commissioner and to replace the revenue entries as they were prior to the impugned order. This was the order passed on 24/1. If he agrees to that, then or else I'll initiate contempt, let him go face the consequence.
Then JDLR, from JDLR, I need to secure, my
What
lord,
was-
Monday, my lord.
There was an interim order.
Please, my lord.
He has disobeyed the interim order.
Please.
If he is able to retrace the steps and bring me the position, I'll keep quiet, or else I'll refer it to the division.
Monday, my lord. Yes. Tahsildar present, may be.
Let him be present. Relist,
Present
the
in-
Tahsil is present as ordered earlier. Relist all. Azhar shall also.
Interim order to be executed.
Interim order continue. Tell him, don't take the risk.
Please, my lord. Please, my lord. I'll.
Serial 95.
My lordship, serial number 88, short date may be given.
ಇಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ಇಲ್ಲ, ಒಂದು particular date ಬೇಕು sir.
ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ, ನೋಡ್ಕೊಂಡು ಕೊಡ್ತಾರೆ.
Please, please.
ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ಸ್ ಕೊಡ್ತಾರೆ, ಎಲ್ಲದಕ್ಕೂ ಇಂಟ್ರಿ ಮಾಡಲ್ ಇದೆಯಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Serial number.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ತೀನಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಯಾವುದು? 62 ನ
can be disposed of tomorrow, my lord.
62.
60, no, no, see, this number 2.
December to dispose ಆಯ್ತಾಗ್ಲೇ.
Yes.
My lord, serial number 106.
Serial number
Petitioner
93, my lord.
96-year-old, my lord, seeking change of kata in the name of the petitioner. 96-year-old, my lord, please, my lord.
Serial number?
106, my lord.
Madam, 106 ನೋಡಿದಿರಾ?
My lord, 106.
96-year-old ಅಂತ.
ಇಲ್ಲ, 106 ಮಾಡಿದ್ದಾರೆ.
96 years ಅಂತ.
96-year-old.
In accordance with law, my lord,
On what basis are you seeking for kata?
Oh, in the grandfather, from the name of grandfather to from the name of petitioner, my lord. On the abatement, if grandfather is no more.
ನೀವೇ 96 ನಿಮ್ grandfather ಎಷ್ಟು ವರ್ಷ ಹಂಗಾರೆ?
Now a petitioner is 96-year-old, my lord.
Grandfather. Whose name was the kata standing?
On the in the year 1934, since she is still in the name of my grandfather, my lord.
And you kept it for 100 years.
Please.
This petition is to issue a direction to the second respondent to consider the representation dated 8/12/2022, by which the petitioner requesting to register his name as the Kathedar. Respect land number 16/1. Since the petitioner is claiming that he has succeeded to the property and is entitled to have his name entered in the record of rights, it would be appropriate to direct the second respondent to consider the representation in accordance with the period of 2 months from the receipt copy of this. Come from this side.
I have obtained a decree in the 2016 suit for declaration and 107. ಖಾತಾ AC ಅವರು ತಮ್ಮ ಕೊಟ್ಟಿದ್ದಾರೆ, ತಹಸೀಲ್ದಾರ್ ಸ್ಪೆಷಲ್ ತಹಸೀಲ್ದಾರ್
107.
107.
ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ರಿ ನೋಡಿ ಹೇಳಿ.
ಶಿವರೆಡ್ಡಿ.
ಅದು implement the order. Need instructions, my lord, from the Tahsildar.
Tuesday.
My lord, 93, my lord. Only short point, my lord. In this, notice was unserved. The order sheet is noticed, case is called, summons is unserved, posted for orders, and the order was passed.
Tuesday.
93, my lord.
Tuesday.
94 may be called on 15th.
Date, date ಕೊಡ್ತಾರೆ.
Serial 97.
My lord, lordship has heard this matter. Only issue was, my lord, a land which is our land, which has been reserved for some purposes under wrong impression, it is the government land.
It is the government.
That what happened, my lord, review was also filed and the matter was restored. And the honorable court has held that the grant in our favor is valid. But in the interim, my lords, under wrong impression that land is a government land, my lord, it has been reserved for it. ಅದನ್ನ ಅವ್ರು ಕೇಳಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ತುಂಬಾ
ಇಲ್ಲ, my lord, that their application has been rejected, my lord. Last occasion I submitted, my lord.
Application ಇಲ್ಲ ಇಲ್ಲಿ, ಅವರು they are wrongly understanding.
ಇಲ್ಲ, my
ಖಾತಾ
lord.
application ರಿಜೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು
Last occasion, my lord, official. Next, any day.
My lord, serial number 95. My lord, heard this matter.
Much obliged.
Serial number 95 heard last week some sort of settlement in this, my lord. My client also present, my lord.
ಏನಾಯ್ತು?
ಅದು ನಾವು ರೆಡಿ ಇದೀವಿ ಸ್ವಾಮಿ, ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ ಪ್ರಕಾರ 1 ಎಕರೆ 25 ಗುಂಟೆಗೆ ಅದೇನು ಒಂದು 5 ಲಕ್ಷ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆದ್ರೂ ನಾವು ಕೊಡಕ್ಕೆ
ಅವರಲ್ಲಿ ಎದುರು ಪಾರ್ಟಿ.
My client present, my lord, is from
You talk to him.
ಅವರು they are not showing interest, my lord, because they already filed a civil suit. And my lord, if they don't settle it, my lord, then I will fight back that civil suit, my lord. My interest, my lord, by virtue of my sale deed already granted by.
Next week date ಕೊಡ್ತಾರೆ.
Next ಗುರುವಾರ
serial number 82, my lord. Serial number 82, sir. 2 weeks time.
ಇಲ್ಲ ಕೊಡ್ತಾರೆ.
Serial number 90. One submission. Serial number 97, my lord. Simple writ of mandamus, my lord.
97.
The next date. Any date, my
Any,
lord.
maybe
Next
call
week.
tomorrow, my lord. Simple
Mandamus.
matter. Simple matter.
Tomorrow, my lord.
Tomorrow.
Your lordship.
97 ನಾಳೆ.
ಅವ್ರು ರೆಡಿ ಇದಾರ ಕೇಳಿ. ಅವ್ರು ರೆಡಿ ಇದ್ರೆ ತಗೊಳ್ತೀನಿ, ನನ್ಗೇನ್.
Your lordship.
104 ರೆಡಿನಾ ಮೇಡಮ್?
104, my lord, it's not. Sorry, it is.
Road was acquired by the some other applicant. The report was submitted by the ADLR. Based on the ADLR report, they have not implemented.
ನಾಳೆ ನಾವು ಕೆಲಸ ಮಾಡಿ ನೀವು
No,
ಬೆಳಗ್ಗೆ.
no, my lord, this is the case where, my lord, encroachment of the pathway, my lord, the request, my lord, I get the instruction from the, my lord.
Lordship, serial number.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಇಂದ ಮ್ಯಾಂಡಮಸ್ ಎಲ್ಲ ರೆಡಿ ಇರೋದ್ರನ್ನ
This is the mandamus idru.
Photos ಹೇಳ್ಬಿಡಿ ಯಾವ ರೆಡಿ ಇದೆ ಅಂತ. ಯಾವ್ದು ರೆಡಿ ಇಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಸುಮ್ಮನೆ ಕಾಯ್ಕೊಂಡು ಅವ್ರ ಯಾಕೆ ಇದು ಅವಸ್ಥೆ.
List to serial number 3, my lord.
Serial number 91, my lord. 91.
ಸುಮ್ಮನೆ ಹೇಳ್ತಾರೆ mandamus ಅಂತ.
Court of Certiorari. Date be fixed.
They'll give you a date.
Serial number 99, my lord. Writ of mandamus to consider my application for.
ಕೇಳಿ ಅವ್ರು ರೆಡಿ ಇದಾರ ಕೇಳಿ.
16. My lord, serial number 99, only mandamus as per the granted.
ಅವ್ರನ್ನ ಕೇಳಿ ಅವ್ರು ರೆಡಿ ಇದ್ರೆ ತಗೊಳ್ತೀನಿ.
Granted ಪ್ರಕಾರ grant certificate issue ಮಾಡೋದಕ್ಕೆ direction.
ಇದನ್ನ ಹೇಳಿದ್ರೆ ಯು ಕ್ಯಾನ್ ಸಾಲ್ವ್ ದಿಸ್ ಪ್ರಾಬ್ಲಮ್ ಯಾವ್ದಾದ್ರು ರೆಡಿ ಇದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ.
99.
All the
Next week may kindly have.
If you do me a favor in the morning, tell me which are the matters you are ready in mandamus matters. I will adjourn all the other matters. Sune why do you want to make them wait? Yes. I'll hear you. I'm just waiting for them to.
ಇದನ್ನ ಜಾಸ್ತಿ ಇಟ್ಕೊಂಡು ಆ ಕಡೆ
Yes. ನಿಮ್ದೇನಾರು ಇದೆಯಾ?
Serial number 90, my lord.
Serial number 99.
Election petition.
Serial number 99. Date next week ಅಲ್ಲಿ.
ಎಲ್ಲ ಕೊಡ್ತಾರೆ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ನಾನು ಒಂದು ಮ್ಯಾಟರ್ ಮುಗಿಸ್ಬಿಟ್ಟು ಹೋಗ್ತೀನಿ. ನಾನು ಹ್ಯಾವ್ ಟು ಗೋ ಅಟ್ 4 o'clock. ನಾನು ಒಂದಿನ ಟೈಮ್ ಕೊಡಿ ನನಗೆ.
Respondent number 13, who has filed a recrimination petition, died. Now, what would be the effect is one of the things to be considered. Kindly see section 112.
No, you don't become a petitioner.
Please.
You don't become a petitioner. You have a right to file a recrimination. Saying that in the case.
He becomes a petitioner. That will be considered as a cross appeal like order 41.
Not exactly in those terms.
ಇಲ್ಲ ಅದೇ ಟರ್ಮ್ ನಲ್ಲೇ ಇದೆ ನಾನು ತೋರಿಸ್ತೇನೆ.
Kindly come to the first provision which permits you to file a
96, 97.
Yes.
When in an election petition, a declaration that any candidate other than returned candidate has been duly elected is claimed, the returned candidate or any other party may give evidence to prove that election of such candidate would have been void if he had been the returned candidate and a petition had been presented calling in question his election.
So any party can give evidence.
Give evidence. Munde. Provided that the returned candidate or such other party as aforesaid shall not be entitled to give such evidence unless he has within 14 days from the date of commencement of the trial given notice to the High Court of his intention to do so and has also given the security, etc., referred to in 117 and 118. Next provision, your lordship may kindly see subsection 2. Every notice referred to in subsection 1 shall be accompanied by the statement and particulars required by section 83 in case of an election petition and shall be signed and verified in the like manner. Like an election petition, like a cross appeal.
So the proviso and subsection 2 are only procedural in nature.
Procedural, but makes it.
In order to entitle you to file this, give this evidence, these are the formalities that you have to follow.
What happens is that recrimination petition is to be filed like an election petition. Section 83, everything. Now your lordship may kindly see 112. He becomes a petitioner then.
If you become a petitioner, then by virtue of section 112,
petition abates as against the requisition abates.
ಹಾ, ಅದಕ್ಕೆ 112 ದಲ್ಲಿ ಆವಾಗ ತಾವು ಏನ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಅಂತಿದೆ.
ಅಲ್ಲ 112 ಅಬೇಟ್ ಆಗೋಗುತ್ತೆ.
ಅಲ್ಲ ಅಬೇಟ್ ನಲ್ಲಿ ವಾಟ್ ಶುಡ್ ಬಿ ಡನ್ ಅಂತ ಹೇಳಿದೆ. An election petition shall abate only on the death of the sole petitioner or of the survivor of several petitioners. ಅವರು petition abate ಆಗುತ್ತೆ. Where an election petition abates under subsection 1, the High Court shall cause the fact to be published in such manner as it deem fit. 3. Any person who might himself have been petitioner may within 14 days of such publication apply to be substituted as petitioner, and upon compliance with the conditions, if any, as security, shall be entitled to be so substituted and to continue the proceedings upon such terms as the High Court may deem fit.
According to you, you want me to make a publication. That is dead, that is all.
That's once that is done, there is a possibility someone can.
So you are not claiming under 116.
116 ನಲ್ಲಿ 116 ನಲ್ಲೂ there is one sentence. Of course, I have not been able to understand what it is. Your Lordship may kindly see second part of it. If before the conclusion of the trial of an election petition, sole respondent dies or given notice and he does not intend to oppose the petition, or any of the respondent dies or gives such notice, there is no other respondent who is opposing the petition, High Court shall cause of such event to be published in the official gazette, and thereupon any person who might have been a petitioner.
The respondent ಬಗ್ಗೆ ಅನಿಸ್ತು.
ಅಲ್ಲ ಅಲ್ಲಿಯೂ ಅಂದ್ರೆ to contest the petition, whoever could have been a petitioner, of course. ಇದ್ರ ಕೆಳಗೆ ಅದು ನಾನು ಅದನ್ನ ಪೂರ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡೋದಕ್ಕಾಗ್ಲಿಲ್ಲ, ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಈಗಿಂದಲ್ಲ, ಇಟ್ಸ್ ಅನ್ ಅಮೆಂಡ್ಮೆಂಟ್ 56 ನಲ್ಲೇ ಆಗಿರೋದು. ದರ್ಫೋರ್ ಅದೇನು ಅಂತ ನೋಡ್ಬೇಕು. ಬಟ್ 112ದಲ್ಲಿ ತಾವೊಂದು ಇದನ್ನೊಂದು
I am my doubts whether you are an election petitioner. Merely because you file a petition in the manner prescribed,
you don't become an
and
a recrimination.
Even if you follow those requirements under subsection 2, all that will happen is you will be entitled to give evidence. That is all. You don't partake the nature of being a person who initiated a proceeding. You are given that option to give evidence to prove that the person, if he has been written. So you will not become a petitioner.
I will not. It's not that I become a petitioner qua the election petitioner.
That is one view, or the other view is by virtue of following this procedure, the law gives you the right to give evidence.
Evidence. That is the only thing. Because nobody else, except a person who has filed the recrimination petition, nobody else has the right to adduce evidence. Therefore, someone who comes in his place can adduce. Nobody else can adduce evidence on that aspect. Of course, not that the other contesting rights, etc., are of different type. But as far as recrimination petitioner is concerned, it is only he who can adduce evidence, and the person whom, if the court permits, substitutes, can only do that. Nobody else can adduce evidence.
There are two things. One is this recrimination petition. The order passed by my lord is pending in the Supreme Court. Just as an information I am mentioning. Kindly see 112, my lord, for a moment. Abatement of election petition. His is not an election petition, sorry. An election petition shall abate only on the death of a sole petitioner or of the survivor of several petitioners. It speaks of what happens in an election petition, nothing to do with recrimination petition. I completely bow down to the interpretation which my lord has said. In order to give evidence, you have to follow and complete certain procedure.
No, but section 83 starts off with the word, an election petition shall contain a concise statement.
Yes.
And
97(2) says every notice referred to in subsection 1 shall be accompanied by the statement and particulars required by section 83.
True, that is only procedural aspect. Whatever is required there, like my lord, for example, verification or giving away, I mean, mentioning certain important aspect vis-a-vis procedure, it's not a right that is conferred. It's a procedural in nature. Whatever you do there, you have to do here.
What you're saying is it specifically talks about election petition abating, not recrimination petition.
Yes.
But then what about 116? What is it that we should do? If any one of the
116, my
respondent
lord.
dies.
If your lordship would see 116. On the death of a respondent, what I should do is totally different from, my lord, this court allowing somebody else to come in the place of recrimination petitioner. This is stage 2, my lord. Totally different
No,
from.
we'll think about 112 separately, but what about 116?
Yes,
What
I
is it I
agree.
should do?
If before the conclusion of the trial of an election petition, the sole respondent dies, it is not so, or gives notice that he does not intend to oppose the petition, or any of the respondents dies, or gives such notice and there is no other respondent who is opposing the petition, the very returned candidate is opposing the petition. The High Court shall cause notice of such event to be published in the official gazette, and thereupon any person who might have been a petitioner within the 14 days of so and so, so and so.
But Mr. Jacquemus, but 116, it says, first thing is, does not.
May I request your lordships to have a look at 41, order 41, rule 22.
No, but because the special act contains a special provision for
Special
death
provision.
of a respondent. It operates in two fields. One is the sole respondent dies, that does not apply. Or gives notice that he does not intend to oppose the petition, that does not apply. Or any of the respondent dies, that applies. Then, or gives such notice, that does not apply. So it will be any of the respondent dies and there is no other respondent who is opposing the petition.
Yes.
The High Court may. If there are other respondents, then the
High Court
question
may, the next sentence may kindly be seen.
now this is conditional to there being no other respondent.
No other respondent.
There are other respondents, then none of them will apply.
But at the
Suppose-
same time,
suppose
kindly
that-
see that word, my lord.
Suppose 30th respondent was only respondent and he had died. Then I have to follow this procedure.
Yes.
If there are other respondents,
And
then you don't.
thereupon, any person who might have been a petitioner.
That is if there are no other respondents. If there are respondents, because the election petition should not go uncontested. Therefore, they want, if there's a sole respondent.
Who might have been a petitioner. The word used is.
How can a respondent be a petitioner?
Yeah, that is why I said recrimination petition is the one contemplated here, but anyway, I did not go up to that. Kindly see order 41, rule 22.
Cross appeal. What is it?
ಅದರಲ್ಲಿ sub rule 4 may kindly be seen.
22 na.
ಹೌದು, order 41, rule 22.
Remand.
That allows the filing of cross appeal.
No, order 4122 cannot really apply because it's a decree operating. Defendant, respondent has a right to object to the decree.
Now
Here it says-
I put it in this way, my lord. Now, there is no respondent who is opposing a declaration to be made in favor of the petitioner that he is the returned candidate. Because nobody can give evidence except the person who has filed the recrimination.
If the other respondents have not chosen to exercise that right of recrimination, You cannot, by virtue of somebody's death, be entitled to that right.
No.
All the
That-
other
That
respondents.
right is already there in the recrimination petition.
No, it was there to this gentleman who invoked that right.
Yes,
Other respondents did not choose to invoke that right.
I would respectfully submit, my lord, if at all a respondent, if he dies and there is a provision under which High Court on conditions or otherwise may permit, then it's a case to be considered for permission. Of course, my lord,
What I'm contemplating is 116 talks about abatement or substitution of a respondent. It basically takes into consideration only one respondent is there. Election petition would go uncontested. Therefore, this requirement of permitting a person to be substituted. But if there's more than one respondent.
Here also, election petition will go uncontested so far as the second relief of declaration is concerned.
No, that the other people chose not to do
Other
it.
people, whether they chose or not, one person has chosen to file recrimination petition.
With this death, it dies.
If he dies, that petition remains. It's like it's another election petition before your lordship. Whether a stage would arise for consideration or not.
It can't be an election petition at any rate. You can't equate the right to give evidence as a right to file an election petition.
It is an election petition because it contemplates court is likely to declare so and so as the elected candidate, but for the evidence that I have adduced. It is an election petition. As far as that relief is concerned, the sole person who was opposing that relief is dead. The sole respondent who was opposing that relief is dead. No other person can oppose that relief. Of course, he may fail on other grounds. That's this thing. Otherwise, respondent number 13, recriminating petitioner, is the only sole respondent who has chosen to oppose that relief. On his death, it goes unopposed. Therefore, my submission is, even under 116, I would come. But anyway, 112 itself is sufficient to say, because I stand in the footing of a petitioner so far as that aspect is concerned, that relief is concerned. Nobody can oppose that relief on the ground of any corrupt, here it is corrupt practice. On that ground, unless they file a recrimination petition. That recrimination petition is filed by respondent number 13. So as far as that relief is concerned, now it remains uncontested. If otherwise he succeeds on other points, that relief remains uncontested.
Worst case scenario, you want it to be published.
Yes.
So that somebody may take a chance and make an application. If they don't make an application, matter ends.
Even if application is made, granting of permission, what should be the condition, etc., is still with the court.
Your argument stems from the fact that this gentleman filed that petition. If
Yes.
he had not filed the petition, then this argument would not be there at all.
Would not have been there. Would not have been there because he is one of the respondent who was contesting.
116 by itself did not take into its contemplation the recrimination. It was only referring to the respondents per se, without the background of the recrimination.
Namige, ಈ stage nalli, I would say 116 also would apply if your lordships are to consider me as a respondent, recriminating respondent. I am the only person who is allowed to adduce evidence to oppose that prayer. No other person can do it.
Let me apply my mind.
No other person chose to do it.
Chose to do it is different.
112 is with reference only to an election petition where one of the respondent dies. It has nothing to do, there is no reference, my lord, to recrimination petition, either under 112 or 116.
Lord Learned Senior Counsel, on the effect of the death of the 13th respondent and the steps to be taken with reference to section 112 and 116 of the RP Act. Orders reserved.
Serial number 81.
Sir.
ಸರ್ ಈಗ ಫೈಲ್ ಎಲ್ಲ ಕೊಟ್ಟು ಕಳಿಸ್ಬಿಟ್ಟೆ ಡೇಟ್ ತಗೊಳ್ಳಿ ನಾಳೆ
Serial number 85, 86.
ಒಂದು ನಿಮಿಷ ನಮ್ಮ ಅಟೆಂಡ್
ಸರ್ ಎಲ್ಲ ಚೆಕ್ ಮಾಡ್ಕೊಂಬಿಡಿ, ಒಂದ್ ಅರ್ಧ ಗಂಟೆಯಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ, ಎಲ್ಲ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸರ್ 95 17ನೇ ತಾರೀಕು ಸರ್ 95 17ನೇ ತಾರೀಕು ಸರ್ ದಯವಿಟ್ಟು
16
ಸರ್ 17 ಸರ್ ಡೆಲ್ಲಿಗೆ ಹೋಗ್ತೀನಿ ಸರ್ ನಂದು
88 16 ಕೊಡಿ ಸರ್.
17 ರೀಚ್ ಆಗಲ್ಲ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 88. ಸೀರಿಯಲ್ ನಂಬರ್ 88 ಸರ್.
21.
Sir, serial number 94.
Sir, 85, 86.
ಸೀರಿಯಲ್ ನಂಬರ್ 85 ಎಲ್ಲ ನಾಳೆನೇ ಬರುತ್ತೆ.
ಸರ್ 88 ಸರ್.
81 ಸರ್.
88 21.
ಸರ್ 81.
ಶಾರ್ಟ್ ಡೇಟ್ ಆಗಲ್ಲ ಸರ್, ಅದಕ್ಕಿಂತ 16 ತಾರೀಕು.
81 ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 81.
ಸರ್ 83 ಒಂದು 2012 ಮಾಡಿ 83 2012
81
2012 ಸರ್
15.
ಸರ್ 81. ಸರ್ 81.
ಕೋರ್ಟ್ ಆಫೀಸರ್
25 ಎಲ್ಲ ಚೆನ್ನಾಗಿ
81 ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 81.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್
ಕೋರ್ಟ್
81.
ಆಫೀಸರ್
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
80
81.
80 ಡೇಟ್ ಕೊಟ್ಟರು.
ಯಾವುದು
ಸರ್ 81 ಸರ್.
81 21.
Sir, 97.
ಫೋನ್ ಮಾಡ್ತಾರಲ್ಲ
25 ಇದೆಲ್ಲ 2 weeks.
97.
108 ಡೇಟ್ ಕೊಟ್ಟಿತ್ತು ಬಿ ಗ್ರೂಪ್ 108 ಮಂಡೇ ಮಾಸ ಇದೆ ಅದರ
Sir, 97, sir.
23rd.
96
23rd.
97. Sir, 97 ನೋಡಿ sir.
71
97.
24 2 weeks entry ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
97 ನೋಡಿ sir.
ಸರ್ 71
97 ನೋಡಿ.
87 ನಾಳೆ ಬರುತ್ತೆ.
97 ನೋಡಿ sir.
46 ಅಲ್ಲಿ ಆಯ್ತು.
ಸರ್ 71
9th.
Sir, 97.
Serial number 71.
97.
71
97 ನಾಳೆ.
ನಾಳೆನಾ?
96 ಸರ್ 96
24th.
ಸಾಹೇಬ್ರೆ 96
22 weeks.
ಸಾಹೇಬ್ರೆ
ನಾಳೆಗಲ್ಲ ಸರ್.
ಸಾಹೇಬ್ರೆ 96 96
71
ಎಂಟ್ರಿ ಮಾಡ್ರಿ
ಡೈರೆಕ್ಟ್
16 ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 93 ಸರ್
ಅದರಲ್ಲಿ ಇಲ್ಲ ಇರೋದೆಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 93 ಸರ್ 93
15 ಎಷ್ಟು ಸತಿ ಕೇಳಿದ್ರಿ? 3 ಸತಿ ಕೇಳಿದ್ರಿ.
ನಾವಲ್ಲ ಸರ್ ಆಪೋಸಿಟ್ ಕೇಳ್ಕೊಂಡು ಸರ್ 71 ಸೀರಿಯಲ್ ನಂಬರ್ 71
ಹೇಳಿದ್ರು
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಅದು 2 ವಾರ
ಸರ್
2 ವಾರ ಅಜ್ಜನ ಆಯ್ತು.
96 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಸರ್. ಎಂಟ್ರಿ ಮಾಡಿ
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ ಅಬ್ಸಲ್ಯೂಟ್ ಇರುತ್ತೆ ಅದು. ಅದು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಇದ್ರೆ ಮಾತ್ರ ಕಂಟಿನ್ಯೂ ಆಗ್ತಾ
ನೆಕ್ಸ್ಟ್ ಡೇಟ್
ಹೋಗುತ್ತೆ.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಇಲ್ಲ, ಅಬ್ಸಲ್ಯೂಟ್ ಇರ್ಬೇಕನ್ನೋ ಅದಕ್ಕೆ ಅದು ಆಗಿಲ್ಲ.
ಹಾ
ಸರ್ 16 ಇದು 19 ಇಲ್ಲ 16.
16 ಇಲ್ಲ
16 ಹೇಳಿದ್ರೆ 15 ಹೇಳಿದೆ ನಮಗೆ.
ಸುಮ್ಮನೆ ಹಂಗ್ ಬರುತ್ತೆ ಹಂಗ್ ಹೋಗುತ್ತೆ. ಅದಕ್ಕೆ
16 ಯಾವಾಗ?
ಬೇರೆದು ಬರೋದಿಲ್ಲ ಬರೋದು ಬರೋದಿಲ್ಲ.
ಬರ್ಲಿ ಏನ್ ಹಾಕ್ತಿರ ಹಾಕಿ. ಬಟ್
ಸರ್ 103 ನೋಡಿ ಸರ್. ಸರ್ 103 ಒಂದು 103
ಎಲ್ಲ 2 weeks ಅಲ್ಲ.
ಬೆತ್ತನೆಗಡೆ ಹಾಕ್ಸೋದಿಲ್ಲ. ಅದೇ ನಮ್ಮ 96 ಅಲ್ಲಿ ನೀವು ವಕಾಲತ್ ಹಾಕ್ತೀರಾ 96 ಆ 2ಗೆ ಇವ್ರು ಇದ್ರಲ್ಲ ಯಾರು ಕೇವಟ ಅವ್ರು NOC ಕೊಟ್ಟಿದ್ದೀರಾ?
25 ಎಲ್ಲಿ ರೀಚ್ ಆಗುತ್ತೆ?
15 16 ಕಲ ಅದು
ಸರ್ ಅದು 2-3
ಇನ್ನ ಬರ್ತಾ ಇರ್ತದೆ. ನೀವು
ಒಂದೇ ಸತಿಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ.
ನಂಡ ಮಸೀದ್ ಅದು ಗವರ್ನಮೆಂಟ್ ಅವ್ರ ಹತ್ರ ಕೇಳಿ ಫಸ್ಟ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಟ್ರೆ ಆಗುತ್ತೆ ಅಂತ ಅವ್ರು ಕೇಳೋದಿಲ್ಲ.
ಸರ್ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ಅಲ್ಲ.
15 ಕೊಟ್ಬಿಡಿ ಸರ್.
ಸರಿ
ಸರ್ 81 ಸರ್ 81 ಶಾರ್ಟ್ ಮ್ಯಾಟರ್ ಇದೆ. ಅದು ಮೊನ್ನೆ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗಿದ್ದು ರೀಕಾಲ್ ಮಾಡಿದ್ರು ಅಲ್ಲ, ಸ್ವಲ್ಪ ಬೇಗ ಅರ್ಲಿ ಡೇಟ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿ.
ಅವ್ರು ಸರ್ವಣ ಈಗ ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ಲ ಮೊನ್ನೆ ಹೇಳಿದ್ರು.
ಇಲ್ಲ ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ದಾರೆ ಮೊನ್ನೆ. ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡಿದ್ರು ಸಾಹೇಬ್ರು.
ಸರ್ವಣ ಅವರು ಮೊನ್ನೆ ಹಾಕಿದ್ದಾರೆ ವಕಾಲತ್ತು. ಅವ್ರು ಬಂದು ತಿರ್ಗಾ ಡೇಟ್ ತಗೊಂತಾರೆ. ಅದೇ 21st ಕೊಟ್ಟಿದ್ದೀವಿ.
21st. ಆಯ್ತು.
ಇದರಲ್ಲಿ HLM ನಾಳೆ ರೆಡಿ ಇದೆ.
ಹಾಕ್ಬಿಟ್ಟು ಹೋಗು ಅಂತ ಹೇಳಿದ್ರು ಸಾಹೇಬ್.
ಅಲ್ಲಿ ನೋಡಿ ಆ ಕಡೆ ಸರ್ ಚೆಕ್ ಮಾಡಿ ಸರ್. ಆ ಸೈಡ್ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಆ ಕಡೆ ಈ ಕಡೆ ಇಲ್ಲ ಬಿಡಿ, ಈ ಕಡೆ ಮೇಡಮ್ ಆ ಸೈಡ್ ನೋಡಿ. ಮುಗಿತಾ ಸರ್? ಸರ್ ಮುಗಿತಲ್ಲ? ಇಲ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಚೇಂಬರ್ ನೋಡ್ಬೇಕು ಅಷ್ಟೇ. ಅಂದ್ರೆ ಅವ್ರ ಚೇಂಬರ್ ನೋಡ್ಬೇಕು ಸರ್. ಸರ್ ಮುಗಿತಲ್ಲ? ಹಾಂ.